Morning, everyone. Just before we start, could I just raise one point with Mr. Risso-Gill, who's here representing the Attorney General this morning?
Yes.
Mr. Risso-Gill, I raise this with a little diffidence because I know that the team working on this on behalf of the Attorney General is significant in terms of numbers, and you may not be the right person to answer this query. So if you aren't, just please say so, and we'll deal with it in a different way. But the query concerns the reductions, the suggested reductions from the IRU in relation to the assistance grants bundle. Assistance grants, as you know, the attorney is not going to make any legal submissions on them. I'm not going to hear any more oral evidence on them. But there was a bundle prepared for the hearing. We asked for reductions. We've now got the reductions, the suggested reductions from the Attorney General. Again, as with past bundles, the reductions are causing some difficulties, particularly for me, who has to determine whether parts of the document should be redacted because they don't appear to have been made upon any rational or logical basis. They don't appear to me to be. For example, redactions are made of documents which have been put in the public domain during the course of these proceedings. Redactions have been made of information which, for example, at the Premier's office was dealing with the assistance grants programme, which is uncontroversial and appears to me to be part of the elected minister's case, and various parts of documents which are apparently critical of the elected ministers have simply been, it is proposed, redacted, but for no obvious reason, no obvious legal reason. Now, is that something you can help me on, or should we deal with it in a different way?
You anticipated correctly, sir. I'm not the right person on that. However, no doubt those who are dealing with that particular matter will have heard and listened carefully to what you've just said, helpfully outlining what the problems are with what has been done so far. And we shall have to respond to that.
Yes, I mean, it's as it were a wider issue because the attorney has, or the IRU on her behalf, have sort of reserved the position of the elected ministers in relation to quite a lot of documents. They've redacted documents on a basis which I find impossible to determine whether a redaction should or should not be made. And these issues will at some point have to be dealt with because at some point I will want to refer to some of these matters in my report and we're going to have to deal with them. But I'm quite happy, Mr. Risso-Gill, to deal with that in a different way. And I fully understand that you can't help me today on it.
The only thing I ought probably to add very briefly, sir, is that I can attest to the very substantial burden which those within the team are bearing, and therefore that may explain why things are not in the order that everyone would like them to be in on every occasion. But beyond that, I don't think I should venture further.
No, and it's understood because a lot of people, particularly I have in mind, public officers, not those who are helping the attorney on a commercial basis, the public officers, and I've repeatedly made this clear as to how grateful I am for their efforts. I know that they are huge, but what I want to make sure is that efforts are properly directed and efficiently directed. But as I say, we will deal with the issue of redactions in a different way, and I fully understand your position, Mr. Risso-Gill. Thank you very much. Mr. Wright.
Good morning, Commissioner. Our first witness today is Mr. Joseph Smith-Abbott, who is a witness who's familiar now with the process of the Commission. Mr. Smith-Abbott, thank you for returning to give further evidence to the Commissioner. When you attended on the first occasion, you made an affirmation. You're still bound by that. As I've said, you're obviously, I hope, familiar with our processes now. The only thing I think I need to do is just to remind you, as I do everyone else, to keep your voice up for the stenographer. The topic that we are asking you to assist on is that of Crown land today. If you take up, I think you've got it in front of you, the first bundle.
Yes, I do.
If you turn, please, to page 1 in that bundle. You will see there a letter which the Commissioner sent to your Minister, Honourable Vincent Wheatley, as Minister for Natural Resources, Labour and Immigration on the 26th of June 2021, asking for an affidavit addressing various issues concerning the disposition of Crown land. You have provided that affidavit, and in fact, as you have done on previous occasions when requests have been made to the Honourable Minister. And if we turn to page 10 in the bundle, we should see the first page of your affidavit, running through to page 46, please. Can you confirm that it's dated the 2nd of September 2021 and carries your signature?
Yes, I do.
And are you content, Mr. Smith-Abbott, for this affidavit, together with its exhibits, to stand as part of your evidence to the Commissioner?
Yes, I do.
I'm sorry, could you pull the microphone closer to you? Thank you.
Mr. Smith-Abbott.
Is it right that, as with other affidavits that you have provided, that this task was delegated to you by the Minister because it involved the search of records at the Ministry?
That is correct.
And is it also right that it would have been prepared with the assistance of other public officers working to you in the Ministry?
That is correct.
If you go back, please, to page 10, and we look at paragraph 2.2, where you say something that you've said again in previous affidavits, which is at the outset, I should further say that in this affidavit, where I mention a document, I do not waive any privilege asserted in respect of it, unless I do so expressly. Now, when you were asked about this, when you gave evidence about belongership, together with Mr. Penn, the Chief Immigration Officer, you explained that this, in your mind, was directed towards the disclosure of personal data. Is that the same case here?
That is correct, yes.
Thank you. It is a helpful affidavit because it does go through quite a lot of the detail and adopts the structure in the letter of request. And so hopefully we won't have to go through every part of it. But if we look at paragraph 3.1, please. You've explained there that in terms of what's meant by Crown land, that it's defined in section 41 of the 2007 Constitution as lands or other immovable property in the Virgin Islands or interest in such property that are vested in Her Majesty for the purposes of the government of the Virgin Islands. And you go on to refer to the Registered Land Ordinance of 1970, and in particular, section 26, which provides that the registration of land as Crown land shall, subject to any registered encumbrances, enable the Governor in Council by a disposition registered under the ordinance to dispose of such land. So those are the two provisions, if you like, that forms the legal framework that allows us to find a definition of Crown land. Is that right?
That is correct.
You go on in terms of setting out details as to the records that are available, identifying Crown land, and these are records available to the government. If I draw your attention to paragraph 3.3 rather, on page 11, you say that there are maps which show Crown land, but which are not up to date. Is that right?
Well, we have to distinguish what up-to-date means, because there are effectively two sets of records. There, of course, will be those that are kept by a survey and land registry, which do have the most up-to-date information. But again, in terms of scale of the production of those maps, because of the fact that you have parcels that are shadowed by the larger size, or actually as you scale down in size, you will not be able to display all of the parcel information that will describe what is crown from private, for instance. So therefore, those records do exist. They are kept up to date, but the easily accessible maps, which would be form part of the geographic information system available throughout government departments for the purposes of managing day-to-day affairs, those are not necessarily always kept up to date to those that are effectively forming part of a separate and distinct record. So I just need to make that very clear, because there are records we do know very well what is Crown-owned parcels versus those that are not.
Right. Can I separate the two? Because I think, as I understood your affidavit, there's obviously the land registry records.
Correct.
And then there's maps held within the ministry.
Correct.
And if we take the land registry records, those will be surveys that are prepared for dispositions of land.
That's correct.
And so if an easement is granted over a piece of Crown land that's held by someone, there will be a survey map, and that will be part of the documents relating to that easement.
That's correct.
If the Crown disposes of a piece of land either by lease or by selling it to someone, that disposition will include a map showing the boundaries of the area that is actually being leased or sold.
That is very much correct, yes.
And so if one were to go through all of those records, you could build an up-to-date picture of the present state of Crown land.
Very much so, yes.
Where it is, how it's been disposed, who has rights over it, etc.
Correct. That'll form part of the registry.
But separate to that, within the ministry, as we've understood your affidavit, the ministry holds maps showing Crown land, but those are not necessarily up to date.
Yes, because again, what I want to say about this is this, that maps showing Crown land do exist, of course. They can be provided, as you would have pointed out. Now, they're all corresponding to the scale at which you will want to present that information. Now, the maps that we work within the ministry, at the scale at which we're working, there are individuals who would have access to those records at the registry. But for the most part, there's another scale of records that are not necessarily immediately synchronizing with those at the registry. And that is the distinction that needs to be made here.
So, I'm sorry. Maybe the same questions Mr. Rowett was going to ask you. So it's the registry maps which are of a scale which is quite difficult to see.
Correct.
Particularly in relation to relatively small parcels.
Correct.
But those, as it were, are definitive and complete.
Very much so.
And up to date. And within the ministry, you have larger scale plans, which, as it were, show the plots better, but they may not be absolutely up to date.
Exactly.
I understand. Thank you very much.
Aside from those, does the ministry hold any other records on the status of Crown land?
Yes, there are registers of the parcels that are disposed. Of course, there will be a record of how those parcels would have been disposed of. Generally speaking, the disposal of any Crown parcel will be supported by some decision, by cabinet action. There would have been negotiations, there would have been leases, there would have been an exchange of information among several departments of government prior to that disposal, if you may.
So if we take a hypothetical example of one disposal of a piece of land, does that mean that for that disposal, you would have a ministry file on it?
Correct.
And so if cabinet were to agree to dispose of a piece of Crown land, but make it subject to conditions, and conditions before the lease, let's let's say, can be executed. Is that, would that be information be in your ministry file?
Yes.
And if, and again, looking at the records that you keep, if, for example, you have complications arising, so for example, someone doesn't meet a particular condition that's been imposed, would that be recorded as well?
Generally, it should be.
And all in the same file?
That's correct. However, in some instances, you may find transactions straddling or disposals straddling ministry files. So that would be based on ownership, prior ownership, current ownership, perhaps if it's being transferred onto another agent or another person, another entity. So there may be instances where you may have to search records across several transactions, several ministry files, leading up to the whole story, if you may, as to what may have been the case with a particular disposal of Crown land.
And are your files kept by piece of land, or are they kept?
No,
by...
they're kept, typically they're kept by applicant.
And so, and that's where the crossover could arise, because it may then connect that applicant to another applicant.
Correct. However, the registry will obviously maintain a history of the disposal of that parcel across those same named entities, or whether it be individually or commercially by say another person.
So what has happened to a piece of Crown land can be tracked through either using your ministry files or going to the land registry.
Correct.
If there are conditions imposed on a sale or a lease, for example, that in respect of a lease, someone has to pay rent, or there is a prohibition put, a covenant put on the transaction so that they can't sell within a specified period of time. Does your ministry keep track of compliance with such terms?
So let's parse that, because what I think I heard you express at the beginning of your question is whether, for instance, a covenant would have been imposed leading up to the approval of that disposal. Is that correct?
No, let me rephrase it.
Okay.
Cabinet decides to dispose of
So
a piece of
we've
land.
already disposed that?
Yes.
Okay.
But there are conditions put either on the sale or on the lease.
Yes.
So I now own this piece of land. I bought a piece of land, but there is a covenant that says I can't sell it within 5 years.
Correct.
Or I've leased it, and as part of the lease, I have to pay rent.
Yes.
Who would be responsible for ensuring that I comply with those conditions?
So there are, for instance, clauses for rent review on a periodic basis. Those will be monitored by the ministry. There may be clauses related to what can and cannot happen with that parcel. Those are, again, monitored and measured, if you may, by the ministry proper, by officers within the ministry. And certainly the resale of any property within a specified period. So let's say, for instance, there's a disposal of land and you cannot resell that land within a certain number of years. That will also be monitored by the ministry or the departments related to that.
Which was going to be the next question in terms of who is responsible within the ministry for dealing with Crown land and dealing with either ensuring that conditions imposed before execution of a sale or lease are complied with, or afterwards are complied with. Is there a department within your ministry that deals with it, or does it spread across a number of entities?
I think it's spread across entities, because, for instance, you may have a situation where someone may want to resell land. So there may be some indication based on the covenants that on transfer that state that in order for that resale to take place, the ministry would have to be informed prior. And therefore, the ministry will receive that indication, and we would then work with the land registry department to, again, monitor the covenants and conditions under which say that resale may take place. The fact that, for instance, the statutory period would have been met prior to that resale.
And are your records held, are they physical records or electronic or a combination of both?
Combination of both.
Is the approach of your ministry to hold something in both electronic and hard copy form?
Yeah, so the better part of the records really at this stage are hard copies. And over time, there'll definitely be the digitization of those records so that there'll be a duplicate, a replicate set, if you may, of electronic files. But all maps are obviously maintained electronically, as well as there may be some physical maps, older maps that are also kept by survey.
So returning to what the ministry knows of Crown land, is the position that the ministry could today provide an up-to-date summary of the status of all Crown land in the BVI?
Yes, I would say yes, that we should be able to, and those records are maintained in individual registers, for instance, of where parcels are either disposed for public or residential commercial purposes. Those registers are kept.
Are they, I mean, do you understand the position to be that there may be areas which of land that have not yet been mapped, but which would be Crown land?
Yes, especially in the context of reclamations. So if you have, for instance, a reclamation that is ongoing or ongoing, not complete, of course, there will not be a survey of that parcel. So therefore, at the outset of the completion of that project, then we will commission a formal survey and then undergo the normal usual procedures for registering that parcel of land in accordance with whatever the decision that would have been taken with respect to that disposition. So the seabed, of course, resides in the Crown. So that parcel, quote, parcel, as it's being reclaimed, is not surveyed, but that interest remains, if you may. The interest of government over the seabed will remain until such time when it's transferred, or at least.
So in terms of reclamation, which obviously is a project which takes time, the seabed being in the Crown, does the part that's reclaimed in an incomplete basis, that remains in the Crown until the reclamation is complete. It's then surveyed, and then it's either retained by the Crown or disposed of in accordance with an appropriate decision.
That's correct.
Yes, thank you very much.
And there is Crown land which falls within the remit of estate lands committees.
That's correct.
We may need to ask you something about the role of those committees shortly, but there will be Crown land that's a way of dividing Crown land, isn't it? There'll be Crown land that falls within the remit of a lands committee and Crown land that falls outside it.
That is correct. And that's principally driven by a long-standing policy that we want to increase, government will want to increase the stake ownership, if you may, of individuals to be able to build homes, for instance, in most cases, first homes. So it's been a long-standing policy to facilitate that process, either through, in some instances, former Crown land, which would have already been disposed through the state committees, the work of the state committees, or ongoing work that would be the subject of continuing dialogue with respect to how those parcels are then to be allocated to individuals. But again, for the purposes of residential home ownership purposes. And it's been going on for quite a number of years, as the record would show.
And indeed, I mean, it's a point that you make in your affidavit about that, the long-standing policy, which, if I may, I'll come back to when we look at criteria. But can I turn to the routes by which an application to either purchase or lease Crown land can be made? We're at paragraph 4 of your affidavit, which is on page 11. But what you explain in your affidavit is that the governor, with the prior approval of cabinet, has the power to make or authorize the disposal of Crown land, and the minister and currently it's obviously Minister Wheatley, has responsibility for administering Crown land. But there are 3 routes by which an applicant can either purchase or lease Crown land. The first is by making a direct application to the ministry, and you say that at 4.3, you say direct application to the ministry, including with the encouragement and or facilitation of a district representative. And you've explained, and this is at paragraph 4.7, then the process where there's a direct application would be the same if seeking to purchase or lease Crown land.
That is correct.
And what happens is, in that case, the application is made, and then the applicant's name is added to a file. Is this a physical file or an electronic file, or both?
Mostly physical.
Looking at 4.7b, you say that the file is kept for Virgin Gorda, Totola, Anegada, and Jos van Dyke. So the files organised in any way other than by Ireland?
So you have direct applications to estates. You would have had or would have applications for estate lands. Those are kept in those particular files. And there are generally, so whether it's nibs, spooners, whatever the case may be, those are kept in estate files. So you would be able to track, for instance, who are the individuals making applications for, say, the disposal of land in their favor. Then you may have general applications for lands that may be received by the ministry. Those are not necessarily and immediately attached to an estate, an existing estate. So they may, for instance, recognize that there may be a parcel available in X place. It doesn't, any of the islands, for instance. So direct reference can be made either to that parcel or just generally access to a parcel of land that they may want to then utilize to build a home. So we have to recognize that there are obviously, in some instances, applications for lands in one case for existing estates, or in the case, as the case may be, former estates that may have been available at the time, and then just general applications.
And the general application would essentially.
And then those would then be kept by island.
Right. So a general application is unrelated to a piece of land connected with an estate.
Correct.
And those are I'll come in a moment to just the estate lands committees as a route to apply. But where one is making a direct application to the minister, in this case, you're making a general application, and that will be categorized by island.
Yes.
What you say, though, is that essentially someone's name goes on a list, and you say the list is periodically reviewed by the minister, who from time to time will make a recommendation to cabinet for an allocation of land to one of the applicants. How often does the minister periodically review?
I can not say to what extent in the past it would have been the case that a minister would review a file. I know that in this particular administration, there have been instances, for instance, where the file, as I understand it to be, would have been reviewed at some point for any lands available, at least my understanding from a dialogue, at least with the current minister. So there would have been, for instance, a review of available lands with a view to then making disposals, in some instances based on lands that were under estate committees, and perhaps in some instances what other opportunities may reside outside of that.
Sticking to the ones that are outside the state committees, does it come down to it's down to the individual minister to decide how often they'll review that type of application?
I would say.
And just so that we're clear, when they are reviewing those applications, are they always applications to buy or lease an identified piece of land? Or do you get applications from people say, I would like to lease or purchase Crown land? You decide, Minister, what Crown land I'm entitled to. So it's an open application, or have they actually searched, found the piece of land, and then make the application?
I'm not quite following the entire sequence of
a general application could hypothetically be in two forms.
Yes,
it could be someone just submitting an application to the minister saying, I would like to purchase or lease Crown land, but not identifying the particular piece of land that they are interested in.
Correct.
The alternative is that they have identified it and they then submit a direct application to the minister and say, I would like to purchase or lease this piece of Crown land. Do you get both types of applications, or?
Yes, so let's take the latter version or the latter part of your question, which is that someone would have identified a particular parcel of land, and then that has to be considered. Before it would get to the minister, I think it's safe to say that there will be some due diligence with respect to what would happen. What is the plan for that particular parcel, which may be a similar parcel in interest by, say, other individuals. So an individual can go to the land registry, identify the fact that a Crown parcel exists without prejudice. In other words, you don't really have an indication of what that parcel is intended for by, say, a separate and distinct applicant, or by any other entity, and that may include government for that matter. So there will need to be some understanding in the first place of what is the likelihood of disposing that land in a particular way before you even get to the stage of, say, a minister deciding what he or she may want to do with that parcel.
Do you mean as to the use of the land? So
the use of the land, yes.
So
are there competing applications or interests?
But if someone comes to the ministry making an application for a particular plot of land because he or she wants to build a house on this plot of land, I mean, there may be a number of reasons why they're not successful. There may be other applicants competing with them to purchase this land to build a house on, or of course the ministry or other authority may have decided that this is not an area we want to build houses on. This is an area we don't want to build on at all, or we want to use for some other purpose, and therefore they can't have that land for that purpose. Right. I assume the ministry considers all of these things.
Yes, the situation is complex, yes, because there may be interests. Land, as we all know, is a limited, finite resource, and varying people may identify the usefulness of that land for a particular purpose. So the ministry would need to be minded to account for all of those in trying to dispose of that parcel. Yes. And that's generally what is being said before we get to a minister making a final determination as to the disposal of that parcel.
No, I understand that. Can you help me with this? Although I know it's in the evidence somewhere. Is there a sort of land development plan which says, you know, this part of this island we're going to use for use X, I don't know, tourism or something. This part we're going to use for residential. Is there any?
Yeah, so I would have made reference in earlier testimony, I think in, well, can't recall which of the, but there is the National Physical Development Plan. And the National Physical Development Plan would speak to the fact that there are generally areas that you will want to encourage certain type of development without prejudice. Now, whether it's binding to then follow that specific course of action, that gets negotiated and mediated by the planning authority when it looks at those plans against the National Physical Development Plan or local area plans that they may develop from time to time. against a particular application that would be submitted to them.
I understand that. So in terms of the National Development Plan, it may be that a particular area of a particular island, a particular use is encouraged, whatever it is, tourism.
Yeah, the National Physical Development Plan, which is separate and distinct from the National Development Planning process, which is based on the Sustainable Development Goals. So the National Development Plan, that layer just simply is independent and distinct from what I am referring to.
The physical
national, because the National Physical Development Plan is actually called for in the Planning Act.
Yes, no, that makes perfect sense, Mr. Smith-Abbott. But I think what you're saying is that if somebody wants to develop in a particular area where a use is encouraged, that doesn't necessarily rule that out altogether, but it's one factor that would be taken into account.
Generally, yes.
No, I understand that, and that's perfectly understandable. Thank you.
I think it was when you were giving evidence about statutory boards that you mentioned the National Physical Development Plan.
I figured that much, but there's been a few.
I was obviously, given your, I think your background as the National Parks Trust Director,
Yes.
it had obviously informed your knowledge. But on that, though, can you just assist the Commissioner with what the present state of play is with that plan?
Which one?
The National Physical Development.
The National Physical Development Plan was approved. So as I made mention, it was approved under the Act. So it was the.
I think if I could pause you there. If we look at Part 3 bundle, please. This is something that the Minister may be able to help us on. But if you turn up page 2093, please.
Okay.
Now, this is one of the documents, and it is one of the sort of documents that was produced to the Commission quite early on, because in May, this had been provided to the Commission by your ministry, and it was something that I think we asked the Minister about, and in fact your predecessor, Dr. Potter, about. When they came in May 2021 to give evidence to the Commissioner. And it's what the Commission was interested in was the criteria and policies governing Crown land. And this was one of the documents that was produced, which is the Virgin Islands Land and Marine Estate Policy, which I think was produced in 2018. If you turn through to 2102, please. 2102.
Yes.
There's a section headed Comprehensive Land Use Planning. Right. Now, if you look at that refers to the National Physical Development Plan. We know that this marine policy was produced in 2010 because in 2018. But here, what it says is the National Physical Development Plan, or the Physical Planning Act requires, amongst other things, the development guidelines be guided by a National Physical Development Plan, and all developments must be approved, permitted. Development plans were prepared in 1976, 1996 and 2005, but never approved. Cabinet recently approved a needs statement for the preparation of a National Physical Development Plan 2013-2025, with the completion time set for early 2014. The National Physical Development Plan is currently being finalised with support from the OECS GCCA programme and is expected to be completed in 2019. Now, this is obviously a 2018 document. So your evidence is that plan was in fact completed and has been approved.
Yes. So let me speak to the fact that the document that you are making reference to, National Land and Marine Estate Policy, is a product of work that would have also taken place under this particular project, the same one OECS Global Climate Change Alliance program. So as part of the overall view of sustainable land management throughout OECS member states, there was a view that we wanted to include and articulate a national physical development plan that would have captured work previously done on the matter. So therefore, there was a selection in this case of 1 or 2 member states which were pretty much well advanced in their development of the national physical development framework. The Virgin Islands were chosen on that basis, on the fact that we already pretty much had iterations of planning exercises, as you would have read out, starting very, very early in the 2000s, all the way, well, really going back even to the 70s, 90s, and then 2005. So on the strength of that body of work, which would have also included a lot of assessment of people's views about how to go about developing the territory, the grant was given to us, and it was administered through the ministry. So I actually acted as a national focal point.
That's your ministry?
Yes, this was our ministry.
Yeah.
So this particular project actually came through the ministry under this project. And of course, it was led by the competent authority, which in this case would have been the Town and Country Planning. Being mindful of the fact that the Planning Act permits and allows for the adoption of this plan to guide decisions about physical development, and that the planning authority in this case would be guided by the presence of a completed National Physical Development Plan. So when I speak to the approval process, I actually speak to the fact that we were very careful and very mindful to look at the provisions in the Planning Act that will allow for the adoption at the end of this particular project, the adoption and use of a National Physical Development Plan, which will then guide decision-making with respect to some of the issues that the Commissioner would have highlighted in terms of having an overall framework for physical development, planning, and land use. So that exists, and that is actually very much in use by Town and Country Planning, as well as by the Planning Authority.
And just remind me where Town and Country Planning sit in the sort of ministerial structure. Do they sit under your ministry?
They don't. They sit under the Premier's office. But because of the fact that, of course, you have this exchange and very close working relationship with respect to land use planning, and then, of course, us, the ministry that is, having to address the matter of land use planning through the management of Crown parcels, we do exchange quite a lot. And for the ministry at the time, it made sense to facilitate really and truly the development of the National Physical Development Plan of overall policy guiding the use of land in general.
And how does the National Physical Development Plan inform Crown disposals, if at all? Because it's not a policy it's not been disclosed to us as a policy that does so.
How well okay? So now you have this policy, the one that you're making reference to, the National Land and Marine Estate Policy, which is the next product of that project, the GCCA project. And because of the fact that there is Section 9, which is the one that you've just read, comprehensive land use planning, overall, there will be a need, and we have identified the fact that decisions about disposals are there lands that are required for public use? Are there lands that are more suitable for residential home ownership? That is all falling within the scope of an ongoing dialogue as to the best use of Crown lands, if you may, for varying purposes. This policy will call for, at some point, the formulation of a Crown lands management plan, which will look at those issues in particular, very granular level view of what the suitability of lands may be for varying purposes, whether they be for private, commercial, or public use.
I mean, so bringing it together, we have at present a national physical development plan, which, according to this paper, was completed in 2019, and you've said is, in fact, we can go one step further than that. It's been approved.
It's been, yes, it's actually under the Act. It's been adopted and approved and is in use.
A development under the umbrella of the physical development, national physical development plan is the policy we're looking at, the Virgin Islands Land and Marine Estate Policy. What stage has that reached? So
let's take a step back, right? So we have these two policies. What we also have is a third policy, which is the Marine Estate Policy. So this is the Land and Marine Estate Policy. So
that's the 1996 policy.
The 1996 policy was actually upgraded and actually worked on. So the 1996 policy effectively would have guided, for instance, the way that jetties, reclamations, moorings are typically addressed, and would serve as the overall framework and guide for the manner in which varying uses may be addressed of both the Crown lands as we know them, as well as the seabed. So parallel to the preparation of this document that we have, that we're looking at, there was an update to the Marine Estate Policy. And that update, which is actually not part of this bundle because we're looking specifically at Crown lands, not the Marine Estate. But there's an updated Marine Estate Administration Policy, which effectively was the subject of a lot of work because we needed to look at that particular framework. So this document, as we're looking at right now, is still in flux because of the need to continue the review, especially of Crown lands, as we're now doing. But in the intervening period between 2018 and really up to last year, we were actively working and would have had those guidelines, that policy approved by Cabinet.
When you say
the Marine Estate Administration Policy.
If you look at 2372, is that the policy you're referring to?
Correct.
Now, this is a 1996 policy. It's dated 1996. We in fact have two versions of it. Minister Wheatley has given us a version which looks more like something that would have been produced in 1996, but the differences between the two seem quite minor. But I think what you're saying, Mr. Smith-Abbott, is that there is in fact a more modern iteration of this policy.
That is correct.
That has been worked on in recent years, and that by recent years we mean very recent.
Yes.
And that developing, updating that policy on the management and administration of the marine estate is the reason why this policy we've been looking at, the Virgin Islands Land and Marine Estate Policy, is still in development.
That's correct.
See, if we look, before we leave that, we may as well deal with this, but if you go to 2104 in that policy,
page 2104.
yeah. Paragraph 12 is the part of this document which, so I'll let you turn it up.
Yes.
That's the part of the document that deals with Crown land, and we asked Minister Wheatley about this back in May 2021. And it points out at the end, there exists no management plan to provide for the sound planning, management and use of Crown lands. If you turn through to 2113, this is part of a table which is headed Policy Recommendations for Addressing Identified Issues. And 2113, we're dealing with the issue being described as suboptimal management of Crown lands. And there are a number of policy options that are identified. The first one being to enact legislation that requires your ministry to develop and implement a comprehensive Crown lands management plan, including plans for the short and long-term suitable use of Crown lands within the framework of a wider national development plan, and the identification of additional Crown lands that are required for essential public purposes. The Crown lands management plan should include plans for acquisition and disbursement, and define sustainable financing mechanisms for Crown land acquisition and the creation of a land bank. Now, where it says National Development Plan, is that a reference back to the National Physical Development Plan?
No, this would be the much broader National Development Plan, which is attached to the Sustainable Development Goals.
See, so we have a sort of hierarchy of plans. The National Development Plan, sitting underneath that is the National Physical Development Plan. Sitting underneath this will be this Virgin Islands land. Parallel to. But definitely sitting under the National Physical Development Plan is this Virgin Islands Land and Marine Estate Policy.
Well, I'm not going to get into where the plans sit by way of hierarchy.
Happy if you move them around.
It doesn't really matter. We have a National Development Plan which provides the overall framework. That's really a view of development at the broadest, widest scale. We have there's been a delivery of the National Physical Development Plan that governs the Planning Act. The ministry proper must have a framework, which is ultimately what this policy aims to do, and by the reference there was a recognition that Crown land management requires a framework for, Crown lands require a framework for how do you go about managing competing interests in the use of a finite and very valuable asset. So therefore, what you've read out in its entirety, which is the preferred policy option, is exactly what I would have stated earlier, which is that there is a requirement, there's a need for us to have an overall framework for rationalizing how Crown lands are to be disposed through the Crown lands management plan. So that's effectively what this bullet aims to do. You would have not seen much articulated under the main policy with respect to just the fact that Crown lands are just simply identified as a certain percentage of the overall distribution of ownership in terms of the territory. But the functional and practical aspect of work for the ministry is to develop this plan that will allow us to then rationalize how Crown lands are to be disposed.
And you've said this policy is in a state of flux.
Correct.
Where are you with the Crown land management plan?
Well, first of all, we are really looking at what are some analogous examples. What are some good practices internationally within the Commonwealth for how do you go about managing Crown lands? And there are some very useful examples, not only within the region, but perhaps in Canada as well as Australia, which have similar frameworks for managing Crown lands. And by that, I mean, you were looking at legislation. What is a legislative framework that governs Crown lands in these other jurisdictions? What are some of their policies with respect to varying aspects of their management frameworks and guidelines?
So is this correct that this is being considered? It's obviously a very important, I mean, a very important aspect of development as a whole, partly because Crown lands represent about a third of the land in the territory, and secondly because it's a very valuable resource. So that's being considered, and eventually there will be some, it's proposed that there will eventually be some statutory framework. And
yes.
And that's being developed at the moment.
Yes, I mean, we're now starting, effectively, this policy right now is in flux, as you rightly pointed out, because we are having to review the framework, the mechanisms, the overall governance. So for instance, and I'm not going to preempt the questions about estate committees, but it is clear, and I'm just using that by way of example. Estate and advisory committees typically have a role in the disposition of lands, right? They will be responsible for vetting based on the availability of a number of parcels, suitable candidates based on the established criteria that would be disclosed to them. However, one of the significant gaps in the trajectory of development of the disposal of lands is that you don't have a legal, they don't have a legal standing, if you may, right?
The committees don't.
The committees now, I'm referring to the committees. So one of the things that we need to really and carefully explore is how do we bring estate and advisory committees into the governance framework? And I don't want to suggest that it will be done administratively, which is effectively the practice. One of the key things that I think we need to be mindful of here is that they have a role. They are an important stakeholder. They provide the layer of vetting and the layer of review of the applications that are likely then to be considered by a minister and by cabinet. So the ministry at this stage is very, very mindful of the fact that we have to reform the governance and the institutional arrangement that allows for those estate committees to have a more significant stake. There's been an ongoing dialogue in some quarters about what is the role of an estate committee, an advisory committee, and that dialogue is being looked at and being taken very, very seriously. And certainly one of the things that in reviewing other jurisdictions and reviewing the framework for how you go about integrating that critical layer
into a modern
framework has to be defined statutorily. It has to be defined statutorily. They have to be given standing. The terms of reference that are, which I'm sure we'll go through in a few moments, those terms of reference are administratively defined. But can we now begin to look at a mechanism whereby those terms of reference actually are enshrined in law? So if we receive, for instance, an application in a hypothetical sense, if we receive an application for ancestral lands, for crown lands, and I use the word very purposefully in terms of ancestral lands, because there are examples of ancestral lands that are actually dealt with, have been dealt with, and are modernly being dealt with. Then that means that we as the ministry have to find a way to give the committees, whether they be estate committees or advisory committees, as the case may be, legal standing and a place at the table in terms of the governance, so that the recommendations and some of the issues of accountability and transparency and good governance are addressed. And that is in part some of the flux, really and truly, if you want to define that, in a practical sense, some of the flux in terms of the fact that this is still an ongoing dialogue, and the policy will, by necessity, have to reflect the views, very, very strong views in some instances, but views as to how best to incorporate the public's input into the disposal of what is ostensibly a publicly held asset of great value. So we have to do that. So we are looking at mechanisms elsewhere that can provide at least some model, some template for us to then build on that, given the fact that recognizing that we've been managing estates, we've been receiving the inputs from estate committees, we've been receiving inputs from advisory committees, but administratively.
Yeah, that's very, very helpful. Thank you.
I mean, that just to finish off, I mean, the three you're pointing towards, I'd suggest that the need to enact legislation, which seems to be the sort of doorway that's envisaged in this paper to having a Crown Lands Management Plan. The first step will be to determine, after dialogue and research, what sort of legislation you can have.
That's correct, yes. I mean,
and you've taken it wider in the sense that it's not just about Crown land management, that the dialogue and possibly the need for legislation will be informed by what should the status of the lands committees be in the 21st century.
Yes, very much so. I think that just to, if you're concluding this particular issue or this point, 3.1 really and truly forms the basis for 3.1 and the preferred policy options, as you would have read, forms the basis of the work at hand. This policy will have to vary to take on all the things that I've already stated, including the fact that there'll be a preferred set of options, legislatively speaking. What constitutes a reasonable legal framework that we can look at without necessarily having to build a house from scratch, if you may. So that becomes the important departing point. And then inevitably, there'll be further dialogue with advisory committees, with land estate members who would have had experience managing state committees, and there are a few of those individuals that are still around that we can rely on as to what would have been reasonable options and practices that they would have employed. And then all of that volume of work will then have to be reflected in a proper legislative framework governing the management of Crown lands in particular. And as you would have said, Commissioner mentioned, modernizing the practice and sort of regularizing this layer of work that would have taken place over several decades. In some instances, some may argue hundreds of years.
But, before we leave it, I mean, amongst the other preferred policy options are developing a database of all Crown lands and publicly managed lands, identifying land parcels where revenue is due and having an agency responsible for collection, and then undertaking an audit to ensure that there is enforcement of penalties and collection of revenues. Those on their face don't necessarily need legislation to be taken forward. Are any of these three being taken forward?
Yes. So the ministry right now is currently undergoing a review of all of the disposals of land, irrespective of wherever they may have taken place. I would have made reference already to the fact that there are registers of lands, whether it be Crown lands or reclaimed lands that would have already existed. So those have to be looked at, and we are looking at how do we then harness the geographic information system that currently is a shared resource across several departments. And there are several departments that comprise the National Geographic Information Committee, Systems Committee. So some are most of the individuals are representatives from varying departments of government, ministries. So all of the information is there. It's just that it's not necessarily purposed in a manner that is fit to address holistically how we manage lands in an integrated manner. So that information system, that land information system, is being construed, is being looked at, and design of an optimal arrangement for databases or whatever the case may be is being explored.
If I take,
In the hope of being helpful on anything else on the theme, you were just dealing.
Could you put your microphone on, please?
I do apologise. Yes. Apologies for interrupting. So, but in the hope of
Still not coming through, sorry.
filters like that.
yes.
Much better.
None of us turn it on correctly the first time. Don't worry.
Well, I'm grateful for the indulgence of on the first time at least. So yes, on the point of legislation which the ministry are looking at, I was just going to refer you, sir, to, and it's further on, we may be coming to it, but there is an example referred to in Mr. Smith-Abbott's affidavit at 17.23, that's page 30 of the bundle. Not so long ago, the Long Look Lands Commission Titles Amendment Act. And so it may be that the ministry will have resources to go to when it comes to legislation. There are older examples in relation to Anagada, but I point to that particularly simply as a rather more recent form.
Which paragraph?
It's paragraph 17.23, page 21 of the internal paging on the pagination on the affidavit, page 30 of the bundle. It's referred to in a particular context there, but there was in respect of Long Look, therefore, legislation which dealt specifically with the sorts of conditions that could or couldn't be imposed.
Yes.
So there is precedent.
Yes.
I hope that's.
Yes, thank you.
That was all I wanted to point out.
Now, Mr. Howard, if you're moving, is this a convenient moment to break?
If I could ask just one question,
No,
and then
certainly.
we will break, because it will be a natural break. Can I take you back, please, to page 11 of your affidavit, please, Mr. Smith-Abbott, and just to finish this off, I'm looking at the root of it, which is before we digressed at the applications that are direct to the ministry. So if you like, the general applications you were speaking of. And this was the ones that are periodically reviewed by the minister. I want to keep the state applications separate, but when you referred to that you anticipated that there would be some due diligence done before a minister looks at or undertakes a review, because the minister makes a recommendation to cabinet. Is that right?
Yes, so
Or 4.7C.
4.7C,
page 12. So you say that somebody makes an application, effectively they go on a list, minister will review, time to time will make a recommendation to cabinet for an allocation of land to an applicant. But my question is whether there is advanced due diligence before the minister reviews or at the time that the minister reviews, what's the criteria that are being used to select which application will be considered?
so I've not found criteria within the ministry that would say guide the selection process.
But I mean, is it done on a first come first served basis on the date of the application, or is it just
I cannot
overall
speak
consideration?
I'm not. It's broad consideration. I can't say what the parameters of.
No, I think that's consistent across the evidence that we've seen, Mr. Smith-Abbott.
What you do say, just to finish this off, is that a survey and a valuation would be prepared before the application goes to cabinet. So, but are these prepared before or after the minister has considered the application?
So, if you're looking at let's I can parse this. If we're looking at commercial leases, normally there will be a valuation, and those will in some way inform whatever the rent values may be. For residential purposes, there would have not been valuations required for the disposal of lands, save that there's been a change in policy earlier this year. And I'm
Since
sure that
February
we'll get
2021.
correct, and I'm sure that we'll get to that. But yes, typically and normally there would have not been valuations which would have then guided the disposal, so to speak. There's been a recognition, obviously, since February 2020 that that's a requirement. And as a matter of fact, now the ministry is very much engaged in properly costing and factoring just that. What is the value of the, or what is the overall cost of the implementation of this policy with respect to the disposal of Crown lands, based on the presence of these valuations?
My question went to the timing, because
So the timing, so the context of timing in terms of whether they're considered before or after.
I mean, it's if they're considered before, if they're available before the minister considers the application and decides whether or not to make a recommendation, and that could inform the decision. If they're available afterwards, then they will be there to inform Cabinet's decision. So just
Right.
accepting that there may be situations where you don't have a evaluation report, but do they, as a norm, do they come before the application is considered by the minister or afterwards?
I can only speak to what has emerged, what is developing right now, which is that valuations generally are now being called for prior to any decision by Cabinet in this case.
So again, just restricting ourselves to what has developed, not historical. The minister will come to a recommendation, and then evaluation is obtained so that Cabinet can approve the recommendation, as it were, with a value in it, either a disposal value or a rental value or whatever it is.
That's correct.
I understand that's helpful. Thank you.
Commissioner, that is a convenient time. I'm moving on to something else.
As you know, we have a stenographer, Mr. Smith-Abbott, so we have to break about every hour. So we'll break for 5 minutes now. Thank you very much.
Thank you.
Good, thank you, Mr. Rao. We're ready to continue.
Thank you, Commissioner. Mr. Smith-Abbott, could we go just to paragraph 4.12, which is where page 13 of your affidavit, please. And you now move on to discuss the second route by which an application to purchase or lease Crown land can be made, which is via an estate land committee. And you set out the process here. Now, the first point you make is that it's the application is first made to the ministry, and you say application forms are usually drafted by the ministry. On what occasions would an application form not be drafted by a ministry?
I can't immediately recall any instance where an application form may not be initially prepared or drafted by the ministry. Generally, there are, for every estate that you're likely to then have disposals around, there's a form available, an application form, which would then be filled out by prospective applicants.
I mean, in terms of estate land disposals, there presumably must be two types. The first is where there is an active lands committee. As we understand it, currently there's only one, the Anagada Advisory Land Committee.
That's correct.
And so the second type of disposal would be where there is no longer a land committee, for example, Spooner's estate.
That's correct, yes.
Where if someone is there, if you like, redisposing of land, then that would fall to the ministry to deal with.
That's correct, yes.
But if we're talking about a sort of an active process where so it's the Anagada Advisory Land Committee, you say that they take the view that direct applications can be made to them rather than the ministry. But you seem to be saying that in general, the norm is that the applications come first of all to the ministry, which then passes it on to the land committee.
That's correct.
Why are applications submitted to the ministry and not directly to the land committee?
I think it's just simply to register the number and type of individuals initially, before then passing those applications on to the estate committees.
And there appears to be a difference of opinion with the Anagada Advisory Land Committee, because they take a different view.
Yes, I mean, in other words, typically the applications would come into the ministry, like you would have made mention, and then are passed on. The Anagada Advisory Lands Committee takes the view that those applications, because of the historical ties to the land, the fact that they are defining, for instance, Anagadians who ought to be, and they do the vetting work around the Anagadians who would have legitimate claim, that in those circumstances, they should be able to also receive those applications.
And this, Mr. Smith-Abbott, is not intended to be a test, but it is for my education. The estate lands committees, my understanding is that they have been in existence for some time. I mean, do they go back to the Unencumbered Lands Act, which were in the middle of the 90s? I mean, do you know how long they've been going, that they've played a part? I mean, the part may have varied over time, but how long they've played a part in this process?
Well, no, some of the earliest ones go back to the 70s.
Yes, I just wondered whether they went back historically a lot more than that, or perhaps not. I mean, perhaps they are certainly the product of the mid-20th century.
I would say I haven't.
No,
so there are instances that, testing this almost sounded like a test, but
no.
Yes, but you do have commissions that that were established to look at matters of lands and.
Well, and those go back to sort of 1854.
Exactly.
Yes.
Exactly.
I understand.
But in terms of the practice of the establishment of estate committees, Yes, that tends to be
more recent.
more recent. And by that, I mean, you're looking at 40, 50 years.
No,
so recent is relative, of course.
So, and again, so I'm not holding to this. This is purely from education. But so all of this was done by commission from the mid 19th century, when the estates were unencumbered and freed. But then the place of the estate committees came in relatively recently, over the last 50 years or so.
Yes.
Yes. No, that's very interesting. Thank you.
Is that something that's being worked out with the Anagard Advisory Land Committee, how the application should be processed?
That's correct, yes.
And as I understand it from your affidavit, which is, this is at paragraph 14.39, which is at page 26. The stage that we're at with that committee is that it was sort of revived in July 2020. It's got terms of reference, and if you go at 1441, you say that the AALC provided a proposed amended terms of reference which largely adopted the same criteria, which is what you've set out at 1439. This is criteria for who qualifies for a grant of land. But are they, what stage have they reached as a committee? Have they got established terms of reference and an established membership now?
Yes, so no, there would have been established terms of reference that would have given way to the approval of the committee in the first place. So there would have not been an approval of that committee without the terms of reference accompanying that process.
And does that approval have to be done by cabinet?
Exactly, yes.
And I know you say they're not on a statutory footing, but I noticed that, I mean, you've put in, for example, the terms of reference for the draft terms of reference for a 2009 Virgin Gorda Lands Committee. It's one of your exhibits. And that has, for example, an ex officio member from the ministry on it. Is that how the Lands Committees function, that there will be at least a representative of the ministry on the committee?
That's correct.
So in some ways, they are akin to a statutory board in that they will have ex officio members from the ministry.
That's correct, yes.
Do they have a budget?
No, not one that I have at least been able to discern that is embedded, for instance, in the normal submissions that would be given to government for funding. And I think that if you look at the strict statutory body enacted by law, National Parks Trust, for instance, which I will be obviously very familiar with, will receive a subvention. So there's a subvention that is defined and which would be ratified in House of Assembly as part of the budgetary process. I've not seen a similar practice with the committees. There may be some allocation granted or given on an incidental basis.
Which would have to come from existing
which would have to come from existing ministry budget. But certainly in defining the legal framework and giving standing, because of course the costs attached, of course, to the management of these processes. So part of the review that I would have made reference to earlier, as part of the testimony evidence, would also require some real serious look at the costs attached in the management of these processes, because they're very energy and time consuming and resource intensive in terms of just, if, for instance, a committee is going to receive an application directly, the administrative cost is borne by someone. So that has to be accounted for somewhere. And that review, that process of accounting for that, then must be taken into consideration somewhere. And that's part of what we need to look at seriously. First of all, the recognition that there are administrative costs, quantification of what those are, and then subsequently how are they going to be addressed as part of, say, a regular budget?
Members of a lands committee essentially are volunteers. They would work for free.
Yes, very much so.
And in terms of the process that they undertake, I mean, you've explained that part of the rationale behind the lands committees is that they are a means by which effect can be given to a policy that to encourage and empower belongers to own land.
Yes.
And so that's the incentive is not for them to dispose of land at market value. It's in fact the opposite. The incentive is to dispose of land at prices that belongers can afford.
That's correct.
Now, the third route that you set out is the discretionary allocation, which presumably that is Crown land being granted at the discretion of Cabinet.
That's correct, yes.
Would it be done on the recommendation of the minister?
So as I understand it, there may be instances where, if there are lands available, for instance, in an area, any given area, there will be some consultation. There may be consultation with the district representative for the particular area to understand from that individual, from that member, who may be individuals who should be considered for home ownership or the disposal of lands. So that's at least the understanding in terms of how that discretion may be applied. There may be some consultation with respect to, say, the awareness and knowledge of that representative of individuals who may be considered, and then the subsequent recommendation.
And in terms of the mechanics, it would still, I mean, let's, an approach is made by a district representative. But ultimately, because it involves Crown land, does it still have to be taken by your minister to the Cabinet?
That's correct.
And I think your affidavit gives examples, because discretionary allocations, as I understand it from the affidavit, it's not just to recognise somebody who's made a contribution to the BVI. It can also be used as a way of dealing with individuals who may be in a particularly vulnerable position. That's correct. And but is it, again, that there's no set criteria? It will depend on Cabinet's analysis of the particular circumstances. That's correct. So there are no guidelines or criteria governing the selection or pre-selection process. What should guide the selection of an individual? I can't say that I found it. If I ask you to turn up the second bundle, part 2, please, and just go to page 1902. This is a part of a letter. Excuse me. It's dated the 18th of November 2020, and you'll see it starting at 1900, Mr. Smith-Abbott, but it's from your predecessor, Dr. Potter, and it's addressed to the governor, and it's setting out essentially how land distribution in the British Virgin Island Crown land distribution is undertaken. At 1902, at the very bottom, you will see that there is a reference to a sentence which begins, so Dr. Potter has discussed the land committees, and says, beside the land committees, recommendations were also made by the minister, which is what we've looked at, and in some cases by the district representative of the district where the development took place, where the committees are not in place. So it seems to be, or Dr. Potter seems to be pointing towards a situation where you don't have a existing land committee, then a district rep can make recommendations to a minister. Have I understood that correctly?
That's correct.
And is it only in those situations? And this, I'm assuming this is a reference by Dr. Potter to estate land. Does the district rep only become involved where the committee is no longer in existence?
I cannot say that. I guess it presupposes that, I'm understanding the question correctly, that if there is a committee in place, would the district representative then also have a role to play? Is that?
Yeah, take
yeah,
that
I cannot say, because barring the fact that I would have not really worked with an estate committee at the time when they were actively involved, beyond the one on Anegada in this case. I'm not certain that I can speak to whether they would have been or not involved at the time.
But where there isn't a committee, we're then dealing with a situation like Spooners, where you've had a committee established, it distributed land, but now perhaps there's a redisposal, as I've called it, but there's no committee to oversee that. Is that the sort of situation where a district representative can make recommendations to the minister?
Yes, so it is my understanding that yes, there would have been an approach, there would have been some consultation in terms of understanding who, once lands became available for redistribution, at least some consideration of individuals who may qualify or may be worthy, or whatever the parameter may be. I cannot necessarily characterize what would constitute something, what would constitute a parameter to then select an individual or not. But yes, there would have been some consultation at that stage in the absence of that estate committee.
And where you are dealing with this situation where it's estate land, but there is no estate committee, is that still described as an estate application rather than a general application?
It will still be described generally because it still falls within the criteria and parameters and the original terms of reference
of the estate.
And as a matter of fact, it is also my understanding that the selection of individuals, say for Spooners in this case, may have reverted back to the original list of recommendations.
The original list of criteria.
And recommendations made by the committee at the time when they were active in terms of the individuals who may be considered.
Yes.
Whether that was strictly adhered to or not, I'm not certain. But at least there would have been some consideration of those names appearing on that report, on the state committee's report at the outset of its work, to then at least nominally inform the selection.
And where you have taking it back, where you have a general application, are there instances where the district representative can write in support of the application?
It's possible. I did not see something that specific. I certainly wasn't looking for that, but it is possible that they may or may have not done so. I can't say.
And just one matter on discretionary allocations, where that is being considered, what information is required to go to cabinet?
Generally, the same information that would support any application: proof of belongership, that fact that they have qualified, that they have met the criteria according to the estate criteria granted or given at the time. Those are, whatever
so it would be the criteria that apply to that piece of land.
That piece of land, generally speaking, at least from my understanding. I may be subject to correction, and I will certainly have to look into that more specifically, but at least that's the general impression.
And I assume, because this is a pretty general discretion when it gets to cabinet. In addition to the matters which, as it were, have to be shown, proof of belongership, the satisfaction of any particular criteria for a particular estate. I assume that also what would be set out to cabinet are the reasons why the recommendation is made. You know, the factors,
Yes,
which have led to which has led to the recommendation.
So in the case of the specific case that is being referred here, you would have had some examination of the parcels available. Whether, for instance, there may have been individuals who may have not met the conditions of the original grant. So in this case, individuals who just simply not paid. So there was a decision taken to claw those back, if you may, rescind that approval. So it then afforded some opportunity to reallocate those parcels. And it's in this context that then you have this discussion about the fact that the estate committee would not be in place because it would have already determined, made recommendations at the time via report. Those recommendations would have been considered and lands would have been granted at whatever time. And now you have this window and this opportunity for reallocation. So under these conditions, what are the best options available? In this case, discretion. And that discretion will be exercised in part by having that conversation, that dialogue with the district representative.
And what we have in terms of the need to establish belongship status, that is a requirement for where you are going through an estate land committee.
That's correct.
It's a requirement for a discretionary allocation.
That is correct.
So in terms of a non-belonger seeking to apply to purchase or lease Crown land, we'll look at the detail in a little while, but that can only be made through a general application direct to the ministry.
Non-belongers are not applying for this subset of lands available for this program. So therefore, non-belongers are governed by the Non-Belonger Landholding Act and a different process. So this is not immediately related to any aspect of Crown estates, Crown land estates.
Yeah, I mean, as I understand it, I mean, the States Land Committee serve a particular purpose, which is a policy purpose. It's not it's not driven by.
Well, it goes beyond policy. I mean, there's quite a lot of administrative work.
No, but what I meant.
But yes, they support.
The point about the fact it's about. Through the history of the committees, going back to Spooner's in 2008 and before that, what you have is the purpose of them is essentially to make land affordable to belongers.
That is correct.
It isn't driven by finding buyers for land at market value.
No, not at all. And
so belonger status serves as a neat divide, because if there's going to be a discretionary allocation by cabinet, belonger status will be a factor. If there's going to be an estate land disposal, it has to be a factor.
Yes.
So if for the non-belonger seeking to purchase, lease land, whether for commercial or residential purposes, their route is through the ministry.
Their route is through the ministry, and that's governed by a different scheme altogether. So you will not have instances where non-belongers are applying in this manner.
Thank you.
If we go to 5.5, please, and just look at the process by which.
We have finished with this. This was number 2.
Yes, we are. If we go back to number 1, please. Sorry. Back to your affidavit.
So I'm being directed to go to
paragraph 5.5 of your affidavit at page 14, please, Mr. Smith-Abbott. This is where you start to explain the process by which someone can make an application. you focus on how someone can apply to purchase Crown land, and then you go on to say that the application to lease is largely the same. You make the point, and this is at paragraph 8.1, that a difference between a commercial application and a residential application is perhaps obvious, but it's in the former. The submitted presentation can include a business plan, and that where there is a business plan submitted, then that falls to be considered by the Premier's office. Another difference, which perhaps we've just touched on, is at 9.2 on page 17.
Well, one word about 8.1 in the context. A business plan may be required under those conditions if there is a development agreement. So there are some instances where there may be development agreements being negotiated under the Planning Act. So there's a specific reference here to the fact that there may be an agreement in progress under negotiations, and a business plan will be called for under those set of conditions. And I make that point in the context of why it would go to the Premier's office. It is in that context that it will go to the Premier's office.
Just develop that a little bit further, though. Can you give set out for the Commissioner just circumstances in which an application for a commercial lease or a commercial purchase won't require a business plan?
I am not certain that, well, in some instances, there's at least a statement of purpose why you may want to lease a particular parcel of land. That statement of purpose may be in some instances expressed by letter, not necessarily the development of a full business plan. And you have to appreciate that there's no standard format for the presentation of that business plan, so to speak. So I've not seen anything that prescribes what that business plan ought to include. But I have seen in some instances expressions of interest, which are just simply described by way of a letter. I want to lease this land to set up X or Y type of business. Or in some instances, there may be a full requirement for a full-fledged business plan, but those may be called for specifically.
I mean, so these are obviously fact-specific circumstances. But before Crown land is disposed to anybody for a short lease, a long lease, freehold, whatever, you have to have comfort if it's commercial that there's going to be a proper commercial purpose and there's an intention, as it were, to carry out that commercial purpose. But what supports that comfort depends upon all of the circumstances, including, I suspect, the length of the lease and the nature of the business and all sorts of other things.
That's correct.
Yes. No, thank you.
So if I just, as I said, before we go back to section 5 of the affidavit, what you make the point at 9.2 is that applicants are required to identify the status and identity of the applicant, because preference is typically given to belonger and BVI Islander applicants who don't possess the economic resources to purchase land otherwise. Additionally, non-belongers and non-BVI Islanders are not permitted to own land without first obtaining a non-belonger land holding license, which is the point you made earlier. But if we go back to section 5 on page 14, 5.4, you say that the applicant has to provide certain documents, whether they are applying as an individual, a company, or a statutory body. But where you have an application being made on behalf of a company or a statutory body, who should be the applicant?
You are asking in the context of a commercial application, who should be the applicant?
Yes. I mean, if there's a company making the application, is the company the applicant, or is it a requirement that it be a director or a senior manager or a shareholder?
Well, again, there's on the matter of purchases, again, there's nothing specifying whether that individual should be a company director, as the case may be. So there will be other statutes, I guess, or provisions, but I certainly have not seen anything within the ministry that would speak to the nature of that applicant, so to speak, whether that should be the commercial entity or whether there should be a director in their own right representing company.
You set out there at 5.4 a number of documents that need to be provided. You say should be provided. And you, for example, refer to a development agreement between developer and the government of the Virgin Islands. Are there circumstances where an application would still be considered valid if the required information is not submitted?
I cannot say that. Well, I could say that there may be some instances where the application would have been considered without some of these requirements as described in 5.4.
But where there are those instances, are they going against the process? Are they outliers rather than actually what the process should be?
As I understand the process described in 5.4, these are general requirements for how purchases would be considered generally. So there would be the provision of the passports, business plan if one would have been called for, and the general certificates pointing to whether the company and its directors are in good standing.
And in terms of an approach, is what you set out there written down, or is it a matter of practice within the ministry?
I think it's a matter of practice within the ministry.
Now, as to a lease, you point out that, and this is at 5.13 on page 15, that a lease can either be for its intended purpose can either be agricultural or commercial. But if we look at, I think it's 8.2 on 17, this is where you're discussing the difference between processes for residential and commercial purposes. You make the point that residential approvals are predominantly freehold, but commercial approvals are predominantly leasehold. So does it follow that it is possible to have a residential lease?
I have not encountered a residential lease. Most disposals for residential purposes, once that individual would have discharged their debt with the ministry, would then receive a transfer of freehold land. For the purposes of
I mean, is it technically possible? I mean, it's technically.
I guess it's technically possible, but in practice,
it doesn't happen because the person to whom the land is disposed will be a belonger. It'll be for residential purposes.
That's correct.
And,
Yes.
and the whole purpose is that's for the as it were the family home.
Yes, exactly.
But if a non-belonger has a non-belonger land holding license, can they make an application to purchase residential land?
Yes, but not through this particular process that we're referring to.
Through a different set of regulations.
Yes, I mean, this is generally you're talking about a parcel of land that may be available for sale.
So the process that we're talking about is disposal of Crown land.
Correct.
And
whereas non-belongers are governed, and like I said, those are typically parcels that are available in the open market for sale. The rules will apply, at least some consideration of that land being purchased at first instance by a belonger or BVI lender. If there's no such person interested in that, then that non-belonger may place that application to then purchase that land, and then there's a licensing process governed by the Act that would be carried out.
And does that apply whether the non-belonger is wanting the land for residential purposes or commercial purposes?
Yeah, respective. I mean, the processes would still be the same for that non-belonger.
So Crown land is really aimed at belongers. I mean, a non-belonger will need to. They can go on the open market if they've got the license. They can go on the open market whether they want land for a commercial.
Well, the license
purpose.
is for the purchase of a specific parcel in this context. So right, so they wouldn't necessarily just receive a license just to go and say speculate.
But could a non-belonger, for example, in relation to commercial land, could a non-belonger seek a lease of Crown land for commercial purposes with a license?
Yes, I guess technically it is possible that non-belonger can pursue Crown land. Yes, it is
for commercial purposes. For commercial purposes,
not for residential purposes, as we have described, but for commercial purposes, it is possible. Yes, and very much the case.
And I mean, you draw a distinction between sort of an agricultural lease and a commercial lease, but someone can obtain or can have an agricultural business that is commercial.
Yes, very much so.
How is the distinction drawn between an agricultural enterprise and a commercial enterprise?
I think that it's mostly where you're likely to see that, first of all, in terms of the types of lands available for agricultural purposes, where you're likely then to consider or locate such a type of application. But yes, that non-belonger who may have a larger enterprise can, for purposes, for commercial purposes, agricultural purposes now in this case, can indeed pursue the leasing of that land for that purpose.
Can you just clarify, if we're moving on now, I think to page 17, if we look at paragraph 8.1, please.
Page,
paragraph 8.1, page 17, please. It's taking us back to commercial purchases and leasing of Crown land. And you say at, you've explained the point about business plan, but it's just picking it up at 8.3. You say depending on the commercial value, difference would be, and this is a difference between commercial purposes depending on the commercial value of the business or development. And the difference would be having a registered development agreement. So to just clarify, what is a registered development agreement?
So registered development agreement, again, is that which is governed by the Planning Act. A development agreement would then form the basis for a commitment by that developer to carry out whatever works. Bring in however many jobs, or generally speaking, satisfy and discharge whatever would have been agreed between government and that developer, so to speak. And that instrument would be registered, so to speak, yes.
And is it only in that context that they would be required to produce a business plan?
Not necessarily. I mean, so we are making distinctions about scale and size of development, and I think that's where we may need to parse this a little more. In some circumstances, as I understand the process, there are some instances where the scale, size, and importance of development may be of such nature that is undertaken, that layer of negotiation, so to speak, may be undertaken. The ministry will obviously have some input, because if that parcel being considered is Crown land, and it could include reclaimed land for that matter too, there will be some exchange. And also there will be exchanges because in some instances there may be labor requirements that may need to be met in terms of labor, importation of labor to assist in the development process. And I'm just using that by way of example of how a much broader view of a development agreement may necessitate some degree of coordination, which will be undertaken by the Premier's office in this case. But there will be a number of stakeholders around the table, of which, of course, the ministry will be one of those in the context of whatever our portfolio thematic areas under our portfolio may be: labor, lands, immigration in some instances. Those are things that we will have to be mindful of in also considering that. So that business plan, or at least the parameters of what would need to happen in order to facilitate that development, would be articulated through a business plan, or maybe articulated through some other means, which would then form part of that agreement as to what government now is going to do to facilitate that process.
And that is all led by the Premier's office.
In that context, yes.
Yes.
In the context of a formal development agreement,
yes,
under the Planning Act, yes.
And where you reference, as you do in paragraph 8.3, a public consultation may be required depending on the environmental impact. That's again referring to the same context.
Correct. Under those circumstances, an environmental impact would be vetted by our ministry, because we are responsible then for the receipt of that alongside with the town and country planning. So the entry point will be the town and country planning department, and then that environmental impact assessment report, whether it's limited or full scope, will be given to the ministry. It will consider that and then recommend accordingly.
Taking you back to 8.1 on the same page, you note at the end of that paragraph that particular concerns have arisen in the context of leases, where the lease is granted, but then financing falls through and the development never proceeds. I think this was a point that Minister Wheatley made when he gave evidence in May, where it's essentially the land is never built on or never used for the purpose it was disposed of. What is being done at the moment to address those concerns?
Well, I think that if I then go back to earlier statements that will feature in that whole discussion about what is the suitable response, legislatively or otherwise, to instances where you have non-performing lands.
That goes back to the sort of internal dialogue that's going on about taking the marine policy one step further and having a crown land management plan.
That's correct.
If I take you back to 6.1 on page 15, please. You were asked to address whether there are published policies or guidance setting out the process for applying to purchase or lease Crown land. And you say that there are no published policies or guidance setting out the process. The ministry is in the process of producing guidelines for publication. Further, the ministry is always happy to respond to individual inquiries. When do you intend to publish your guidelines?
So I want to go back to the baseline of this discussion, which is that the National Land Policy provides a platform to articulate exactly what these guidelines may be. Similar to what would have happened with, say, the Marine Estate policy and the Marine Estate administration policy. There needs to be a similar exercise where we are indeed minded to publish guidelines such as these. And that will form part, not necessarily, I mean, it may form part of the policy, it may be an appendix to the policy. No decisions have been taken that are firm around that, but there is a recognition, a very strong recognition that the policies and the guidance for how you go about applying for Crown lands, what is actually required, the means by which you make determinations and recommendations, and parameters for what should guide the decision-making process. All of that is certainly under review.
But there's no timeline yet for say, guidelines.
If I take the process that would have been undertaken with respect to taking the update of the marine estate policy into the current state of the administration policy, a similar process will be undertaken. So I would say that this is something that we're actively working on, and it's a matter of priority. It is a huge priority for us. So I would venture to say that, you know, within the next few months to within a year, we should be able to at least have a very clear notion, because we already pretty much have a baseline, and the baseline again is the same policy that you're making reference to. The guidelines, and I want everyone to be mindful of the fact that the determination of guidelines, the consultation around how do you come about stating a firm position as to what we're going to do. Of course, the drafting process. It's a series of steps. Because there are a number of agencies involved in this process, as described in the response and the affidavit. It's clear that we will also need to consult internally and externally as to how these guidelines are going to emerge. So that policy by necessity will be republished for consultation and for further review. And that process is time consuming. So I will want to say that certainly something that we're going to engage very much in the public domain, because we do have a good baseline, a good starting point.
Is it sort of, and I'm not being dismissive, I'm just trying to put it into context, but is it just one element of the whole package of work that you're undertaking,
Very much
which
so.
Includes, when we looked at the draft Virgin Islands Land and Marine Estate Policy, you've got, and that policy drafted in 2018, still in draft, but that envisages the need, as you have done, Mr. Smith-Abbott, the need for legislation. It envisages the need for a Crown Land Management Plan. And then you've spoken of updating the policy for management and administration of the marine estate, the 1996 policy. But guideline, I mean, it's obvious that there must be an awful lot of work still to do.
Yes,
So in terms of a timeline of a few months to a year, is that a little ambitious?
It may be. I think that given the legislative process, so let's break this up a little more, because I think that we have to recognize that legislation is not something that we're going to complete in a year. So to that point, yes, legislation takes time to articulate and flesh out. Even if we were to adopt a comparable legislative framework that we can look at, as I made reference to, that process takes time. So,
I mean, the steps you've got to take really are firstly the legislative framework, which is the framework which you'll be working under. And as I understand it, you're looking at other jurisdictions for models, but any model will need to be tailored to this particular jurisdiction, exactly. Which has its own characteristics. But so you need to have the legislative framework, and the guidelines will sit under the legislative framework.
That's correct.
That's where they will sit. So that's the timeline that you're working to.
So if you were to break that up a little further, because I think that when references are made as to what can reasonably be done within the scope of months to a year, we have to first of all define in a very clear way exactly what that framework looks like. In other words, if we are addressing, for instance, applications, disposal, and all aspects of disposal as would have been described through parts of this dialogue that we're having this morning. If we're looking at the role of valuations, if we're looking at public use of lands private use of lands, crown lands in this case, reclamations, etc. It's a very dynamic and complex environment that has to be defined. I think that we've defined, generally speaking, in broad terms, what the high-level policy objectives are, whether it's to enable economic activity, commercial development, home ownership, recreation. There are issues of biodiversity conservation. There are issues of protection of critical infrastructure, because there are going to be some assets that are going to be deployed to protect the shoreline in whatever ways that we define. That is where you have a national development plan, a national physical development plan, to guide how you begin to rationalize the optimal and best use of lands that are fit for purpose. That framework pretty much is already ongoing, and I would have already spoken to that in not only this testimony, but in former testimony. Now, to the specifics of how do you then dispose of that land for the intended purpose. So there may be a decision made that we want to designate an area for biodiversity purposes, for protection of the shoreline, as the case may be, or for residential purposes or commercial activity. That plan, for the most part, what we are going to rely on is the fact that we do have existing registers of the current uses of lands, and we do have some baseline and an understanding of what some lands are intended for. So we're not starting from scratch. There is information within the ministry that can be used for this purpose. Now, how do you then bring all of this together is really the Crown Lands Management Plan. Then you take a step back from that. What actually calls for that Crown Lands Management Plan is an act. What does that act specify? What does it do for us? Is exactly what you would have said, Commissioner. You have to look at the models. You have to look at what's relevant to us, what is fit for purpose. And then you say, okay, these elements are good. These are not relevant to us. We need to introduce, like I would have made reference to, estate committees, advisory committees. We need to bring those into this framework. Those are not necessarily going to feature in some of the legislative frameworks that we may be looking at. So that means that we have to consult with former and current members of advisory committees and estate committees. That process could take a while. And that process, but I could say that we are going to start that dialogue. We're starting that dialogue, obviously.
But I absolutely understand all of those steps, and it seems to me that those are the steps that you propose to take, and those are the steps that you will need to take. But in terms of the guidelines will sit under all of that.
Correct.
And I mean, logically have to be dealt with after all of that is really pretty well in place. And the guidelines themselves are not straightforward. Guidelines to sell, let's say, residential land, guidelines to sell residential land to the highest bidder, relatively speaking, would be straightforward. But here, the guidelines for residential disposals are not straightforward because it's not for understandable reasons, it's not the intention to sell land to the highest bidder, but to sell land to belongers at a price which they can afford. That's putting it very shortly and less sophisticated than it really is. But those guidelines will take some consultation and some thought.
Very much so. And I revert to an earlier statement, which is that land is a valuable and finite asset. So the number of individuals far exceed the lands available. So that means that some due care and consideration has to be given to the whole question of how do you, in a transparent manner, if you are going to publish such guidelines, how do you ensure that there is some transparency and equity and fairness in the disposal of that land? Given the fact that, as you rightly pointed out, it's not as straightforward. It's not, if you're going to sell a plot of land half an acre, $100,000. I outbid you by 10,000, 110,000. I'm going to go with the highest bidder as the seller. Sold. That's not the case here, as you know, because the policy states that government is looking to increase the stake of home ownership, the stake of land ownership. How do you do that? It's not straightforward, as you rightly pointed out.
It's not straightforward. I mean, and that has been a policy that is to allow people of the Virgin Islands to own their own homes, to put it very shortly. That's been a policy for a long while, and it's not straightforward. I mean, I think all we can say really, isn't it, Mr. Smith-Abbott, is that all that is on any view going to take a little while.
Yes.
Because there's a lot of thinking, a lot of consultation to do to bring all of that home.
That is very true. But I think that just to round up my response to that is that there's a recognition that the state committees
have
the advisory committee
have an important part to play in
important
that.
important part to play in terms of opening that process up, even when that committee may not necessarily be in place. There may be some consideration for the reestablishment of that committee on an ad hoc basis, or some reestablishment of or reenactment or revisiting that list that they would have generated for those people who may have not necessarily been awarded lands at the time when so there's some thought, and these things do take time. So the terms of reference, so to speak, for how do we go about defining all of this, yes, within the scope of months, year or so.
Yeah, I mean,
but yes, the actual work is years in the making.
Yes. Thank you.
And I think that the three things that flow from that, though, is that firstly, you may ultimately need to produce more than one set of guidelines.
Inevitably, yes.
Secondly, it is not as simple as mirroring the processes that you have set out in your affidavit in written form.
Yes, the affidavit makes reference to what obtains or what would have obtained when those committees perhaps would have been active. So that's perhaps an example, as Mr. Rizoga would have also made in his brief intervention. Examples of where the committees have informed and provided some layer of transparency in terms of
in practice.
In practice. How do you then bring that into a framework that suggests that this is part of the way that we're going to do business legislatively by law? So therefore, it removes the appearance of any opacity around this.
But Mr. Awad's point is this, I think, that under the current scheme in practice, which you very helpfully set out in your affidavit and described today, there are no guidelines. And so obviously by introducing guidelines, you're not simply replicating in written form what's happening now.
No.
You are creating a modern system.
Exactly.
For the allocation of Crown land in all its various forms.
Exactly.
And it is, the point is it's various forms, because you will have, I mean, I think you use the term ancestral lands, where you have an estate. Let's take it Spooners as the example, or the current Anegada Advisory Land Committee. They will have a defined purpose and a defined area of land that they have to consider. You will also have residential land that falls outside the estates, which is Crown land and which the minister will have to consider. And then on top of that, you have the commercial side of things, where Crown land being leased for commercial purposes, which again will call for a different set of guidelines entirely. But that I think what you're talking about, what you've been talking about, is promulgating ultimately guidelines about this is how you can apply and qualify for Crown land. But internally, is the intent also to produce guidelines as to how an application will be processed and considered?
Yes, very much so. And I think that that the short answer to your question is yes. There has to be some determination as to how that application moves from the public sphere into the administrative processes that we are now having to manage, because there will be a cabinet paper that will make recommendations that will take the input of the state committees, advisory committees. It will be acted on because there will be something that will happen in the ministry without necessarily defining what that is, that will prepare that. So that space that you've now carved out has to also be defined. And it will go to the point of how the institutional arrangement, how the governance of Crown lands ought to be conducted from start to finish. And on top of that, you have, in addition to all of the purposes that you've described, there is a legitimate use, which is a public use. So we also then have to look at other ministries to inform schools, health facilities, roads, etc. Those also fall within Crown lands, and that also has to be defined. I mean, we're talking about the disposal of lands because of the residential or commercial purposes, but there is a public good also to be can be considered. And those public goods and services are legitimate, have a legitimate place and expectation, and they have to be met. So it's going to, this is, you pointed out rightly that this is not a process that we can undertake to complete in a year, but at least what we do want to say about this is that the framework for elaborating this ought to be defined within a reasonable period. Within a year, you could define at least what we just described sort of conceptually and to some extent hypothetically right now, but that is the scope of what ought to be done.
And taking it, you say taking it from start to finish, it will be then how applications are processed within the ministry, the basis on which the minister may determine to make a recommendation, and the finish is the basis on which cabinet may then make its decision.
That's correct.
If I can ask you just to turn up page 18, please. Just a quick question, I hope, on in terms of agricultural leases, because you point out there that whilst it's your minister and your ministry that's responsible for dealing with applications to purchase and lease Crown land, where you have agricultural leases, then another ministry, Ministry of Education, Culture, Agriculture and Fisheries, becomes responsible. But I'm right in I'm thinking that they can make the recommendation, but it will still be for your minister to take the matter to cabinet.
That's correct.
Now you say, and this is at paragraph 11.1 on the same page, that that the criteria applied in assessing an application for purchase or lease Crown land are not recorded in written policies and guidance, but you then point to at 11.2 general criteria for residential applications, which include the age of an applicant, family considerations and housing considerations, and whether they can afford to develop. How does the ministry assess whether someone can afford to develop?
So right now, there is no set way in which the ability to carry out the development currently exists.
You just want comfort that if land is sold for a residential development, for a house, that house is going to be built within a reasonable time.
Correct.
And that comfort could, I suspect, come in different ways from different people, but that's the comfort that you're looking for.
Right. So if the land is disposed for the purposes of building a home, does that person have the capital required not only to dispose of that debt, which is the purchase that land, but then of
To
course
build a
erect
house.
the building. Yeah. So there, that I've not seen where that test of the ability to carry out the work has been exists.
And does it come down to, in reality, in practice, to a public officer within the ministry making an assessment and then providing that information to the minister?
If you look at the non-belonger land holding process, that non-belonger would have to provide financial records that would indicate that he or she or they would be in a position to carry out the development as indicated in their plans for holding that license and by extension holding that land. So there's no similar test or requirement when it comes to this particular area.
And in terms of family and housing considerations, what does that refer to?
That refers to whether you are looking at, again, it's part of the policy to facilitate home ownership across various clusters of family types. So whether it's a single parent with a child, or whether you're talking about a family, are you providing that land so that it will facilitate home ownership to someone who may have not necessarily been able to afford otherwise land. So those are some of the considerations by family.
When we're having this discussion, we're talking about consideration within the ministry of a direct application, because
How about that? Well, yeah, it was still obtained to some extent.
well, I mean, that's what I've taken it as, because in terms of considering the application for a state, I mean, I'll rephrase that. If there's an existing land committee, the ministry's role, at least initially, is to act as a conduit to guide applications to the advisory committee to make recommendations.
That's correct.
Where you have a direct application, the ministry will have two roles. If it's Crown land that isn't linked to an estate, then the minister will consider it and make a recommendation. If it is Crown land that is linked to an estate, but there is not an extant committee, the minister will again consider it. But in that instance, what the minister must have regard to must be the criteria that apply to that estate.
Yes.
So, I mean, Spooner, I keep coming back to Spooners because that's the example that Minister Wheatley gave us in May. But Spooners have defined criteria. So presumably, whenever you're dealing with Spooner's estate land, you always have to go back to those criteria.
Yes, that should be the case, yes.
But, and it's the point you make in your affidavit that the criteria that you apply to non-estate land will be informed by how the estate land committees dealt with it.
Yes, in other words, if you're looking at a situation where you have a parcel of land where someone still wants to build a home, it's outside of an estate per se, then broadly speaking, I mean, the parameters are pretty broad in and of themselves. Belongership or of some sort, age, what the familial situation may be. And those are things that are carrying out or have been carried out of the various iterations of estate committees, who would have in their own right looked at these issues themselves. They would have looked at the particular conditions under which that individual, the applicant, would have found themselves, their own knowledge, so to speak, and of those individuals, because they are coming in some part from within the communities that are looking at these applications. So there are several factors that would be taken on board that you can transpose into this other realm of non-estate disposal of Crown lands for residential purposes, for argument's sake.
what you'd go on to say, and this is at 11.3, is you turn to commercial applications and you say the considerations, you set out there the considerations that may be had. And you reference political and policy considerations and economic and social aims that a government may have. So whether how Crown land is disposed of for commercial purposes, it just comes down to it will be dependent upon the policy of the government of the day.
Yes, I mean, you may have examples of a particular sector that you may want to develop, agriculture or otherwise, and you will seek investors, or you may seek individuals who can bring value economically to the territory. So those are high-level policy directives that will then be followed up with the suitable lens to accommodate such an activity.
What happens if you have a change of policy or a change of government?
If you, in what context?
Well, if someone has you have policy A, which, let's say, encourages a particular type of commercial venture, and somebody makes an application to purchase land on that basis, but then the policy changes, or a new government comes in. What happens then?
Well, my understanding, at least nominally, would be that there will be, depending on how vested that entity may be in that parcel of land, say, because it all depends on the level of how vested that individual may be, or if the purpose of that land was intended for one reason, but then it was switched without transformed, changed with a change of administrations. I guess there will be some dialogue with the impacted individuals, the stakeholders, to come to some negotiated resolution as to how that land may be employed, may be used.
But I mean, normally in developments where there's a change in policy, and there are obviously the changes in policy all the time in all sorts of ways, it is that there will come a point whereas it's too late for the change of policy to affect the development, because the development is underway. You know, the land has been sold to the developer and the developer has started to build whatever it is. So there'll come a point where it's too late. But until the points come when it's too late, the policy change can result in a different approach to any particular application.
Yes, very much so.
That's just how politics works.
Yeah, exactly.
Yes.
And in terms of, you've made the point that the general criteria, as you've called them, and you've set out criteria for residential applications and commercial applications, so they're not recorded in written policies or guidance. So these have just emerged as a matter of practice.
Yes, over the years, I would say yes.
And you also say, and this is at your 12.1, Sir Smith-Abbott, that the general criteria have not changed since 2007. But you then go on to say there are 3 things which are now due to be insisted upon going forwards in respect of applications made direct to the ministry for a disposal of Crown land for residential purposes. And you set out the 3 things: the applicant be a first-time homeowner, have a genuine intention to develop the property for residential use, and is able to demonstrate an ability to do so. In terms of those 3 things that you're going to use taking forward, I mean, do you have definitions? For example, do you have a definition of a first-time homeowner?
Well, yes. I mean, that first-time homeowner must not have in his or her possession land elsewhere.
Of any sort, or that could be turned to residential use?
Potentially, yes. I mean, I think that here is where we will have to define, because I just gave you a very quick example, but here's where we have to define what first-time home ownership may be. That person may have commercial land. I don't really frankly know. In this hypothetical environment that we are sort of casually wandering around.
Yes.
Yes, I mean, that person may have land, quote, to develop commercially. They may not have land to develop a home. Does that person get excluded from this program? It's yet to be determined, I think, but yes, but as a matter of principle and policy, yes, we are encouraging first-time home ownership as a principle. However it gets defined and promulgated to the public, then that becomes the subject of what we then need to do.
And it's I suppose that what you've set out there are the policy. What there then needs work to do is the mechanics. So behind the policy, and this is again something we've explored with more than one witness. Ministers will set the policy, and that's what you set out there. The public officers that then have to deal with the technical details, as more than one witness has described it. But it's as I say, defining what a first-time homeowner would be, defining what a reasonable period of time would be. That they having an assessment process to demonstrate an ability to develop the property for residential use, which is something we've talked about. So there is something where there's more work to be done.
Yes.
Can I just ask though one thing about the estate land committees? And I've tried as we've gone through to make this distinction between the direct application to the minister, which would have to then be considered internally, and with the minister taking a recommendation in the process that goes through the estate lands committees. Would you accept that there is benefit in having a land committee that drafts its own criteria because they have local knowledge?
Well, let's look at this. There is, I think, what has emerged with the estate committees is a relatively consistent practice of determining who qualifies for lands. And we've had several iterations, several estate committees. So we're not starting from a blank slate, so to speak. Are there then objective conditions that will govern specific disposals across islands because of historical considerations? I again go back to the whole notion of ancestral lands, because there is a notion that there is not only long-term occupation of that land or use of that land in particular ways. There may be historical precepts that will govern how that land gets disposed. So that also needs to be taken into account. That needs to be closely studied, consulted, and agreed. And then does the estate committee have a right to inform that process? By all means. By all means.
No, that's the answer, isn't it, Mr. Smith-Abbott? That when you're preparing, when these guidelines are being prepared, you will need input from the estates committees, because there will be, in relation to various estates, different islands, different factors that will apply in their case that need to be fed into the guidelines.
Very much so.
I mean, that doesn't necessarily mean that the estates committees should be able to dictate exactly what their criteria are. Doesn't necessarily mean that, but they should at least have an opportunity for input into the criteria that are adopted.
Yes, and what I'm also stating is that input, because right now it's administratively done. So therefore, to the point made earlier, it has to be enshrined in law somewhere.
It needs to be, as it were, written down.
Written down. So you could start by way of policy, you could start by way of practice.
But end up with some written guidelines so that everybody knows transparently and openly
how we're going about doing this.
Exactly.
How we're going about disposing of lands for any particular need. No. We are looking at residential purposes, but there are a number of other legitimate uses
where different guidelines will apply.
Which you have to mediate conflicting uses, where there must be some degree of adjudicating that conflict. in use, the role of cabinet in this whole process, that has to be addressed. How do you get public input and feedback from through the committees, if that's the mechanism we're going to use, the state
into the process,
and how do we then loop that information back to them?
No, I understand.
If we just turn
I'm
page,
sorry. Again, in the hope of being helpful, there is evidence in the bundle of the current sort of dialogue that takes place with respect to the Anegada Land Advisory Committee. So I could give you the reference rather than taking it
Mr.
to
Risso
it.
Gill is reading my mind because I was just going to ask you to turn up
it's
page
very good that
283.
Always steal thunder at every opportunity, Mr. Rizzo Gill.
I think Mr. Risso Gill had in mind, I hope, 283, if you could turn that up a bit, perhaps just illustrative of the kind of complexity. Page 283 in the same bundle.
And 620 and 621, which is a product of the Anegada Advisory Land Committee as well.
Thank you very much. And just before we go to this, not stopping us going to this, I said that how long do you think you'll be?
I
with
was
Mrs.
going to
Smith-Abbott
suggest we have a
altogether?
short break for the stenographer, and then I'll try and finish Mr. Smith-Abbott within sort of 20 minutes after that.
Do you want to deal with this first?
Yes, please. I mean, I think the reason I was going to highlight it, Mrs. Abbott, because it is I think it's a record of a meeting of the committee, but the first question they ask is, who is an Anegadian? And that sort of perhaps illustrates the first thing is the potential complexity of the questions that have to be asked. But secondly, also that they may be specific to different islands, for example, because you make the point in your affidavit that Anegada has a particular significance in the BVI and has its own separate history. And so different questions will arise in different contexts.
Right. So therefore, do you impose a model that may have been suitable or reasonable for other islands, say Anegada? So Anegada has a particular set of conditions that govern long history that governs the adjudication of lands, which have not been settled, which is still the ongoing work in tandem with the committee.
Yes.
So that has to be worked on and will be worked on. Will be worked on in dialogue with the committee to the extent to which subdivisions that are currently taking place will be guided by the input of the committee for either residential or commercial purposes. So they are having a dialogue internally by those recommendations.
Thank you. Commissioner, I suggest a short break for the stenographer, and then we'll try and finish Mr. Smith-Abbott as quickly as we can.
We'll have a 5-minute break, Mr. Smith-Abbott, and then come back and complete your evidence. Thank you very much. I think we're ready to resume. Just before Mr. Rowett asks his next question, could I just ask one question? Because you'll be able to help me. You don't need to look at it, but on the Anegada Advisory Land Committee minutes, there are a list of people who want deeds and so on, and some of them have in brackets afterwards ancestral, and you've referred to ancestral claims to land. Could you just help me in a couple of sentences about what that means?
So there was a network of walls, which were very much well understood to have individuals vested in the use of that land for whatever purpose. So that network of walls, there's sufficient information and memory as to who those individuals would be.
Yes. So these are effectively plots of land, but marked by walls.
Yes.
There is, as it were, historical knowledge, information about who owns these particular plots of land. Is this simply in Anegada, or is this on other islands too?
This is unique to Anegada.
That's very helpful. Thank you very much. Yes, Ms. Rowett.
Thank you. If I take you to 27, please, Mr. Smith-Abbott, and just your paragraph 15.3. We've been discussing the general criteria, and you say, I'm not aware of any differences in the general criteria depending on whether the land to be leased or purchased is to be used for residential or commercial purposes. Just wanted.
I'm sorry, which?
Sorry, your paragraph 15.3 on page
15.
27 of your affidavit. You say essentially no differences in the general criteria, but just to clarify that a little, if we go back to 11.2 and 11.3 on page 18.
11.3.
Yeah, so there you set out general criteria for residential and general criteria for commercial. There are obviously differences between the two. Were you intending at 15.3 to refer to whether something is purchased or leased?
So effectively, the process, the application process, if you want to think about the manner in which the ministry begins to act on a request for the use of that land, that doesn't by process differ that much. It's generally by letter. In the case of estate committees, you will have an application process, but someone would instigate that by simply writing to the ministry, suggesting that they want to have, make use of the land in whatever purpose, manner that they describe, and then that will begin the actions within the ministry. And there are no distinctions between residential, commercial purposes for the purposes of beginning the action at the level of the ministry.
If we jump forward to page, just look at page 19 briefly. You say at 13.4 at the top, we're currently preparing guidance for a distribution in respect of the Copper Mine Estate subdivision. What stage has that guidance preparation reached?
So we are making use of the existing templates of estate committees. We are introducing the basic principle of financial capacity. In other words, the ability to do or carry out the works, the residential project, so to speak, build your home within a reasonable period of time. There is work already in terms of a subdivision plan, which already pretty much determines that there are X number of parcels available, and effectively what we must then carry this to carry this process forward, at least begin to take into consideration, given the number of applicants, what is a reasonable way to at least not only register interest, but then dispose of that land. So although there's a notion that it will take time to develop a framework, it has to be balanced against the reality that there are disposals that are likely to take place. And in terms of defining at least some parameters that are reasonable within the scope of what has been done in the past, and again, the introduction of financial capacity, the introduction of a reasonable time frame for the implementation of works, that has to, those two elements or determinants, the criteria, has to be introduced into the terms of reference, so that at least in this particular disposal of land, we begin to exercise some of what we've gone through.
But have you actually got draft guidance available?
It's still in progress, but again, we are going to use the existing terms of reference from the estate committees, the ones that obviously we would have disclosed in the bundle, and modify those. So there is at least a baseline from which we can then proceed to define these other parameters in a very practical sense.
The one you referenced in that paragraph is the Virgin Gorda Lands Advisory Committee, which was exactly a draft one from 2019.
Correct.
So that's although it's still a draft, that's the most recent version of a set of references.
And we will build on that one.
Can I turn just to?
So I think maybe the Anagada one is more recent. 2021 is more recent, but in any event.
That's true.
I'm sorry, would you state that again? Half of your statement only got to me.
The Anagada terms of reference are more recent. I think they're dated 2020.
That's right. Yep, it's paragraph 1439. In terms of valuation reports, which we've touched on, you make the point in your affidavit that they are now a standing requirement for residential applications since February 2021. Does that mean that an application doesn't go forward if you don't have a valuation report?
That is correct. That is, in other words, what the ministry intends to do is to ensure that the valuation reports form a part of the cabinet paper as it proceeds on for determination.
And what you say is that
which bullet are you looking at?
We're now at page 27. If we look at 17.1 is where you discuss this. If I draw your attention to 17.3, the current policy view is that even if the government of the Virgin Islands wishes to maintain support to BVI Islanders and belongers in this way, and that's the way you're referring to is takes us back to 17.2, where it says, government policy has consistently been to make land available at deliberately low prices to BVI Islanders and belongers for residential purposes. But you say that the change, and it's going back to 17.3, is that it is right that the cost of that policy, in terms of the difference between the value of the land on the open market and the price at which it is disposed of, should be recognised. So what is meant by recognised?
So let's take a step back and use a hypothetical example. In the open market plot, a parcel X may realize $50,000, say, but the purchase price of that parcel may be at $30,000. So the difference of $20,000 is the cost of this policy, excluding the administration costs, which can be calculated if we really wanted to get that far into it. But excluding the administration costs, the equity position, in other words, government has given that applicant $20,000 worth of equity. And that difference is the cost of the policy. So that valuation report will give you exactly the basis for asserting that the cost of implementation of the policy over time is the addition of any number of disposals.
Whatever it is, yeah.
Including commercial, including any other reasonable use of land that can then be appraised by an expert, by a land appraiser, which is effectively the policy that we're currently implementing. So every parcel now is appraised, and that report forms part of Cabinet's submission. So the aggregate number of reports over any number of disposals for this particular program will be added up and can be disclosed as part of, say, the indicators that are disclosed in our budget, because there is an input of money. So we may have X number of hundreds of thousands of dollars on an annual basis to build roads, build infrastructure to facilitate the homeownership program. So that's an easily quantifiable measure of the cost of the policy.
And it also enables the whoever it is, the Cabinet, I suspect, to take an informed decision as to whether to continue the policy or change it or do whatever it wants to do.
Exactly.
Yes.
It's a way, as you say, of assessing the cost of the policy. What it doesn't mean is that Cabinet will follow the valuation report, because to follow the valuation report will be to go against the policy. No.
In other words, we know that the value of the land is 50,000. The sale value is 30,000, because that is exactly what the program is intended to do, to make homeownership affordable. So therefore, the policy position here is that we are going to discount X amount to improve the equity position of that applicant, so that they can use that equity position to get banking arrangements or whatever the case may be. I'm not going to speculate. But for the purposes of what the ministry has to do, is it has to, under this new environment, it will take the aggregate sum of that favorable equity position given to that applicant. So $20,000 times however many disposals, plus whatever other costs that we may have been minded to budget for. So in this very loose example, we may have allocated $300,000 for roads and whatever else, and we may have disposed of $1 million worth of land, for argument's sake, which means that the cost of that policy, if you would sell that land, that total amount of land for $800,000 is $200,000. So the cost of the implementation of that policy is $500,000, because it's a $200 equity position plus the $200,000 that is a budget allocation.
And I suppose just to maintain the distinction, I mean, this as a policy, the gateways, whether you have Belonging status or BVI Islander status, that's what opens the door to you. If you are a non-belonger, you have to go through a different route. Open market purchasing private land.
So that is not costed. That is not factored anywhere in this.
Yeah, because you don't fall within this program at all.
That's correct.
And commercial, the disposal of Crown land on a commercial basis, whether by lease or sale, is different, because their valuation does matter, and it has been since the 70s.
Correct. The basis of determining, just for clarity's sake, the basis of determining a ground rent or lease value is typically on the unimproved value of that land, plus whatever percentage is applied on that unimproved value to give you that ground rent, or it may be founded on historical precepts of other similar leases that may have been granted. So that is a totally different environment, which is not to be confused with this particular program.
Which has a particular policy objective.
Correct.
And which is a policy objective that has spanned different governments.
Exactly.
Now, just clear this up for me, please. If you look at 17.A, you say that the valuation reports generally required prior to submitting the matter to Cabinet for approval. And you say the same thing at B, where you're speaking of disposal by an exercise of...
Which one are we looking at?
We're looking at page 27, 17.4 at the bottom there, please.
Right.
You've just at A, you say that the valuation reports generally required prior to submitting the matter to Cabinet for approval, and you say the same thing at B when you're saying when you're dealing with disposals as a matter of discretion. In what circumstances would it not be required?
I cannot say right now under what circumstances it will not be required. In other words, my understanding is that in general terms, commercial valuation reports are generally used to determine the value of a lease, say, for instance. And
I mean, I think you've clarified, I think this should have the difference between the uses of valuation reports for resident since February 2021, which is about being able to assess the cost of a particular policy,
right.
Whereas actually when it has a more distinct, more specific use with a commercial situation, because it informs what price government is prepared to let the land go at.
Right.
Well, if I could move you then just to 17.19, which is at page 29, please. Now, you take us here to the new Anagada Advisory Land Committee terms of reference, and you say that they include recommendations as to conditions which should be imposed, and these are conditions as to how long someone should hold the land before they can part with it. At 1720, you say this was a deliberate initiative taken late last year to protect Anagada from abuse of the process. In particular, it was designed to prevent flipping, where a belonger obtains land at a heavily discounted price and makes a windfall profit on an onward sale. How common is flipping?
I cannot speak to how common it is. I know that in dialogue with the current committee, this is something that really is a concern because it goes to the core of whether, for instance, Anagadians locals will be able to afford land in the future at reasonable rates. So there is some consideration really being given as to how do you begin to address any flipping, as you called it.
You called it as well.
I called it flipping, yes. So yes, but yes, flipping in that you effectively look at holding that land for 7 years, and then you would have received that land at exceedingly beneficial rate, in keeping with the fact that you had sought the land based on ancestral claims, and therefore you would want to retain that land in local ownership for as long as you may.
Can I clarify? Help me with this, please, because and we can move it out of Anagada, but the policy has the benefit that it makes land affordable to belongers. And so, as you say, you have somebody can purchase land at a beneficial rate. Once they get it, they usually get it as a freehold. So when they do sell on that land, are they restricted as to who they can sell it to? I mean, can they sell it to a non-belonger who has the who obtains the right license, or must they always sell it to a belonger?
Well, what I do know is that government has a first right of refusal, and that is typically built into the transfer documents. So at first instance, do you then have the ability, government will have the ability to reacquire that parcel for redistribution. That's obviously one way of looking at it, and it transcends. This is now across all islands. This is not just any singular place. Again, I go back to the point of the equity position that you are favorably given by granting under the program lands in question, right? Which were former crown lands now being held in freehold. So the transfer document will specify the fact that, say, you are to give consideration to government so that the program can then continue if you don't want to retain it. Is it a practice then that you may want to foster that equity position then benefits, which was a public good, may I add. It was a public good. It was public lands. Then who should effectively benefit from that position at the end? And that is something that is being looked at right now.
And is that part of the overall sort of, let's call it a policy review that we discussed with you earlier, where the Crown Land Management Plan will have to develop? And so part of that will need to consider, I suppose, how government can best take the land back or exercise its right of first refusal.
Correct.
Which could mean, I mean, if government is purchasing it off someone who, do they have to pay market price, or can they get it discounted for the benefit?
Well, right now there's no guidance around that. There's no guidance around the conditions for resale. So that would.
There may be some assistance on page 30 at 6 at the top of that page.
Well, that is so the statement here is to increase the number of years to 7, given landowners crown land before land can be sold, and in the event that it should happen, the government of the Virgin Islands has preference or right of refusal in purchasing the crown land, undeveloped land, back from the land recipients for redistribution to other applicants who did not receive crown land before at the same cost between landowner and the government of the Virgin Islands. And this is one of the elements of what the Lands Committee on Anegada is contemplating very seriously.
So I mean, to put it at its broadest, the possibility of flipping is very much in your mind, the ministry's mind, and as part of the review you're conducting, I know it's an inelegant term, but you will be considering anti-flipping measures. You'll be considering measures to prevent a purchaser of Crown land from simply selling on at possibly a very large profit. I mean, those measures, it seems to me, could take a number of forms, either simply a number of years or a requirement to give government first refusal on any sale on some terms, or both. But I mean, there are a number of ways it could be done. Is that, and this, I think, these paragraphs 5 and 6 in paragraph 17.19 are the recommendations from the Anegada Advisory Land Committee as to what they would like to see in respect of Anegada.
Right. So I want to make sure that it's clear that the recommendation is not coming necessarily solely from the ministry. So the committee itself is being is thinking about about these issues.
No, I understand that. But,
right.
but the ministry is thinking about it in the context of
the context of a much broader issue, because of course we are not just disposing lands on Anegada.
Yes. No, I understand that.
One small correction. So it's 17.19. Those are the ministry's terms. There is reference below that at 17.21 without citing them to what the Anegada Advisory Land Committee came back with in response to that. And that was the reference to pages 620 and following, which I gave you earlier.
Which is 221 years.
So there was a slight difference between them, but not much.
So 1719 are
That's the ministry.
The approved.
Yes.
Approved version. Yes,
That's
thank you.
right, sir.
Yeah.
So 1719 is the ministry's
That's the ministry,
proposal,
including 5 and 6. The 6 deals with the members of the family and so on.
which we find, Commissioner, at page, that's at page 611 and 612 in the bundle.
Exactly.
And then the ministry, the Lands Committee came back with,
Slightly different.
this is at 1721, that rather than the periods being 7 years, they should be increased to 21 years.
Yes, and they removed the provision restricting sale beyond a member of the family or household.
So, so it was a different way of doing it.
Different way of doing it. Yes.
No, that's very helpful. Thank you.
If I just take you, please, to page 31 on the bottom there. Mr. Smith-Abbott, you were asked to deal with a selection of sample disposals just to see how the process worked and to explain it. And you set out in the remainder of your affidavit a summary of, in respect of those transactions. But just so that we're clear, I mean, these are not transactions you have direct involvement in, because they would have occurred before you took up your post as permanent secretary.
That is correct.
And so were you just dependent on the research that was undertaken by your team, identifying the relevant papers and putting a chronology together?
That is correct.
Now, at various instances, and we can see an example of that if you look at 2311 on the next page. And there are other instances of this where you use the word "I understand." So you say in summary, "I understand the position in respect of this disposal to be as follows." Where you say that, is your understanding based on your reading of the papers and information you've received from public officers working to you?
That is correct.
And you also say, "I believe," for example, at 2312 on page 34.
That is correct. Yeah.
Again, that comes just from your reading of the papers that
That is correct.
Now, there have been instances, and for one example, we see at 35, where we asked you to look at a transaction that involved the BVI Electricity Corporation, and you say that you regret your officers have not yet been able to locate and gather the paperwork for this transaction. Now, I think that there was another one which is
Yes, at the end.
Lunder Bay.
Correct.
Which again is at the very last paragraph of the affidavit.
That's correct.
And can we take it that those searches have not borne fruit and no papers can be located for those?
Yeah, unfortunately, I cannot. We cannot locate those files.
You have explained in your affidavit, I should put on the record, that the circumstances in which files are, certainly historical files are held. Obviously, that material was lost because of the hurricanes, and then subsequent to that, the system by which you stored material has changed, hasn't it?
That's
and that's affected the officer's ability to retrieve material.
That is correct, yes.
Can I deal with one final matter, and I hope I can deal with it shortly. As Permanent Secretary to the Ministry of Natural Resources, Labour and Immigration, you were sent a warning letter which dealt with various circumstances arising out of Crown land. You were invited, and as you know, we've done this with you before, to submit a written response. Some of the issues raised in that warning letter with Canvas today, especially the availability of written criteria or policies or guidance. But is it right that, firstly, you haven't submitted a written response as Permanent Secretary, but you adopt the response that's been provided on behalf of Honourable Wheatley?
That's correct.
Thank you. Commissioner, I've reached the end of my questions. Can I conclude by thanking Mr. Smith-Abbott for coming today, for the time that he's given the Commission, but also very much for the way in which he has given his evidence. Thank you, sir.
Could I just ask one last question? And again, I'm afraid it's a test question, and if you don't know the answer, we'll find out the answer from somewhere else. Throughout your affidavit, but particularly when discussing Anna Gardner evaluation reports, you refer to, I mean, this concerns the policy that we've been discussing, that the government policy has consistently been to make land available at deliberately low prices to BVI islanders and belongers. Could you explain to me, I've got an idea about this, but it would be helpful if you could explain to me the difference between BVI islanders and belongers as you understand it. As I say, if you don't know, it's not intended to be a sort of examination, and we will find out, because there must be a legal basis for this. I've found a legal basis, but I just wanted you may be able to confirm what the difference is.
In a practical sense, with respect to all that we've discussed, there is no functional difference. A belonger is entitled to any and all of what we've just discussed.
Quite.
So a BVI lander typically derives citizenship by descent.
Exactly. No,
by descent.
No, I think that's how I
understand. And birth of either of their parents.
Yes.
And a belonger may not necessarily have that.
Because a belonger may be belonger by certification or
correct, which we would have addressed in the other affidavit.
And this is maybe something, if Mr. Rousseau-Gill knows the relevant provisions, that he'll be able to respond to. If you can't, as I understand it, BVI islanders are a subset of belongers. So if you're a BVI islander, you've got to be a belonger. But if you're a belonger, you don't have to be a BVI islander.
Right. So BVI islander, so belonger is, yes, I guess, a much larger group.
But and BVI islanders fit within that group. So if you're a BVI islander, you're definitely a belonger.
Yes. You're definitely a belonger. Yes. If you're a BVI islander, you're automatically a belonger.
Exactly.
If it would be helpful, I suppose we could go to 61 of the bundle and quickly look through them with Mr. Smith-Abbott, if that would be of assistance, sir. It's at 61 of the first volume of the bundle.
No, I don't think it is, because I think
we know where we are.
I think we know where. If Mr. Smith-Abbott had answered in a different way, that may have removed the foundation of my understanding. But
very well, sir.
I've got it. Thanks, Mr. Soka. Can I just say thank you very much, Mr. Smith-Abbott, for your evidence. Some of these. The explanation of some of these things is not straightforward, and you've made your evidence, both in writing and this morning, has been very clear and very helpful in understanding the system. Thank you very much.
Thank you, sir.
Now, we've asked the Minister to come at 2:30, sir.
Oh, fine.
So, so we'll resume at that point.
Good. Thank you very much. We'll resume at 2:30. Thank you. Good. Are we ready?
Good afternoon,
Good afternoon,
Commissioner.
Minister. Are we ready to proceed?
We are.
Good. Thank you very much, Mr. Rowett.
Commissioner, our next witness is the Honourable Vincent Wheatley. Just for the record, if I could confirm that Mr. Edward Rizzo-Gill for this session continues to represent the Attorney General and the elected ministers. Honourable Wheatley, thank you very much for coming back to give further evidence to the Commissioner. You will by now be familiar with the hearing process.
Very.
And so the only thing I need to do, I hope, is to remind you just to keep your voice up for the stenographer. The topic today is one that we've actually canvassed with you before, and that is Crown Land. I think you'll remember, if we can go back that far, that in May, when you and your then Permanent Secretary, Dr. Potter, came to give evidence to the Commissioner, it was on that topic.
Yes, I recall.
I will also need to just ask you some questions about belongership, which follow on from evidence that the Honourable Premier gave recently. Okay. Now, since May, the Commissioner has received more disclosure on the topic of Crown lands. He also has an affidavit which your current Permanent Secretary, Mr. Joseph Smith-Abbott, made on your behalf. Have you had an opportunity to read that affidavit?
Absolutely.
Thank you. Now, you were sent, as Minister of Natural Resources, Labour and Immigration, a warning letter, which is dated the 21st of September. If you don't have a copy, you should see a copy on the desk with you. You will appreciate the nature of this warning letter, which, as I've explained to you and to others, is it intended to notify you of potential criticisms. They are not the view, they do not represent provisional or concluded views of the Commissioner, but they are there to, for fairness to you, to give you notice of matters that you may wish to put in a response to. You did, in fact, put in a written response. If we could just take a quick look at that, please.
This one.
So if you should have something which is headed Appendix A, response of the Honourable Minister. You have that. And it has with it a small bundle of documents. Can you confirm, please, that that carries your name, your signature, and the date, the 29th of September 2021? It's on the penultimate page.
It's not there.
If we go back to the front, Honourable Wheatley, you'll see that it is headed. Okay. Have you got it?
Page 9.
Thank you.
Yes, that is my signature.
And your date, it's dated the 29th September 2021, is that right?
That's correct.
And can you confirm that you are content for this written response and the accompanying documents to form part of the evidence before the Commissioner?
I am content.
I should also add to what Mr. Rowett said, Minister, that this morning we heard evidence from your Permanent Secretary on the system, and I mean, it was very helpful in explaining with his affidavit how the system works and the guidance that there may be, the policies that there may be, so we may not have to go over much, if any, of that. That I think now is very clear to us. Thank you.
That's good to know.
What followed from your submission of your written response, Honourable Wheatley, is that the Commission wrote to the Attorney General raising a number of additional questions and queries, and you then submitted a further response, which you should have that on the desk in front of you as well. It is headed response to the Honourable V. Wheatley to email. If you go please to page 6, which is the very last page. And Can you confirm that carries your signature and the date, the 7th of October 2021?
Not on that page. Your page 6 doesn't have any signature on it.
I think you might be looking at the bundle that accompanies it. There should be a separate, short, smaller document. If you go to the front of the bundle you're looking at.
Yeah, on page 6, there's no signature on this paper.
I see. Oh, I think they've been combined. So do you have a document which is headed response to the Honourable V. Wheatley to email?
Yeah.
If you go through that,
Page 6.
page 6.
Yes, so my name is there, but there's no signature.
I see.
Dated October 8th.
7th of October. The version we have is signed on the 7th of October.
Yeah, this one says 8th, but there's no signature on it. So I'm not sure.
It may have been submitted afterwards on your behalf.
Can I make sure that they're the same documents? The document I have is signed by you, Minister, dated the 7th of October.
One I have says 8th and is unsigned on page 6.
Can we just check that they're the same documents? If we're speaking from different documents, that's not going to help.
Just shapes and yeah, it'll be marked with
Use this. Thank you. We'll just make sure you have exactly the same document, which it sounds as though that in substance is the same in substance. But this will be your signed document.
I think it appears that probably an electronic version was submitted with a different date, unsigned. But if you're content, Honourable Wheatley, we would want, it's preferable to use the signed version. Whilst that is being sorted out, can you just confirm that you have the accompanying bundle to this has an index to it, which has, again, it's got the heading and then index to bundle. Do you have that?
I believe so.
Right. And that should have 48 pages to it, with the very last page being an email with the heading financial implications, legal implications. And that's from your former permanent secretary.
Yes.
So we've got, at least we've got the right bundle.
But we have the right one. Okay, let's try this again. Yes, on page 6, that is my signature, dated 7th October 2021.
And are you content that that should also stand as part of your evidence before the commissioner?
As far as memory serves me, yes.
Well, it's important that it be
Yes.
your evidence, Honourable Wheatley. So,
It is my evidence, yes.
but you're happy.
I'm happy, yes, I'm content.
And that should be without qualification. Are you content?
I'm content.
And that contentment, does that stretch to the accompanying documents?
The accompanying documents?
Yes, which were the ones that we looked at.
We should go through them. We'll see where you take me today.
Well, you've submitted those documents
Yes.
to the commissioner. I
Yes.
just wanted to confirm that you're happy that
Yes, I'm content.
they should be part of the evidence.
They should be part of the evidence.
Thank you. Could you just help me with one thing though? In the first written response,
Mhm.
when you signed your name, you wrote, "I believe that the facts stated in this response are true." In the second, where you were just answering a number of additional queries, you wrote, "The facts and matters set out in this response are true to the best of my recollection, knowledge and belief." Why did you choose to use a different statement of truth second time round?
A lot of the files that we often refer to, we could not find. You never know something when you're going to find afterwards. So just as a safeguard, because we did find a file late, which is why we were late to the submission. So we have to protect ourselves in case we find additional information.
If we turn then to the, there are two aspects of the warning letter. The first is the issue of what might be said to be the availability of guidance and policies on the disposal of Crown land. And also, the second relates to a specific disposal of land. I'd like to take them in those two parts, please. So if we can deal with the first, if you turn up your first written response, please. Do you have your point A?
Huh?
Now, the potential criticism that was raised was that there were no, or there are no, or alternatively inadequate published written policies or guidance that set out the process to be followed by applicants when making an application to purchase or lease Crown land.
That is correct.
And you accept that that is correct. Now, you say though, however, that save for the marine estate policy, and I just wanted to confirm which policy you were referring to. If we pick up, please, your part 3 of the bundle.
Number 3.
It should be a bundle that starts at page 2062, Honourable Wheatley.
Starts with 2000.
So does mine, Minister. So we're together on that.
Okay.
I think I may have slightly different pagination from everybody else.
You've got the right bundle.
Okay.
If you turn up 2093, please.
2093. Yes, that is the marine estate policy, land and marine estate policy.
And is that the policy that you are referring to?
Yes, in this one here.
All right. So you say save for the marine estate policy. So that's the policy you have. Now,
It's a policy, that policy was passed in cabinet, I think in 2019, is the one we work with.
right.
Since taking office, this one was.
That's something I wanted to just ask you a few questions about. So if we go, just to sort of, we can orientate ourselves on dates, if you go to 2110, you'll see that it's there's a section where it summarizes the policy recommendations. And can you see the footnote at the bottom, footnote 7? It says the policy was drafted in 2018. Mm-hmm. When you gave evidence in May 2021, I asked you about this, and at that time, what you were able to tell the Commissioner was that the policy had gone to Cabinet,
mm-hmm. That is correct,
and then gone to the Attorney General's chambers. Am I right to assume that that's for vetting of the policy?
That is correct.
And then you said, and your words were, I quote, it would be. You said it would be, quote, finalised in the next 6 weeks, end quote. So I think you're able to update the Commissioner, say it was approved by Cabinet.
Cabinet, yes.
What stage has it reached now in October 2021?
Oh, that I wouldn't know. I'll have to find out from the technocrats in the office. It will not come back to me.
I see. But if you can do your best just to explain how it works. So it's obviously a policy that predates your arrival in office.
That's correct. We finalize it, take it to Cabinet.
And then it goes to the AG. It doesn't have to go to the House of Assembly.
It depends if it requires any kind of legal changes. If you have to change any laws, it must go to the House of Assembly.
I see.
And I wouldn't know until they send it back to me and say, oh, you have to take this to the House of Assembly to make this change of law.
So once it's been approved in Cabinet, it comes back to the technocrats and they do something with it.
To AG chambers. Attorney General's chambers.
Once it's left the Attorney General's chambers, where does it go?
It comes back to my office to the technocrats.
And what do they do with it?
It depends on what the guidance is from the AG chambers. It just depends on what the guidance is.
Because could the guidance be that there needs to be changes to the document?
Or the law, or some particular law to implement what you're trying to do.
Right. Now, the topic that as I've indicated, is Crown land. If you go through to page 2113, you'll see there that under the heading suboptimal management of Crown lands, it points out that there's no Crown land management plan, and there makes a number of policy options, policy recommendations, if you like. One is enact legislation that requires the Ministry of Natural Resources and Labour to develop and implement a comprehensive Crown lands management plan. And then if we go on to the next page, you'll see that it speaks of developing a database of all Crown lands and publicly managed lands, then identify land parcels where revenues are due to be collected, and then lastly, undertake an audit in relation to the enforcement of penalties and collection of that.
My understanding is it is being worked on. The policy had two parts, the marine estate administrative part and the land management part. The marine side has been finished because as a territory, there's more water than land. So we gave that marine part a priority. We are now currently working on the land side of it, the land part of it. So it is a work in trend.
But in terms of what is being done, specifically in relation to Crown land, can you assist the Commissioner at all with what stage that has reached?
I wouldn't know exactly where it is. I'll have to find out from the technocrats where exactly that process is. There have been several discussions about it, because one of the things that as a new government, we strongly believe in is empowerment for people through land ownership. That's something very dear to us.
I mean, that is a point that is made in Mr. Smith-Abbott's affidavit, because he has, and he's explained this today, the distinction, and tell me if I've misunderstood this, but one can make a distinction between commercial disposal of Crown land for commercial purposes and disposal of Crown land for residential purposes. When you're looking at residential disposals, it is disposals to belongers and BVI islanders at prices that are deliberately kept
reduced there
below market value.
That is correct.
Because of a policy that has been the policy of a number of governments to encourage home ownership.
That is correct.
Whereas when you're dealing with commercial disposals, it's a different thing, and then market price is a factor.
Usually there's the intention, that's usually the case.
Now, if we move on then to back to your response to the warning letter, what you say as B, and this is in response to a potential criticism that there are no published written policies or guidance that set out the process by which the ministry, that's your ministry, yourself as minister, and the cabinet would follow when deciding how to dispose of Crown land and on what terms. And what you say is that the ministry is in the process of producing guidelines to applicants for publication, and has noted the suggestions of the former governor in letters to me and to the ministry dated November and December 2020. We will also consider producing guidelines for the ministry and cabinet. So the starting point, I think, is you accept that they are at present no published written guidelines.
Not I'm aware of. I know when they have the various estates, those committees do have guidelines that they use or criteria in selecting persons. But in terms of having publicly broad guidelines, I'm not aware of any.
Or, I mean, what Mr. Abbott, Smith-Abbott explained is that you have currently one land advisory committee in place.
One active one, yes.
The Anagada Advisory
Yes.
Committee. And he echoed evidence that you gave in May 2021 when you spoke to us about the use of the Spooners estate guidelines.
Yes.
But again, correct me if I'm misunderstood, but the minister yourself may be asked to deal with a direct application for a disposal of Crown land. So that can come into your ministry, and it can come in two ways. Someone can identify a piece of Crown land that's outside one of the estates and apply to you, or where you no longer have an estate and there is a new disposal of estate land. So a parcel of land in Spooner's estate is somebody wants to sell it on or whatever, you'll be involved in that.
The intention when these Crown lands are disposed of, the intention is not for the person to sell it on. The intention is for persons to actually use the land for the intended purpose. In studying this whole issue of lands when I came into the office, a number of strange things were discovered that we have been trying to address long before you came along. We've been addressing some of these issues. They do have to go back to cabinet. If somebody acquires Crown land, because the government retains the right of first refusal. But I think Mr. Abbott would have told you the challenge we found is that persons get property on discounted prices. However, when they intend to dispose of them, they go to market prices. And we had no real defense as to how do you handle that? Because the government will not give you land for $200 and buy it back from you for $80,000 to sell to somebody else for $200 again. So we found this little loophole that persons were able to acquire Crown land, not use the Crown land for the intended purpose, which is usually residential, and then try to sell it on for a huge profit. It is something I did not like, and I still do not like.
And Mr. Smith-Abbott explained that was something that was being considered in the context of this broader review.
Absolutely.
On how to deal with land generally, but in particular Crown land.
Yes, I must say I was quite shocked when I came to the ministry to realize there were really no strong systems in place. That's why immediately we started putting systems in place to strengthen our land distribution and our land management.
Yes.
It's an ongoing thing. It's a lot of work to do. We've done a tremendous amount of work. Apart from these distributions, we also met a number of old outstanding land disputes that we try to address the best we can, but we'll get to that later on. But we want, and even going forward, we want when we do give persons land for home ownership, that they actually build homes on the properties, because within a reasonable time. We have to be reasonable persons. Things are very difficult.
You reference the suggestions of the former governor. Let's look at the letters that he made those suggestions in. If you pick up, I'm hoping it's in the second bundle, the second bundle on that side.
Two.
Yeah, and at page 1299.
1129.
1299, please, Honourable Wheatley. You have it.
I do have it. I remember this letter well.
Right, it's dated the 16th of November 2020. It's in response to a letter of yours of the 11th of November. What the then Governor Augustus Jasper wrote was that, as I'm sure you will agree, it's important that comprehensive guidelines are in place to be used as a benchmark for anyone who's involved in the decision-making process, and would serve as an essential document not only for me, but for my successor, and it would serve as a guideline for the Attorney General's chambers when providing comments or advice on land matters. I assume the Ministry is operating from guidelines that stipulate priority of the allocation process, selection process, and the guidelines by which individuals are recommended to Cabinet for disbursement of Crown land. The other letter to which you refer from Mrs. Jasper is at 1304. There he, this is a letter to Dr. Potter, 18th of December. He says in keeping with our efforts to maintain transparency as it relates to the equitable and fair distribution of Crown land, I'm seeking further clarity on the process. And he speaks about specific tangible criteria used by committees, ministers and district representatives to determine how land is allocated, who's eligible, how lands are apportioned. Then he says what considerations are used when the minister uses discretion, and what are the rights and privileges that are granted, as well as any other associated conditions. He then refers to the use of valuation reports. In whistle-stop tour through those two letters, but what particular suggestions have you noted from those letters?
If I can be honest, with this with that particular governor, Augustus Jasper, he seems to have a real problem with locals owning Crown land. I look at these as deliberate attempts to stop or slow up a process. I had a lot of trouble getting land signatures signed off on. It's always some other thing. You always wanted something else. And these days seem to be just that. You know, you have these land transfers the governor must sign, and they're held up for months upon months. Person are calling me every single day, and every day, how you come to this area, how you came to that area. We had to go through a lot of time going through all these estates, explaining how to correct. There was no general policy. Like I said, I didn't meet a general policy. There were estate policies. I had to go through every single estate.
Can I break that down a little for
Yes,
you?
sir.
And just to ask you, sometimes you speak a little fast.
Yeah, I get excited sometimes because it just took me back to a funny place.
We're talking across each other, but it's important that we hear you. So could I just ask if you speak up a little bit, because your voice does drop.
I'll do that. Yeah.
But just to take you back to the question, you said in your written response that the ministry is in the process of producing guidelines for applicants for publication, and has noted the suggestions of the former governor. All I wanted you to do was point the commissioner to which suggestions had been noted.
The one he pointed out was the criteria, and I explained to the then governor that it depends on where the land allocation is. If it's a Spooners one and the one you like, you go to the Spooners file and the criteria is there. If it's a North Sound, you go to the North Sound file, that is there. If it's a Stevens Estate, you go to the Stevens Estate file. If it was a Nottingham Estate, Nibs Estate, wherever the land or Enegada, you go to that file and the criteria is there. There's no general policy. I found no general policy. That is what we're currently working on.
Mrs. Smith-Abbott helped us with this again this morning. My understanding is that there are criteria for the estates committees. Yes. I think the most recent one is Anagada, which I think was reviewed quite recently. I think at the end of last year. The newest one would be Copper Mine. So right. That's not in process now. Yes, yes. But we've looked at Anagada as well, which is the end of last year, which is in place. I mean, the committee's in place.
Yes.
But so the estates committees have various criteria. You went through this with us helpfully in May. And they're not identical, but they follow a similar pattern, but they have some criteria. But as Mr. Abbott said, and as Mr. Smith-Abbott confirmed this morning, firstly, applications can be made outside the estates system.
That is correct.
And in any event, even with the estates system, the applications will come to you for a recommendation.
I take all recommendations to cabinet for confirmation.
And they'll eventually go to cabinet. But so I understand that the committees have some criteria, but in terms of the exercise of your discretion, the cabinet's direct discretion, there are no criteria. You've confirmed that. Mr. Smith-Abbott's confirmed that. And
besides, sorry, not quite there. No criteria. It's just very general. Like you must be a belonger. You must have land already in those kind of general things.
No, that was my fault. No written criteria.
Right.
I know, because Mr. Smith-Abbott told us that firstly, you've got to be a belonger, else you're in a different system. And there are criteria which he mentioned, which are often or usually taken into account. And he went through those with us. But there are no written guidelines. And he explained that that's part of the current process. So when the former governor asked for it's important that there are comprehensive guidelines in place, that's different from simply the guidelines which apply to each estate, because these are guidelines which under which the discretion is exercised.
Technically, yes. To answer the question, I don't know of any lands that were granted to anyone who went to land registry or anywhere, saw a piece of land and wrote into the ministry and got it. None comes to mind. Nearly, well, maybe one or two. I've seen somewhere person did identify land and say, I would like to purchase that piece of land. But I don't recall any ever been granted. Most of the lands that are granted usually come through an estate or through a committee. I mean, none comes to mind. I'm not saying an alien, but none comes to mind right now. Because I think I can recall every piece of land I gave out since I've been in government.
But I mean, that's helpful to know, because I mean, I'm trying to separate residential from commercial.
Right.
And I think we're talking about residential.
Sorry.
No, that's fine. I just want to make sure we're on the same page. But what Mr. Smith-Abbott explained is that, you know, it is possible. It may not happen very often, but it is possible to make a direct application to a minister.
Oh, absolutely.
And that's where the point goes to, because where you are dealing with a piece of Crown land sought for residential purposes that falls outside the estates, then it appears, you know, the only, you have what Mr. Smith-Abbott called the general criteria. You must be a belonger, but there isn't any standard criteria for those kind of disposals.
Mr. Commissioner, I'm not sure where the concern came from, because no land was given out like that. I don't recall any. The one that the governor had at that time was for Spooner's estate. He had kept them held up for months. I couldn't understand why, asking for document after document after document, when it was very clear what the guidelines were for awarding those lands. The only conclusion I could say, he didn't want to sign them. That's the only conclusion I could come to. He had a problem signing lands for locals, because we came into office campaigning and giving locals land.
I'm sorry, Mr. Rowe, but that's not what these letters say. These letters say they do say that it's important to have, and you must have, comprehensive guidelines about how prioritization is done.
Yeah, and we have worked on that.
So you don't disagree with the thrust of the letters?
Not in this case, no, he's not correct, because those areas had guidelines. If he made a suggestion, I didn't need the government to tell me we need guidelines for lands. I expected to meet guidelines when I came in. There were none. We started working on guidelines right away. But these things, lands are very complex matters to deal with. You don't rush through lands like that. We have limited land mass. You have to be very, very careful when you're going to create subdivisions and dispersing lands. You don't have infinite amounts of lands. It is something we are walking through very, very carefully.
But I understand that. And again, Mr. Smith-Abbott's evidence was very clear on that. And he said that the guidelines are part of a process which will start with overarching frameworks and then go through policies and then end up with guidelines. And in terms of the Crown land management policy, that in the document we've looked at is to be over a 5-year period. And so that's going to take some time. And the guidelines, of course, will fit under the policy. So we are years away from having comprehensive guidelines.
He's speaking as a technocrat. I don't have 5 years in my term. So
no, quite.
What he wants to do in 5 years has to be done sooner.
Quite. But so what has been done, if anything, in relation to writing down the guidelines that are used in the meantime, pending
And that we are doing. That's what we are doing. They are working on it as we speak. Because we've started the subdivision in a Copper Mine. We're starting in the bond next week. Those properties will be coming up very soon. The guidelines must be published. We've got to make sure that the guidelines are well known by everyone seeking to apply for Crown land. We are addressing that issue.
But I think there are potentially, I think there are two issues that arise from Mrs. Smith-Abbott's evidence. The first is that it's not a simple picture.
It is not. Because
there may be historical associations with a particular estate that affect how you can dispose of that land.
Yes, that is true.
There are island-specific issues. So he writes in his affidavit about the distinct history of Anegada.
Yes.
And so it's not a one-size-fits-all approach, which is and again, I'm paraphrasing his evidence, but his evidence is why this process is going to take so long is because the starting point is and explain you have a national physical development plan. You then have the marine estate, land and marine estate policy that you've explained has just gone through. Then the next stage, and we're speaking about Crown land, is the Crown management plan. And that has to factor in not only what you do in Crown land, but what you do in Crown land on Virgin Gorda, what do you do with Crown land on Anegada? Do you need legislation? How do you involve lands committees? What status do you give lands committees? So this was the picture that he got. And so as part of this package, the guidelines will emerge as part of this process. And I appreciate that a politician may have a different timeline in life from a technocrat.
Always.
But would you disagree with Mr. Smith-Abbott that you may not have had an opportunity to listen to his evidence today, but that it is a complicated picture?
Well, absolutely. It is a complicated matter. That's why we can't necessarily rush it, but we can't take forever either. We're not going to wait for a perfect system before we start distributing land.
Well,
and see, the point you made is what I tried to explain to Augustus Jasper. These things are sometimes island or estate specific. This general thing he's looking for doesn't exist. We are now creating it, but it's going to take time.
Yes.
Until we get to that point, we have to use what we have.
And isn't that what approach is being taken with the copper mine estate?
Exactly, the copper mine.
By using what you have.
And we improved upon it. Because I think the PS should have said this morning, one of the things that we want to avoid in studying the land's distribution over the last 30 or 40 years, you will see a number of persons who were given Crown lands who never developed them. 30 years ago, never developed the land. Land is limited. We're trying to avoid a situation where somebody's awarded Crown lands and doesn't develop it, and then maybe at some point in time tries to sell it. So we're going to include a criteria in there where you must demonstrate an ability to develop within a reasonable time. Now you may ask me, well, what does that mean? Demonstrating an ability, the easiest thing to do, just like with the non-belongers, is to show a bank statement. I have the money to build this house tomorrow. But that's not only the way, it's not the only way you can demonstrate an ability. Maybe you have an uncle who's a contractor who will say, I will build you this house at cost. Or a godfather who said, I will pay for the house for you. And some persons in anticipation have already bought materials and have the materials stored either at a shop or in somebody's yard, who can very quickly and easily commence building a home. So it is something we are trying to see how it is going to work. I agree with the criteria should be published. We are going to do that.
in respect of these two letters, and I appreciate you think that they were unreasonable demands by the former governor, but just looking at them dispassionately, what they say is there should be comprehensive guidelines which are transparent, so everybody knows what they are, in respect of the distribution of the disposal of Crown land, and there should be valuation reports in respect of disposals of land. Now, just stopping there, I appreciate you may say that's a counsel of perfection, but from what you said, you agree with that as a proposition. There should be comprehensive guidelines, and there should be valuations.
And the reason being, because we have limited land. So as we always have a lot more applications than property. So all guidelines do really, in this case, is eliminate persons. They don't help them get it. They eliminate persons, because if you have 10 pieces of Crown land and 1,000 applications, you have to eliminate persons. I see those guidelines as eliminate no people.
And only doing that.
They will do more harm than good if you take it too far. Yes, there should be guidelines, there should be transparency. I'm all for that.
But
valuations are useful so you can know what you're giving away.
But there are two sorts of guidelines in the way that you're speaking, Minister. Firstly, there are preconditions. I mean, one obvious one would be belonger. And so if you're not a belonger, you don't get on the pitch. I mean, you're just not within the scheme.
Right, for Crown land disposal like this.
Yes.
Right. That is correct.
I mean, I appreciate there's another scheme for non-belongers, but,
right.
but under what we're talking about. So those are sort of preconditions, I understand that. But what the governor was pressing for is guidelines in the assessment process. So you may have 100 or 1,000 applicants for a limited number of pieces of plots. But what are the criteria which you apply? Not to eliminate people, which are different criteria, but to assess which of who amongst this large, perhaps, group of people should get these plots.
And that's what I was saying. That's the new criteria we are putting in, because I say what I've seen from studying the various files, the intentions were simply to put lands in persons' hands, which I have no problem with. If you continue like that, you soon have a bunch of people with land, undeveloped land. The criteria that we're trying to implement is to capture those persons who are most ready to build, which is where that criteria comes in. There must be an ability to develop within a reasonable time. That there would take out a bunch of persons. Most persons might not be ready to build tomorrow or 5 or 10 years. We will capture them later on, but what about those who are ready to build now?
And do you apply that criterion to estate land as well?
Only Crown lands.
No, but I'm dividing Crown land, residential Crown land, into estate land and non-estate land.
Okay, like private land? Private land, yeah.
No, sorry, I'm confusing you.
Yes.
What my understanding so far is you can take a number of estates. You have Spooners, you can have the Nottingham estate, you can have the Copper Mine estate, and I've collectively with Mr. Smith-Abbott just called that estate land. So where you have the Anagada Advisory Land Committee, they will make recommendations to you.
Right.
Where there is no longer an extant lands committee, you decide on the disposal.
Oh, I understand your question.
Do it by reference to the existing. You go to the Spooners file and you say, what are the criteria? Okay,
no, you're not correct at all. So whenever there's a distribution of land, usually there's a committee put in place. So for the Copper Mine division, subdivision, there will be a lands committee put in place to go through that vetting and to collect the applications and make sure everything is there. There will be a committee put in place then.
All right, I may have.
So for example, when I came to office, there was no Anagada Lands Committee, but I knew I wanted to get Anagada land sorted out. It's a 136-year-old problem. A committee is a vital part of getting that problem sorted out. So I reinstated a new committee. So before any lands are given out, a committee should be and will be put in place.
But what about this? And just explain this scenario to me. Someone who has inherited, or a piece of Spooner's estate land passes through. The only reason I use Spooner's estate, Honourable Wheatley, because you used it all the time in May, so that's why it's stuck in my head. But that piece of land gets to a point where someone decides to sell it, or someone else decides to buy it, but there is no Spooner's estate committee, is there? So
okay.
In that instance, as I understood it, the ministry becomes involved. And when you're looking at a disposal of that piece of land, you apply the previous criteria.
No,
So
you're confusing two separate things. The committees are only involved with the original distribution. They're not involved in any other aspect of that.
Exactly.
They're not involved in any resale.
Yeah.
Now, we do have a concern with that issue you pointed out there, because we don't want persons reselling Crown lands.
Yes, and I understand that, but my question goes to this, is that when you are involved in a resale and the ministry gets involved, and let's say you buy it back and then you decide to sell it again.
Oh, okay.
Right? But are you using the original Lands Committee criteria, or are you going to be adding your new criteria, which is, are you ready to build?
It's a hard question to answer because we have no history of it. We have no instances of it ever happening where the government has bought back land in an estate to resell. I don't know of any single case. So it is something to consider what would happen in that case. But I would guess that in that case, since the land was bought pretty much under covenant, you'll have to use whatever covenant the land was first acquired under.
So you have an ongoing situation where estate land, which was originally disposed of some time ago, is passing out essentially into private hands. Yeah,
I don't have any instances where the Crown ever bought it back to redistribute. If it happened, not in my time, or not in recent history. I don't recall any instance where the Crown bought any land back for the reason I said earlier, because they get the land at discounted prices, which they all look for, but resale is always market. It's always market. Resale, always market. I will not be buying market price land to give to somebody like that.
Understand. So effectively, it passes out of the absolute control of government.
Exactly, which is something we have to try our best not to let happen. It should never go out of that situation. And we're going to address that going forward. May call for amendments to the law, I don't know. But it's something that we are very mindful of, because I do know of cases where the Crown land was eventually sold into private.
I understand. If we just move on through your response, this is at your point C and E, which is in response to the potential criticisms that there are no alternatively inadequate published written policies or guidelines which record the criteria which the ministry, minister and cabinet should take into account when deciding whether to dispose of Crown land. You say that it's right that there are no written or no published written policies or guidance setting out the general criteria.
Sure, general, because again, these lands are area specific. So what will be the point of publishing a general guideline when, if you're going to go to Spooner's, it's a very specific situation. If you're going to buy land in Enagada, it's a specific situation. So there can be no general guidelines at this point in time. I'm not sure what it would say.
As we understand from Ms. Smith-Abbott, the exercise that has begun, which will take some time to come to fruition, will produce guidelines which are not necessarily reflective of the practice at the moment. It's all bets are off.
We'll see what they say.
Exactly. So there may be changes, but you point to the Estate Lands Committee's criteria being a useful guide.
Yes.
And you say that there is policy for the management and administration of the marine estate. Can I ask you just to turn that up in two ways, please? If you could go to part 2 of the part 3 bundle and turn up page 2372.
Sorry, what page?
2372, please, Honourable Wheatley.
Third bundle? Sorry, part 1?
Part 3, I'm hoping.
Oh, sorry,
I think I've got
I'm in the wrong one.
Slightly different numbers from you, but 2372.
2372. Yes.
If you also turn up your warning response came, your written response came with a bundle of documents, and if you turn those up, the first exhibit to those is is also the policy. You see it.
What page are we on? Oh, yes, on 2372, yes, the policy is it?
2372, keep 2372 open. If you look at the first bundle of your written response, the bundle of documents that it came with.
And which number are you on?
And I'm looking at page number 1.
It refers to the Marine Estate policy?
Yes, if you look that up, just open that up to page number 1, because that's it. No, go through, please. That's the actual response. Go through to the, you have the actual exhibits. I think it's that one. It should have page number 1 in the bottom.
Yes.
Right.
Restricted?
Right, yeah, exactly. Now, 2372 is the version that was given to us back in, I think, March 2021. And if you look at the one that you have recently produced, it's, though they're both the 1996 documents, they are in different, the difference between them are relatively small. The one that you've recently produced looks like the sort of thing that might be produced in 1996, whereas the one that we have is a more modern one. It has a handwritten date of May 15th, 1996 on the top of it, whereas the date in the 2372 is all typed. And then
14th May.
There's difference in fonts, really. We haven't been able to spot any substantive difference, but can you account for why there are 2 different versions of this policy?
No, I can't.
Mr. Smith-Abbott said that it has, explained that it has recently been updated. Do you know how recently it was?
Well, the one that we passed in 2019, soon after we came in, if memory serves me right. I'm not sure why you're saying 1996.
I'm saying 1996 because the one that you've produced has the date, May 15th, 1996. And the one that your ministry disclosed back in March also has the date 14th of May, 1996.
I'm not sure. Maybe that was the original document that they were working from.
Right, and well, it's policy for management and administration of the marine estate. Has it been updated during your administration?
As far as I know, yes. Memory serves me right. Yes, in 2019.
It might be helpful if we could get a copy of that update. Okay. If that's possible.
I thought you had a tailor.
Now you point to that as providing criteria to allow.
Very, very broad question.
You have, whichever version you want to use, but can you point the Commissioner to any particular criteria that apply to the use of Crown land?
The document that I use is a much bigger document. The marine estate policy that we have does not only for marine administration.
I mean, the reason I ask is because these are questions that we put not only to in the request for an affidavit to you, which Mr. Smith-Abbott provided, but it doesn't appear, it isn't referenced as a document which gives criteria in Mr. Smith-Abbott's affidavit, nor was it disclosed to us or to the Commission following a request on the 9th of March for disclosure of the criteria. So I wonder just if you, and I can show you that, if you go to 2366.
2366? 2366?
Yes, please. When the Commission asked for disclosure of the criteria that governed disposal of Crown land, we were given 2 documents. One was land distribution in BVI research, which is the correspondence actually that Dr. Potter had with the Governor, where she set out the details. And then the second one is that land and marine estate policy in draft at that time. no mention of this 1996 policy. It's not mentioned in Mr. Smith-Abbott's affidavit. So the question becomes, what's the basis on which you say that it informs disposals of Crown land?
If you go, no, we said it's the only one we had that even mentions Crown land. And if you look on 2386 in the same bundle, yeah, there's some mentions there about it.
So this is who owns the land, the seabed, water, foreshore are vested in the Crown.
And government's role and so forth.
And can be, so this is, and correct me if I'm, what this is about the marine estate. This is about who owns the seabed, isn't it?
The original document that was divided in two. As I said, the first part's passed in cabinet, the second part we are currently working on that deals with the land.
Right, but this is the 1996 document. So I understand on the 2018 document that we looked at, that you've explained is that the marine side of things has been progressed,
right,
and the land side of things is going. But it's just what in this 1996 policy helps us in terms of disposal of Crown land.
The question is the only place where it was actually addressed.
So in the hope of assisting, page 14 of the bundle attached to the 29th of September response may be a place to go for this.
Page 14.
Page 14, tab 1, page 14.
The wrong document. I've got the second half of the document.
It should have handwritten Appendix C at the top and reclamation package, but it deals particularly with the reclamation of the seabed.
We've got that.
And there are criteria to be met, set out there for the reclamation of the seabed.
So this is criteria that has to be met when someone is seeking to reclaim the seabed.
Yeah, yes, but I was saying it was the only place where the question was addressed at this time, which I found, which is highly inadequate, which is why we set out to get to modernize this.
See, so if I just to understand your response, Honourable Wheatley, I mean the reason for pointing the Commissioner to this document is because whilst inadequate, it was the only document that you found that referenced Crown land.
Yes, in a general sense.
And this doesn't directly apply to Crown land because
it's the only reference we have.
No, I understand that.
Hence why we started developing a policy.
Because this only applies to the seabed or reclaiming land. Okay.
That is correct, Commissioner.
Thank you very much.
If we just move through your again your written response, the next criticism is that there is no or no adequate use has been made of valuation reports by the minister cabinet when deciding whether to dispose of Crown land, and if so, for what consideration. And what you point to is you say that valuation reports have been used for disposals for commercial purposes.
It's usually the case.
But not usually for those for residential purposes.
Usually the case.
I think Mr. Smith-Abbott explained that has changed because
yeah, we're now applying it. Yeah.
So, but he's also explained that what purpose those serve. And you then explain that the particular approach to valuation by the State Land Committee.
I would venture to say I do believe, because the intention was then and still is now, the objective was just simply to get land in person's hand. The value of the land was not really considered, for whatever reason, wasn't considered. It wasn't important to the ambition. But when you try to do other things now, you realize you want to know what you're giving somebody, essentially what you want to do.
And said Mr. Smith-Abbott, and I understand it, how much it costs. So as a policy, this
has a cost.
This has a cost, and this is in part how you calculate that cost.
There you go.
And the point is, the fifth sort of potential criticism arises is that applicants for Crown land are sometimes made with the encouragement and or facilitation of a district representative, which will include the minister and elected members of the cabinet. And your response to that is that
Elected members, whether cabinet or not.
yes.
Persons will go to the district rep and say, can you talk to the minister for me? Or could you write a letter or recommendation for me to the ministry requesting Crown land? It does happen.
Is that, you say requesting Crown land, do they also write in support of an application?
Elected persons? Elected persons?
Yes.
I don't think, I think I have this one case where a person wrote on behalf of their constituent and said, could you please consider this person for Crown land? It's reasonable to expect.
Yeah, well,
not really comes to mind, but I'm sure.
But to consider them for a particular piece of Crown land.
Sometimes very general, sometimes it's specific. You may say Crown land in Spooner's estate, or Crown land in Nib's estate, or Crown land in the Bond, or Crown land in Copper Mine. It may, sometimes it's just very blank. Consider me for Crown land anywhere. I simply want to own a piece of property.
And the elected member will say,
I support this.
I support this person who wants to buy a piece of Crown land somewhere.
I think the instances where the representative may not or may give a full response, if it's maybe a specific case, minister, this person house has burned down. Can you consider giving this person some property to build back a house, or whatever the situation is? In that case, they may advocate for their constituent. That is quite common. That is quite common, where somebody may advocate on behalf of the constituent for whatever reason.
What you point out is that an application will go through a process involving 5 different government departments.
The process of awarding Crown lands, yes, it goes through, it's actually more like 6.
Well, can I try and list them, and you can add the 6? I mean, firstly, it goes through your
It
ministry.
comes to my ministry first.
Then it will go to cabinet, AG's chambers,
Correct,
governor's office,
correct,
inland revenue,
correct.
land registry.
You missed one.
I've got 6.
Survey department, survey department.
Right.
They have to make sure the land is properly surveyed and given block and parcel. Without that, you can't do any transfer.
But in terms of the firstly, the governor's office will only be involved after cabinet has made its decision.
That is correct. After cabinet approves the recommendations,
Then the governor has to sign it.
he signs on behalf of the Crown.
Yes.
Not the minister, the governor signs. That's what I was saying. That's what I said earlier. A lot of those things were held up. The governor refused to sign them. A lot of them for a long time. He went through every department. The governor said, I'm not signing these here. And I started asking a million questions. Irrelevant questions, if you ask me. Some of them may be important in terms of bringing more transparency, but they've been through the process. They have been through the process. The governor sits in cabinet. Why are you now holding this process up, asking for these things that you already have?
But in terms of the process, there were no written guidelines. We know. I mean, I know that there were the estate criteria, but in exercising the discretion which is exercised by the minister in terms of recommendation, ultimately by cabinet who approve it, exercising the discretion, no written guidelines. So in that sense, a lack of transparency as to how the process works, because without guidelines, no one knows why A is chosen and B is not chosen.
We have, I understand what you're saying. We have general guidelines written. You said a general one, a belonger. Once you're a belonger, you may be considered based on circumstances. You can add other criteria, like depending on whichever administration. I prefer younger persons to give them a better start in life.
But every minister in the cabinet will have his or her own criteria. Old, young, family, all sorts of people who might be vulnerable. There are lots and lots of potential criteria, but without having written criteria, how does one know how the discretion, which appears to be pretty well unfettered, how is that discretion exercised? How do we know?
Yeah, we're going to fix that. That's concern where we will publish the criteria.
No, I understand that. And as I say, Mr. Smith-Abbott spoke very eloquently as to the stages that need to be gone through to find the criteria guidance, which will be published so that all of the applicants, as well as those dealing with the process, all of the applicants will actually know the criteria, and we'll be able to say, well, I score strongly on these criteria, not on these criteria, and so on. But at the moment, those criteria are missing.
As a general guidelines, yes, but when the committees do have their criteria. When you apply through a committee, and I said in all land distribution, it's very, very rare where committees are set up to make sure that these guidelines are followed. Just like with the Enagara Lands Committee, when you apply there, they go through a checklist of these things. In terms of publishing them out in the public, why would you publish Enagara land criteria in Tautolo? And the Guardians would know what they are, and they're on their website.
I understand that. I understand. I think the point we've reached is that if we take the Anegada Advisory Land Committee, that is or has reached a point where it has its terms of reference and it has its criteria, it's working towards its criteria, which will be, and it's the benefit of local knowledge.
There you go.
So that's number one. Number two, you have copper mine that's going to go along the same route. So, but that is about disposing or resolving, if you like, it's a starting point. You have an area of land that is now going to be disposed to various people involving the local community through a lands committee. But as I understood your criticisms of the former governor, it's that when he was dealing with disposals involving estates where there was no longer a lands committee, and those were coming in, he was asking about what the criteria were, and you were pointing him to, well, it's Spooners, here's the criteria, it's Nottingham, here's the criteria. And he didn't simply accept that those criteria applied.
So because there was no committee?
But where there's, I'm sorry, so I may have banged on about this a bit too much, but where there's no committee, do you still apply the original criteria? Because if you still apply the original criteria, what's the basis on which you can add your own criteria?
We use the same criteria.
So
if memory serves me right, the only land distribution that we really had was in Spooners, because when I got to the ministry and I realized that there was no really clear policy, and before I could do a new distribution, I checked all the old distributions, and I made a startling discovery, particularly in Spooner, but it wasn't only in Spooners, where a number of persons were granted land. Spooner had a big list of applicants, let's say maybe 100 applicants. There were probably 25 parcels of land. So they gave the 25 persons, they were awarded land in Spooner's estate. I discovered a number of those persons did not pay for the land they were awarded. I found the same issue in Virgin Gorda, where a person was awarded land 27 years ago and never paid. I made a public announcement. Land, I'm giving you another month and a half to pay for this land, or else I'm going to take you off the active list and put you on the reserve list and find persons who are already approved by cabinet and put them in their slots. This was not anything new, which is why I couldn't understand why it was held up.
All right, I understand the context, but when you're doing that, if you're applying the original criteria established by the land committee, even if it no longer exists, you can't add your own new criteria.
I didn't.
So in what circumstances can you add criteria as a minister?
I would get under a new subdivision, which is what I'm doing.
So when copper mine comes up,
it'll have
in those circumstances, you, Vincent Wheatley, can add whatever criteria. I mean, if you
that is correct.
Particularly favour the elderly or
That is correct.
young,
Yes.
then you
For
can do
that
it.
subdivision, yes.
Yes, but that will have a lands committee. Who ultimately decides the criteria, the minister or the lands?
Oh, we do it together. We do it together. Just like with any other lands committee, there's a lot of backward and forward, a lot of meetings, because we have some ideas, they have ideas. They have
Who has the ultimate say?
cabinet. At the end of the day, once we all finally agree on a final version, it goes to cabinet for approval on the membership and the terms of reference.
If we move on, one of the things you cite is the memorandum. Sorry, let me just finish this. It's you say that when a recommendation was later made by me in respect to Spooner's estate to fill vacancies of those who'd failed in their applications.
Failed to pay.
Yeah, failed to pay. Merits of those applications were carefully considered before new allocations were proposed to cabinet. And you cite a memo, but again, because it was Spooner's estates, they would have been considered against the Spooner criteria. Is that
exactly.
right?
And approved list. More persons were approved than they were parcels of land. So we went to those who didn't get a chance at first and brought them in.
I see.
And put those who didn't pay back on the waiting list.
If we move on a little swiftly, if I look at your points M to N through to O, please, Honourable Wheatley. You say that in the desirability of making improvements in order to conform better to the principles of the desirability of making improvements in order to conform better to the principles of good governance is recognised. Hence, I have now insisted on a wider use of valuation reports. Now, that's the use in residential transactions. Where you say wider use, why not insist on valuation reports for all?
We usually would use them for only commercial, usually.
Well,
but now we've included residential.
So for residential going forward, it's a standing requirement. You must have a valuation report.
We will require.
And is it a standing requirement? And has it been a standing requirement for commercials disposals that you must have a standing? Valuation report?
I wouldn't say must. There are always exceptions. There are always things that go wrong. But I think it would be expected that there would be one. I'm sure you'll find a case where there wasn't one.
You say that, I mean, yes, there are always exceptions to everything. But should it be the norm that there is a valuation report?
It's very useful. I mean, I would want it for my purposes. But another minister might not see it useful at all. He might say it's a waste of money because it does cost money to do evaluation. It's not free. So somebody might say, because it solves no purpose, really, I'm not going to have it. But for my purposes, I think it's an important tool.
Fortunately, you're the minister. So
I'm the minister, and also I will do it. Yes,
you get.
I will do it.
But I mean, certainly for as long as you're minister.
For my purposes, I will do it now. Yes.
You want a valuation report?
Yes, I would want a valuation
both for residential and for commercial.
Yes.
Before we leave the question of the Spooner's allocation, a quick look at page 361 might help. 361. I'm sorry, sir.
Is that at paragraphs 5 and 6?
Exactly. Just because that should illustrate what was borne in mind, I think, in the distribution that the minister had in mind.
This is the Spooner's estate
yes
distribution.
This is the late one where, as the minister described, there were spaces became available because people hadn't paid up.
Thank you.
I mean, the point is that you are you are using additional criteria to choose people above and beyond what the Spooner's Lands Committee decided.
For the new subdivision, yes.
Well, not just for the new subdivision, but for this Spooner's reallocation.
So those persons were already approved by cabinet, but there was no parcels of land to give them. So they would have gone through the original criteria.
They've gone through the original criteria, and they're on they're on the reserve list.
They're on the reserve list.
Okay, I'm sorry, Mr. Rice, to interrupt. Is this right? That they've, as it were, passed the Spooner criteria to get onto the list. Is that right?
Yes.
So the Spooner criteria, which are common, I think, amongst the estates, very similar in the others. So they'd passed those. So what you ended up with are, let's say, 100 applicants who've passed the Spooner criteria for 25 plots of land.
Yeah.
The question is, how do you choose from the 100 the 25? And in choosing the 25 from the 100, I think it says here in paragraph.
No, I said that's what I meant.
Yes,
right.
But what it says here is that the applicants were streamlined based on the number of dependents, access to land, and their inability to qualify for a loan based on income. So those are criteria outside the Spooner criteria, because they've been satisfied, on which the 25 were selected from the 100.
My understanding is they're all qualified.
No.
Sorry.
No, it's me, Minister. I just need to explain this better. There are criteria, the Spooner criteria, doesn't matter what they are at the moment, but they're common criteria. The 100 people satisfied those criteria, but for only 25 plots. Right. So someone, I mean, ultimately cabinet, had to select from the 100, 25 people. They all satisfied the Spooner criteria, but they had to select the 25 people. How was that done?
I don't know.
Oh, right. I want to hear from you on that. But before I do, in paragraph 5, where it says the applicants were streamlined based on the number of dependents, access to land, and so on, I thought that those were criteria in which the 100 people got reduced to 25. That was the streamline.
I'm not really sure how they chose the 25 out of the 100. That was before my time.
Right. Okay. Okay. Right.
I have done no new subdivision, Mr. Roberts.
No.
It may be helpful to show the minister the date. So this is
if you go to page 360,
21st of February 2020.
So I think what we're not talking across purposes. What we have is we understand that your new subdivision is going to be the copper mine.
Right.
But what you've told us is that you were involved in if you like, a reallocation of parcels of land on Spooner estates, because you were confronted with a situation where people had not developed their land. So you moved them from the approved list to the reserve list. Right. And therefore you had 25 plots of land to reallocate.
Yes, how we made that decision?
And this is what Mr. Rusagil has taken us to, which is how you did it. And this is, so all of those people are already on the list. They've passed the Spooner's test.
Right.
So what the Commissioner's question was about is 5 and 6, do they show the criteria that you applied to select from the reserve list 25 people?
My understanding was that they all qualified, so it didn't matter. Any random number would work there. My understanding is that they all qualified.
They all qualified.
That's my understanding.
They all satisfied the criteria. We absolutely understand that. But nevertheless, there were a number of ways in which the 100 got down to 25, because there are only 20. I mean, you could have taken them the first 25 alphabetically, but you didn't. How did you get the 100 down to the 25?
No, that's what I'm saying. So this way you have a misunderstanding. When I came to the ministry, I met those 25 there. I'm saying some of the 25 didn't pay. So I took them out and put in randomly the other ones from the reserve list.
Randomly? From the reserve list.
I would have consulted with my colleagues to see who they were. So to see from the reserve list, do you know anybody here who meets the criteria for these vacancies? And I don't recall how many it was.
Which criteria did you ask your colleagues to consider them against?
I'm saying there was no need to, because they already qualified to be there. They are already qualified to be in the list. The question you're asking is, how did they choose that 25? I'm saying I don't know. I met I met some persons there. If you're gonna ask me when I removed the ones who were delinquent and how I got in those others in there, I consulted with various persons about who they were. Okay, they all qualified to be there. I don't know how they chose the first 25.
No, understood.
But they all qualified.
You've created 25 spaces.
Right.
And you've got to fill them.
So it didn't matter with whom, they all qualified to be there. All 100 qualified to be there.
All 100 met the Spooner's test.
Right.
So you had 25 places.
Yeah, so I consulted with persons as to
it may be so.
benefit most.
Forgive me for interrupting the Honourable Minister, but it may be so that the Minister could be invited to refresh his memory from paragraphs 5 and 6, because it's.
What page is that?
If you go to page 361, please, Minister.
Yeah. Yes, I was consulted persons on these things. Because some of the persons from that list, I wouldn't know who they were. So I had to depend on other persons' knowledge and so forth. And I would, as soon as the packages were in the ministry, with saying who they were in terms of what their attributes were. And this is a while back.
So you had 25 spaces.
That's not an exact number. It's probably 4 or 5. I don't recall. I'm just saying.
Well, we can. I think we can probably see how many you have, because I think certainly there's a list at 363.
Oh, so for 7.
7.
Okay.
But to fill I mean, if we look at 4, what happened is that. Because obviously you had to revoke the grants. So 4 tells us that Cabinet revoked 14 grants, and now you had recommended 7 new people. So in terms of choosing those 7, did you do that on just taking soundings from because you would have had a long list of people who qualified
from my colleagues and other persons, yes. Representatives have also sent in recommendations.
I see. So you had soundings from
my colleagues,
district reps. You spoke to your cabinet colleagues.
That is correct.
Did you speak to anybody else? Did you?
No.
So essentially elected members in cabinet and outside cabinet were able to make recommendations, and then you just chose.
Took it to cabinet, yeah.
But you took 7 names to cabinet.
Yes, that's correct.
And how did you get from the soundings to the 7 names?
To my colleagues. My colleagues would bring recommendations. I would have told my colleagues, listen, I have some spaces here. Do you know any persons who may benefit from this here based on the circumstances? I don't know these persons, but I have to depend solely on my colleagues to inform me.
To suggest someone. Okay, thank you.
No, it's 10 past 4.
I think it is a convenient time.
Okay.
Thank you.
Minister, you know because you've been here before, but we have to have breaks every now and then for the stenographer. So we'll have a 5-minute break now for him. Thank you. Yes, Mr. Wright.
Thank you, Commissioner. Honourable Wheatley, one last question before we move on to our next topic. Mr. Smith-Abbott spoke to the Commissioner about the progress on the Crown Land Management Plan and how the various policies all sit together. But he does not reference, but you do, the land distribution programme. And you mentioned that as part of your response, which you say that this will be part of the next budget. Could you just, in a sentence or two, just tell the Commissioner what the land distribution programme is, please?
It is the ambition of, I think, every government to ensure that all local persons get land. But again, when I got to the ministry, I was trying to give out Crown lands. I realized apart from not having certain policies in place, there was no program. It is one thing to want to do something, but there must be a mechanism by which you're going to achieve your objective. And we realized that there was no mechanism to deliver Crown lands to persons. Thanks to the Premier, I got some money to cut some roads for access to lands already given to persons. What this program is going to, because it's a funded program, what it's going to do is put in the budget money and a program for how Crown lands, or to make Crown lands available at all times. If you look at the Crown land distribution, it's not a regular thing. It happens periodical, maybe once every 4 years. Or because I'm an advocate for persons owning land, I think Crown land should be made available more regularly. It's only going to happen by having a program that is capable of delivering Crown lands, making sure roads are cut, surveys are done, utilities implemented, block and parcel attached. Only a deliberate program can deliver that. We've created a program for the first time in history, I believe. It's embedded in the budget to ensure that what we're trying to do, publishing the criteria and so forth, because once persons are aware of what they have to do to access Crown land, it's going to happen more frequently because they're going to get prepared to receive the Crown land. There must be a mechanism in place now to make sure it happens regularly.
So there are various policy plans involving land, and the program, I assume, sits under the policy. So exactly. The policy is whatever the policy is.
Exactly. But how do you deliver?
The program is effective. The implementation.
That's what the program. It implements that policy.
Understand. Thank you.
If I can move on.
But I want to add one more thing too, because apart from Crown lands, the policy also look at affordable homes. We have the first project ever on the BVI happening as we speak, to be concluded in a few months' time. That idea of affordable homes is something we're also going to put into the policy. Not every person can afford to buy land and develop the land. If you have a policy where government can get large tracts of land and through share volume can build homes at a reduced rate because of bulk, then they give more persons access to owning their own homes. If you look at the Joes Hill project, that is an example of what we're talking about. I would like to see that there replicated throughout the BVI in a very uniform and elegant manner, that more persons have access to property and homes. That is the objective of what I'm trying to do. It's my only ambition right now, putting homes and lands in our locals' hand. Hopefully this governor would cooperate and sign off on all my land things, not like the last one. Thank you.
Just to turn though to commercial use of Crown land. And again, Mr. Smith-Abbott explained that process. Now, if I ask you just to turn up page 920 in the first bundle, 920.
Fix this one.
You should get to a cabinet memo. Now, what the Commission had asked in the request for affidavit, and which Mr. Smith-Abbott and his team did, was to using a random sample of Crown land disposals, just to set out the process that happened in each. And he's done that. Now, one of those was this one, and we're looking at a cabinet memorandum from 16th of December 2020, which is headed lease of a portion of Crown land for commercial purposes, Zimomi Limited. I'm hoping that this will shortcut matters, Honourable Wheatley, so that I don't have to take you to the actual documents themselves, but I can do if you need to see them. But effectively what happened was on the 4th of December, a company called Zimomi Limited submitted a letter to your ministry requesting to lease a portion of Crown land opposite the Dr. Orlando Smith Hospital, and it was for commercial purposes, and they wanted a 99-year term. That was acknowledged by the ministry. It was mentioned that what was required was a detailed business plan. The ministry then on the 15th of December received the requested business plan, which was headed proposal for a vibrant mixed-use development in Road Town, and it was estimated. It says in the cabinet memo that the estimated cost was a $10 million development. In fact, in the business plan, it gives it as $10 to $15 million. And it had mixed use, as we say, so there was a residential component, retail component, and office component. If we turn over, the ministry made a survey request.
There you go.
And then if you look at the bottom at 8, it was noted that a valuation report was going to be required. Then at 9, that the next steps would be that a lease agreement would be executed. And so it attached the various documents, for example, copies of the land registry for the parcel of land, which was parcel 125 that was being sought, certificates of good standing, certificate of incorporation, memorandum and articles of association. If we just quickly look at some of those documents, if you turn up to 958,
Documents.
do you have it? Yes, that's the certificate of incorporation for the company, and you'll see that it's incorporated as a BVI business company on the 15th day of December 2020. You'll see if you turn to 957, that the certificate of good standing for the company is dated the 16th of December 2020. And you then have, if you go through to 962, the memorandum of association, which, if you go through to 965, is also dated the 15th of December 2020. Now, one of the other matters that had to be resolved, and which the reason for the survey is that there was going to have to be a subdivision of the parcel of land. So I can take you into more detail if you need it, Honourable Wheatley, but I hope that's enough background for you, just to try and, what I'd like your help with is just to understand, how a commercial process works when you're dealing with Crown land. But what we have is that at the time of the paper, December 2020, you have a number of outstanding matters. You have the need for a valuation report, the need for a survey, need for it to be subdivided, and reference to all this is made by the, if we look at 924, by the Attorney General's Chambers, where they say at 18 that it appears, sorry, I'll let you turn the page up. But the Attorney General's Chambers say that this appears premature because it's premised on a subdivision. The rent is to be calculated by reference to a valuation. Now, given that, according, as we understand it from Mr. Abbott, Smith-Abbott, forgive me, is that the process is that the survey and the valuation report ought to be available prior to any recommendation being taken to Cabinet.
I'm not sure is required for the lease, for sure. I'm not sure for the recommendation to cabinet. I could be wrong. I stand to be corrected, but first I know
he's obviously, he and his team have set out the process in detail. But
I'll take his word for it.
but can you help us with effectively with this? Why the rush here?
You see the date on it? Yeah. Middle of the pandemic, we are trying to get the country shut down. We're trying to get economic activity in the country. If you look at the financial implication, it lays it out there. This is somebody trying to put an injection of $10 million in an economy during a very bad time. The worst pandemic in 100 years. We are scrambling, trying to figure out how we're going to get this economy moving. That is the hurry. That was the hurry, to get economic activity in the country.
And how can you get it moving when you, and why take these steps when you still haven't got a survey, you haven't got a valuation report, you haven't got
those things would have to happen before you can get a lease. But at least this gives them permission to go ahead preparing these things. This is a permission to go ahead. This is not a lease. This is cabinet saying, okay, based on what we have here, go ahead. And once we get these things in order, now we can prepare a lease for you to get some activity going in the country. $10 million is a lot of money.
If you go to 925, please.
925?
Yeah. What cabinet is invited to decide and does decide? Sorry, I'll if you go to 981, sorry, that would be a better way to do it.
The cabinet here is laying out all the parameters for what the lease is to look like once everything is in order. So, sorry, what page?
It's better to go to 981 because that gives us the date. So 981 is the 20.
981. And I still can't say if the lease was ever completed.
Well, that was going to be one of the questions, so we might get to that. But 23rd of December 2020 is when Cabinet meets to discuss the paper. And so Cabinet then decides to subdivide the parcel, permission be granted to lease a portion of land with, as you say, conditions, with, for example, the rent to be determined once the valuation survey report is done, that the area to be leased is once the subdivision survey is done, etc., etc. But in this case, what had been asked for was a business plan. And this was from your evidence in May and from Mr. Smith-Abbott's evidence. Business plans are considered by the Premier's office. So do you know whether in this case the business plan would have gone to the Premier's office? It
would only go there if there was a development agreement. I don't think it's a development. I could be wrong, but I don't think it's a development agreement for. I could be wrong. Because that's what the Premier's office.
It's a building on the business plan, which is, and we can find this at 937.
937?
Yeah. This is a part of the business plan. Um, 937 is about proposed cost and source of funds, and so you see that it's going to be funded by private funding and mortgage financing, but none of the banks or personal investors are named. But what's said is that the estimated value of this mixed development will be in the range of 10 to 15 million. A project schedule is that construction will take 5 years, scheduled to commence in 2021, with a time frame of 2 to 5 years to fully build out. So can you help whether would a registered development agreement be needed when you're dealing with something that has a value of 10 to 15 million dollars?
A development agreement?
Yes.
It's not only based on value. It's also normally have a development agreement when the developer is trying to secure his business. So the reason you have a development is when you have certain demands from government. I plan to come into your country and I plan to spend, or whatever I'm here, I plan to spend $50 million. Therefore, I would like hotel aid. I promise I would hire 50 locals. I promise I would donate to whatever. In this case, this person doesn't want anything from government, so there's no need for a development agreement. They're simply investing in the country. So I don't see a need for one, a development agreement.
One of the matters that you spoke about in May was the situation where sometimes you can have a lease granted, financing falls through, development never happens. And that this was something to guard against. Now here you have a situation where Cabinet has decided to grant a lease in circumstances where you don't have a financial statement of any kind. What you do have, if you look at 935,
935?
Sorry, 953, sorry.
We're going to start this here. He has to get us soon.
Which is a letter of December 14th, 2020 from a bank to the principal of this company, expressing an interest in the proposed commercial development, referring to several meetings, further engagements towards developing a comprehensive understanding of your business plan, and where feasible to offer bespoke financing options. So it's not a concrete agreement to finance the business. And the letter, as we've seen, is written on the 14th of December. So it's written, in fact, before the company has even been incorporated, which is done on the following day. When you look at the business plan itself, it doesn't tell you who the personnel of the company are. It does reference people whose names will be known to you. They are now known to me. But doesn't it take us back to that point of isn't this all, as the Attorney General's Chambers raised, premature?
What is premature? The bank tell them they would finance this project?
You Cabinet, you get a letter of an application effectively on the 4th of December. By the 23rd of December, you've granted a lease.
No lease has been granted. Cabinet is saying, you must understand what the Cabinet decision is saying. Cabinet is saying, based on the requirements for a lease, Cabinet must bring these things form the lease. If memory serves me right, I don't think that lease is done yet. And to answer the other question about the land being taken back if not used, that would be in the lease. These are just saying it's okay to go ahead and once you get all the requirements, a lease can now be drawn up.
But it's this permission be granted, that what it says is permission granted to Zimomi Limited to lease.
Yes.
That's Cabinet's decision.
Right. But Cabinet doesn't produce leases. Understood that there are Cabinet set conditions. Those conditions have to be fulfilled, and that will ultimately should be fulfilled.
It's just there are examples of applications that take a much longer process. It's just, can you shed any light on why you go from the 4th of December to the 23rd, appearing to give the green light to a $10 to $15 million development in Road Town?
I'll remind you again, it was the middle of COVID. All the businesses were closed down. Here's the opportunity to bring some employment. Yes, we're going to jump at it. Here's somebody saying, I see all the hotels are closed, the supermarkets are dwindling, there are no yachts, there are no cruise ships. How do we get money in this economy? Through construction. Construction is one way we can get some economic activity in the country.
I understand that point
so I'm not understanding then.
A hypothetical point, but in this, correct me if I'm wrong, but in this proposal, firstly, there were lots of things to do before there was even a lease. And I don't
think there's a lease still because these things must be there.
No, I understand that. So again, why the rush for Cabinet to approve a lease, which hasn't been completed yet? And sorry. And secondly, and then you can answer them all together, or both of them together. There's no requirement that this development happens.
That's covered in the lease. The Cabinet is simply saying, we agree for the ministry to create a lease. The ministry still has to do the lease. The lease cannot be done until all these things are met, the evaluations, the subdivisions. This is a process. So the sooner we could decide that we are willing to do this lease, the sooner they can start their work. It may take them a year to complete the process.
I understand, but until they've got a lease, they aren't able to commence the process. But there's no obligation that they do build.
That would be in the lease.
But here, where it's got the conditions of the lease that the cabinet have set out, where is the obligation to build?
What I would say to that is that what cabinet is saying here, these are the minimum requirements. We can add in, like you've seen, if you look at the one with YEP, if you must build within a certain period or the land reverts back to the Crown.
Exactly. Yeah.
Yeah. That we could put that in the lease. In fact, I would like it. I would make sure it's in the lease when the lease is finally done.
But it's again going back to process. What we've understood is that before the matter goes to cabinet, you need a valuation report. And here you are putting the valuation report in at a later point in time into the process.
For the lease, yes. Like I said, sometimes I'm not sure it's a requirement that it must be first. But I know for the lease, it must have it for the lease to be properly executed, because you will use the lease in most cases to decide how much the rent is going to be.
The valuation report.
So the valuation
yes,
report.
yes.
And the valuation report is not done by the ministry, it's done by an independent contractor.
But again, it's taking us back to Mr. Smith-Abbott's affidavit. I mean, the tenor of that is that, before the matter gets to cabinet, the valuation report should be there. That's how the system that the ministry operates.
Under normal circumstances, I'll take us over for under normal circumstances, I would guess yes. These were not normal circumstances.
Does that mean that during COVID, you've had a policy that you would not have valuation reports until a later stage in the process?
I don't
Did you make an exception in just this case?
That was not a policy decision. What did he say, that the valuation must come to cabinet first?
My understanding of Mr. Smith-Abbott's affidavit is that that the valuation report is obtained before the matter gets to cabinet.
Only for the lease, not for the permission to create the lease.
But that then suggests it goes round twice. So if we take this as an example, you have round one is when it just goes to cabinet without a report. Or cabinet, as we say, permission be granted to lease a portion. The lease then has to be entered into, valuation report, etc. done. It then goes round back to cabinet to sign off.
Well, it's a bit false what I'm doing, so we'll see. But I understand what you're saying. But the valuation reports say that they're used to decide in the lease what the rent is going to be. So you must have the valuation report. It's not required for cabinet to do anything, but it is required to form the lease.
But what does cabinet do with the lease? At the end of this, let's say that there is a lease at the end of this process. Do you sign the lease, or does the Premier sign the lease, or does it go back to cabinet?
I think the Premier signs the lease.
Does it go back to cabinet?
I'm not sure if it has to go back to cabinet. It may go back as an information paper. The lease that you asked for is not ready. Here's the lease. It may send it back to cabinet, but it must have a valuation at that point in time to complete that lease. It's not required before.
See, so your understanding is that there is no requirement that a valuation report be.
I'm saying I'm not sure, but I know for the lease it must have it. So you're the one saying it must go to cabinet first.
Yes. Well, I'm not the one who's saying that.
I'm saying I'm not sure. Because I'm not sure why cabinet would need to see the valuation first. In a time like COVID, when you're trying to get something moving, it is needed for the lease, not for cabinet.
How fast are things? Do you get things moving if you have all of these steps to do?
You have to ask the technocrats. I don't know. I'm not involved in any lease preparation. Once cabinet gives the parameters, I may see the finished product and to look at it and say, okay, well, is there anything we missed?
Because the other feature of it is that well, can you tell me this? Do you know how far the project has gone? I mean, has parcel 125 been subdivided?
I don't know.
And you don't know whether there is in fact a concluded lease or not?
I don't know. I haven't seen one, so I would assume there's none. I'm sure if there's one, I would have seen it. So it's safe to assume that there is no lease.
Is that the sort of thing that should cross your desk, Minister?
Yeah, it should. It should. So I'm saying it's safe to say there is no lease. I'd be very surprised if there was a lease. So it's probably still in process. You know, technocrats, they will take their time, and Cabinet says, or the gentleman or the company would like to build by 2021. He has 2 months, a year is almost done.
Okay, can we turn to another example? And this is if you turn up page 1063, please, which might be in the second bundle. I'm just going to try and take this quite quickly, if I may, please, Honourable Wheatley. But and I'll just try and summarise. But it concerns lease of Crown land at Parakeeta Bay for agricultural purposes, and that's to Daniel Klein Poultry Farm. Essentially, if we look at paragraphs 1 to 2, and I'm very quickly going to summarise. So, in effect, the background information was and this is 14th of October 2020, but there was reference to the importance of food security. Mm-hmm. And then the Ministry of Education, which obviously captures the Department of Agriculture, submits a letter on behalf of Mr. Klein to lease a parcel of land. The background is that he's operating a poultry farm in Cane Garden Bay, which was set up without the required planning permission, and which has led to complaints from residents and visits from the Department of Agriculture. But what is also said is that there is a desire to increase production, which would not be achievable at that location. And so the Department of Agriculture and Fisheries supported a request to relocate the facility to Parakeeta Bay Estate. And what the department did was to identify a parcel of land in Parakeeta Bay Estate, which would be suitable for the relocation of the farm. Mm-hmm. Now, if you go to 10, independent appraisal of the plot was commissioned, which to determine the market rent for agricultural purposes. And the valuation report, that valuation report gave the open market value as $75,000. Now, what that means is that, and it says at 11, that the ground rent was determined to be $43,000 per annum for 25 years with an option to renew for a further 25. Sorry, I'm going to, at 11 and 13, what's cited is examples of other sort of other rents agreed with similar entities. And so in one case, at paragraphs 11 to 13, we see that, sorry, I'm going to start that all over again, because the valuation report for Parakeeta Bay gave a valuation of $75,000, but the decision of Cabinet was not to base the rental figure on the valuation sum, but on 2 previous agricultural disposals in that area. And the first we see at 11 is from 2018. The valuation there was of $43,000 and took account of comparables. I can show you that. But the company then made a counter offer based on its own research, of 200, and I think it was eventually settled at I think 2,400. There was a similar process for another company which led to essentially an annual rental sum of $800. Now, I'm sorry, it's a bit of a whistle-stop tour, but in this case, the rent, if we go on to 16, then refers to ground rents for lands for agricultural purposes on Virgin Gorda, reviewed to be assessed at 1% of the value of the land. And such values should only take account of the use of the land for agricultural activity. And it references a 2001 document. What it also references is the financial secretary raising the fact that it's high time the government review and modernise its leasing policy of Crown properties. And what's also in the papers we see is that there's caution from the financial secretary. And this was in relation to the Infinite Eco Limited against subsidising commercial enterprises. So the point we get to is that Cabinet decides that the rent would be not based on the valuation of 75,000, but would be based taking account of these other businesses, these other and the 1% valuation, and adopt $750 per annum as the rent. In this case, can you help us with this? Why would you not follow, as Cabinet, the valuation report?
I don't.
There may be room for confusion here because if one looks at paragraph 18 of the memo, it's seen that the value of 750 is based on the 75,000, but it's a percentage of that figure.
1%.
That's a
1%.
I'm sorry.
It's 1%.
Exactly, of that. So it's based. It does have its root in the valuation. It isn't based on the valuation report, or the valuation report is ignored, but that a particular percentage of that is taken.
Let's take that. If we look at page 1066, then.
What's 18 is?
So do you see that
18.
18 is taken from 16, which refers to land for agricultural purposes on Virgin Gorda, being assessed at 1%. Now, obviously, Parakeeta Bay, as I understand, is not on Virgin Gorda. But if you go to 1131,
Sorry, what number?
1131, please. This is what it's based on. So you have, although it's stamped at 2001, and it's Virgin Gorda Central, it's an agreement made in 1996 between the governor and an individual. And that's where the 1% comes from. Now, so the question, I can reword it as this. Where you have a valuation of 75,000, why is it justified to take 1%?
I'm not sure. I guess just following what the pattern has been. That's what I would guess.
Well, the pattern, the pattern that seems to be
1%.
Is 1% in Virgin Gorda in 1996. In 2018 and 2019, it's to negotiate, it seems, with, if you look at 11, which is a company called Infinite Eco Limited.
What page are you on?
Page 1065.
What was the question again?
Let me take you through it again. So
Why 1%?
yes,
You're asking?
yeah.
I would guess, I mean, this is an agricultural lease, and I would guess that whatever's in this paper would have been sent to us on agriculture. I'm not the Minister for Agriculture, but because of the Minister for Lands, we did the lease for agriculture.
But you take it, it goes, the paper comes from your,
Based on what they would have sent to us.
right. So take us back to this, go back to 1063.
Mm-hmm.
Just explain to me how that paper is produced, because it's a paper from your ministry.
Because we're the minister, I'm the Ministry for Lands, and agriculture takes place on lands. If they want to give a lease, I know that they're trying to reform our agricultural practices, where persons are given leases to use land as opposed to basically squatting. So agriculture would have written to the ministry and said, we want to give this particular farmer a lease on this particular area of land. Here are the terms to produce the lease for them.
So with the content of this,
my understanding is my ministry would have gotten all information from the agricultural ministry or the agriculture department to produce the paper, because only we can produce a lease.
so you can't help at all with
No, I really
why
can't.
any of this was set at this
I
level?
really can't help. I'll have to refer you to the agriculture department as to what their going rates are for farmlands. I don't think it is set by my ministry. I don't think so.
So your
But
ministry,
I stand to be corrected. I know we produce the leases, but based on instructions from agriculture.
so there's this, in terms of the content of this, background information, what comparables to use, what percentages to use, that all comes from the Department of Agriculture.
It would be my best guess that it comes from agriculture.
I mean, because the reason is you sign off the cabinet memo, but
Is my ministry taking the paper to cabinet?
but you will have no involvement in reviewing that memo.
No, I mean, review it, yes, for cabinet, but in terms of the information there, I wouldn't be producing that.
Oh, I
That's
totally
more
understand.
like it from agriculture.
I'll leave it.
So they have done all that background work and provide to my ministry to produce the lease.
Can I just take you then to the second half of your the written response to the warning letter?
Before we move to another topic, there is one matter which forgive me, it took me a while to find it. On the signatory to leases, there is an example in the bundle on page 683, and it's the governor.
Yes. No, thank you.
It's always the governor that signs on Crown land.
Crown land lease, this is fine. Thank you very much.
Let's go to the second half of your written response. Now, the detail there, Mr. Wheatley, is set out at great length, and it has a certain lengthy history. I don't want to.
What number are you on, sir? R?
Are you in your written response?
Yes.
Right,
What letter?
Give me a moment.
It's paragraph R on page.
Okay, I got it. Page 6. Yes, I'm there.
You're there. So, as you will have appreciated, it's the details are quite lengthy, but and some of the history you were not involved in, because you came into this whilst this was still going on. But to try and summarize, a parcel of land which is not too far from where we are speaking, which is parcel 310. And that was leased by government, or by the governor, I suppose, to an entity called Nature's Way. The lease was never executed.
So it was approved in cabinet, I think is the correct term.
Yeah.
It was approved by cabinet
It was approved by cabinet, but
to produce a lease.
okay, well, we'll take it in stages. So cabinet approved a grant of a lease, but it was never executed because, and one of the reason was that there was no easement to the property.
That is correct.
There was, however, a long-running dispute between Delta Petroleum and the government over its decision to grant that lease. And what happened was that the user of the adjacent lease, 309, granted the governor an easement over 309 to 310. So that got round the problem that there was with Delta, because Delta wouldn't grant an easement over its plot. So Delta owned 221, somebody owned 309, Nature's Way owned 310. Nature.
Well, they were promised it.
Yeah. Well, all right. Yeah, so Delta was on 221. 310 had cabinet to approve a grant of lease to 310 to Nature's Way. 309 had somebody who had also been approved for a lease. Delta wouldn't grant an easement over 221 for the occupier of 310, but ultimately the occupier of 309 did grant an easement, and so that allowed the person to do that. Yeah. Meanwhile, Delta was occupying and using 310.
Occupying, or they used it, or they bought it?
They were occupying that land without permission, weren't they?
Okay.
But do you agree?
Oh, I don't know. I'm not.
Well, it's right, isn't it, that in 2018 they were the recipient of an expulsion order from plot 310? I
found that out in late December, December 17th, I think. December 17th, I found that out.
Yes, December 2020, you found out that there had been an expulsion order.
December 17th, I remember the date very well.
I mean, I can show you the expulsion order.
No, I've since seen it.
Yeah. Now, when you came into office, what then happened was that you negotiated with the person with Nature's Way.
Well, how you jump all the way to the conclusion? A lot of things happened before that.
Because all of the things are not matters that you were engaged with, and that's why I want to kind of focus on what you did.
No, before that, I negotiated, because when I came into, this is a quick little background, because when I came into office in 2019, I was given a list of land problems that very long standing, some 50 years old, some 30 years old, some 20 years old, but long standing problems. And the PA said, if you take a crack at these, because nobody else had managed to get these problems solved. And they were going on and on year after year, up to 50 years. This particular case was one of them. This particular case you're referring to here was one of many cases that they asked me to try and resolve. So I consulted the AG chambers, and the AG said, basically, both parties have a legitimate claim to the property. I should try and negotiate with them. And that's where you start, where under advice of the AG chambers, I called the parties in to explain their side of the story. And Nature's Way came in, she brought her son, probably my first time meeting her. I was aware of what the issue was at that time, and asked her to explain to me what this issue is all about and why do you want the property.
Can I stop you there? I will take you back to it then. So let's start back when you become involved. So you're the new minister, you come in, it's February 2019 or March 2019. You said you were given a list of problems. So was this a written list?
Well, there are files. There are files in the office. It would have been a file.
I see. So were you just handed the files?
Yeah. Because
what you said in your second written response was that you received oral, not written briefings with respect to this disposal of land.
Yes. The PS would bring a file and tell me what's in the file. But there were files.
Right. So the dispute that you had inherited was a dispute between.
There were several of them.
Well, but wasn't it a dispute between Delta Petroleum and the government as to who had a right to that land? No,
it was the issue of who was going to get the land, Delta or Nature's Way. It was an unresolved situation. It's been going on, according to the lady, over 20 years. She had been trying to get this matter resolved.
She had tried for 20 years trying to get access to her land.
This is what she told me, yes. She said over 20 years, she's been trying to get this matter addressed. Of she wanted occupation to that land at Cabinet in 1997, had promised her, had approved for her to go on that land. It was 1997.
But 2007, I think.
Or 2007?
Yes.
Okay, sorry, 2007. She remembered getting a letter saying, we are giving you this land in 2007. So looking at many years later, she's saying, I got this letter, but I'm still not there. So I was asking her, so I asked her son, well, why did you want the land? So she sat and she explained to me very passionately what her dreams and aspirations were as a BVI lander, as an entrepreneur, what she wanted to do. She had a business in a building that she was renting. She said, I don't want to be paying any rent anymore. I want to build my own building, and I want to expand my business to include the marine sector. That was the reason for her wanting that specific waterfront property. She wanted access to the marine sector, and she wanted to be in her own building. So she wanted to build her own building, and she wanted to access, that's why she wanted that particular. And we had several meetings about it. So
right. So you met with the person to whom, I mean, it's Nature's Way.
Yeah.
I mean, I just don't want to use the individual's names. Right. That's all right. But you met with Nature's Way.
There were several meetings actually.
And you understood that person, and it is in 2007, had been granted a lease to parcel 310.
Cabinet approved the lease. She never got one. It was only approved in Cabinet. It was never produced. As I know, it was never produced.
No, it was a Cabinet decision.
Well, it was a Cabinet decision that she be granted a lease.
And her understanding was that she was entitled to access that piece of land.
That's what she said to me.
And what was it that had stopped her accessing that piece of land?
She never got a lease. She never got the lease for the property. Nobody executed the lease.
There were two problems over and above that. Firstly, no access. Initially, there was no access until the right-of-way was granted. And that resolved that. Secondly, Delta Petroleum were in occupation. That was another problem.
Well, I don't know. I know the reason why I was told from the files that the reason why the lease wasn't executed because Delta felt that they had the right of forced refusal to the waterfront property, which is a alongside government's policy. And Delta had threatened this in the affidavit that if they ever grant her a lease, they were going to file a judicial review because they thought that they were the ones entitled to it. And that seems to be the reason why the lease was never executed. Now, whether Delta occupied the land, I don't know. Illegally, I don't know. I found out afterwards that Delta did indeed occupy the land because of the eviction notes. When I brought it to their attention, they did vacate the property.
If you just look at 1168, please. I think we're in bundle 2. Honourable Wheatley, this is the Cabinet memo of 27th of June, which is, as we're slightly jumping ahead, but it's an application to lease parcel 310 by Bevis Sylvester. Mm-hmm. So on the 27th of June 2019, this goes through to Cabinet. And if you look at financial implications, at 11, on page 1168. And this is a paper signed off by yourself, but it says the primary point that's being made by the Finance Ministry is that, or the point that's being made is the need for a business plan. But what's said is, furthermore, the draft paper says nothing about how the persistent and continuing contraventions by Delta Petroleum Caribbean Limited is to be resolved. And that's, I'd suggest, well, firstly, is that it does go to that the point that they were occupying 310 illegally. And by then, I appreciate you say, you know, that you only learnt of the expulsion order after the event, but that expulsion order was made by the governor in January 2019. You can see that at 1218.
Yeah, I wasn't aware of it. I'm not sure why a copy wasn't sent to my ministry, or maybe it was sent to the ministry, but I wasn't aware of any expulsion notice. There's one comment there.
I mean, you say that you weren't aware of the expulsion notice, but what led up to it is that let's take you to 1214.
What was the purpose of the notice?
I'm sorry.
Where was an expulsion notice?
Well, let me take you through it.
What page number?
I'm sorry?
What page number?
If you go to start off with 1213. This is from your, well, it's before you come into office. So 17th of May, 2018. And it's from, I think, the permanent secretary that you had when you first arrived in office, Mr. Smith-Abbott. And he's writing to Miss Barry in the Attorney General's chambers, and asks her, having met with the principal of Nature's Way, that, and you see that at the end, that what's written is that Assistant Secretary Penn will commence the process which will lead ultimately to the execution of a lease between the principal of Nature's Way and the Crown. Whilst that is in progress, we ask if you can write to Delta Gas Station via their attorney asking them to cease use of the said parcel of land. So that's parcel 310. If you turn over to the next page,
That's very interesting.
you have a letter from the AG's chambers, read parcel 310, essentially telling Delta Petroleum to vacate, cease and desist utilising the property for either storing chattels or docking marine vessels. If Delta should fail to adhere to our demand herein, government will be forced to take such further action as is deemed expedient without any further reference or notice to Delta. And that's from Miss Barry, Principal Crown Counsel. What then happens is that on the 11th of July, this is 12:15, Delta write back to seek an extension of time and says, as you may be aware, our client owns adjoining property, that's parcel 221, which they currently use for various purposes. They've been unable to fully comply with the request, and they are minded to extend the compliance time to 15th of August 2018. Then if we go through to 12:17, on the 1st of October 2018, Miss Barry, for the Attorney General's chambers, writes to Delta Petroleum's lawyers and say, instructed to demand that Delta ceases use of the property no later than 1st of December 2018. And what she writes is that, had an opportunity to take full instructions on the matter, now able to advise that government's not in a position to discuss a lease of the subject parcel, which is something that Delta had raised in their letter. In fact, a decision to lease the said parcels to other persons was taken by Cabinet in 2007, but never actually finalised for various reasons. Steps have continuously been taken since that time in order to finalise. Both parties are now ready and able to do so. It is in this vein that we were instructed to demand that Delta Petroleum Limited remove its chattels and cease otherwise utilising the property in July 2018. In light of the foregoing, I'm instructed to demand that Delta ceases use of the property no later than the 1st of November 2018. And then what followed is on at 12/18 that on the 18th of January 2019, the governor signed an expulsion notice to trespasser occupying Crown Land Parcel 310, and that was directed at Delta Petroleum. So that's
Minister, you said you had a file given to you in relation to the dispute. One would imagine that this correspondence should have found its way onto there, but did you not see it on there?
I didn't see it. I didn't see it.
Okay.
I can't say it was on the file.
Sorry?
I can't say it was on the file.
You can't say
I
it was
really
on
can't
the
say
file.
it was on the file.
No. Okay.
At that time, I was more focused on resolving the problem between the two parties, between who should occupy the land as opposed to going through all the back and forth.
It may help just again to give context if we turn over, please, Minister, to 1221. Because this is a draft cabinet paper 2019, and it's in relation to the parcels of land that we're discussing. At one point they were called lots 1 and 2, but you'll see that at C there's reference to the person who is the lessee of parcel 309 granting an easement to parcel 310. But if you turn over, please, to 122, and it just helps us to look at the background information. And let's run through that. So in terms of background, I appreciate you will have inherited this background, Minister, but firstly that in 1997, the Executive Council agrees a portion of reclaimed land be awarded to Egypt Construction Limited. That was what became eventually 309-310. Then in 2007, that decision was taken to revoke that grant because Egypt Construction Limited was no longer in existence. And in fact, the principle of Nature's Way had connections to Egypt.
I think, sorry, but so Gary, that last part of the first paragraph is very important.
The very first paragraph.
Paragraph 1.
Yeah.
They agreed that the portion of reclaimed land be awarded to Egypt Construction Limited in exchange for land given by the company during the dual carriageway construction. It's very important that be understood. Why the government of the day thought it important to break their own policy and give up the seaside property in front of somebody else. It's something the government very rarely ever does. You should give one person seaside property in front of somebody else. But they felt obligated because they took her land to build a highway.
I mean, that's a point you make in your response, if I don't do it, tell me, and I'll finish with this document, okay. And I'll take you to where you say that. All right, but let's finish this document. So, 2007, Egypt Construction Limited no longer in existence. What then happens is that Cabinet further agreed to award Nature's Way a lease for a parcel of land, which is now identified as parcel 310. Right. What's noted at 4 is members are asked to note that the directive of Cabinet was communicated to the applicant by a letter dated August the 1st, 2007. I can take you to that if you need to see it. Members are further asked to note that due to the issue of a right of way to service parcel 310, the property could not be transferred to the awardee. So the reason the principle of Nature's Way couldn't get it was because there was no right of way. Now, that may be linked to the point you make that you're giving someone seafront property in front of someone else. If we then go to 5, by instrument 2017, a grant of easement was given in favour of the Crown providing access to the parcel. So that's the person who's leasing 309,
Right,
giving the easement to the grant. So in effect, whereas before, the principle of nature's way couldn't access 310 from 221 because Delta wouldn't give an easement over their land, could now do it via 309, as from 2017. But what's said at 5 is after that hurdle was solved, the other issue to be rectified was to have Delta remove all equipment belonging to them and to cease using the property for docking. And it then sets out the background, and we've looked at this letter, the letters themselves. So the exchange of correspondence, if we go to 7, Delta did not comply with the request of the government. So the Chambers was further instructed to prepare an expulsion notice for execution by the government to be served on Delta. And this was served. And it says to date, the company continues to occupy the property. So we can date this
January.
This after January. And in fact, I think when we get to the end of the document, we'll see where we are. And then by a letter dated the 31st of May 2011, a request was made by Mr. Bevis Sylvester requesting the opportunity to lease the same property identified as parcel 310. Upon submission of that request, no decision was made as it was recognised that the land was already awarded. What is then said at 9, and this is draft, so the details are not added, but that effectively Delta submitted a request to lease parcel 310 to continue the operation of their business. And in exchange for this leasehold interest, Delta entered into an agreement with the government to reduce the debt owed to them. And then what's said at 10 is the point is made that the principle of nature's way, or through no fault of or the ministry, it's no fault of the ministry or the principle that matters have not been resolved as timely a way as anticipated.
What date is that letter? In
Which
9?
letter?
9?
That
2011?
I can't help you with.
Oh.
But because this is a draft memo.
Because I've never seen it before.
Well, it's just because at the bottom it carries your name as a draft memo.
Or draft? Oh, okay.
Yeah.
Yeah, I don't do drafts. Okay.
I'm sorry, you don't see drafts?
No, not very rarely do I see drafts.
Okay. But there clearly must have been some discussions between government and Delta about that.
There would have been somebody else, not my ministry. And I said that's probably somebody else.
But where it's concerning a lease, would it have involved your ministry?
At least yes, but in terms of negotiating, what is?
Well, it's 9 refers to a request to lease the parcel from Delta.
Yeah, I can understand that, but I'm saying to negotiate, we can't do that. That's the Premier's office.
You can't
negotiate with somebody like that.
I see. I follow. All right. I think I understand.
As a Minister of Finance.
So that's the sort of background. So where we then are is the steps you then take, because the steps you take is to give me a moment, please. You, as you've said, negotiate with the person for whom the cabinet has previously decided to grant the lease, and the effect of the negotiation is that that person agrees to move to another commercial location.
let me make some clarity to that. After I met with her first few times, and she explained to me what her aspirations and ambitions were, which I have to respect that as a business person. We came to one conclusion that she could not afford to do the things she wanted to do at that location. Okay, it involved a reclamation, it involved building a marina, it involved building a building. She said to me, at her age, she don't think essentially she could afford that. So I said that I may have an option for you where you can achieve your dreams and aspirations without the expense. And that's when the idea came in, a kiosk at Pier Park. It gives her the marine access that she wants for her business. It's already built, you simply move in. I tell her, think about these things. It's an option to where you can achieve exactly what you want to achieve without the headache. And we'll see if we find another piece of land for you because the government did take your land. So we owe you a piece of property as a BVI lander. I think we owed it to her to do. And I said, I was trying to find a piece of land to compensate you. And she agreed. And that's when we could now move forward to talk to Delta about leasing that land. She relinquished her rights to that property.
Pause there for a moment. I said, and I forgot to do it, but if you go, I think you've got the bundle of documents that accompanied your supplemental response.
Which one is that?
I hope it's the
response.
The second response, the October response.
Yeah, October 2021.
If you go to 44 in that. You should, I hope, be at a memorandum that's dated the 4th of July 2011.
I'm there.
Right. Now, we don't need to go into the detail of this, but it's from the permanent secretary, then permanent secretary, the AG in 2011. And there's reference to the fact that when Egypt Construction Limited went into liquidation, parcels of land that they owned, particularly 221, were bought by Delta Petroleum at auction.
At auction, yes, that's correct.
But then what's noted is that the person who became the principal of Nature's Way had been a past director of Egypt Construction and gave permission to the government to place the new highway through it.
That's correct.
And then it continues, it appears as though the government wanted to give her an opportunity to start over, although we are not under any obligations to do so. So is that the sort of what you're referring to when you say that the government owned this person?
I'm not sure why they felt they had no obligation. You took her land for a road. You have some obligation to her. Well, I don't think she was paid for it.
We don't know the circumstances. We don't have any evidence about that. But if we drill it down to this, in terms of the steps that you took, the effect was give me a moment, please. If you turn up one I mean, the effect was that you by negotiating, were able to put in place a situation whereby Nature's Way moved to a different location. And if we go to 1138, so again, it's a cabinet memorandum that gives us the background, but if you go to 1141, what the outcome in terms of Nature's Way was that the grant of the lease or the by cabinet was revoked, right. And that was a 99-year lease. Right.
I don't recall what it was.
I can find the document for you if we need to see it. What the cabinet then approved was that Nature's Way could purchase a portion of parcel 251 for a sum of $1 plus a statutory fee of $200. And there were various sort of conditions put in. What you had also obtained was a resolution, and we can see that at 1152. That we'll get some explanation. We go to 1151, Minister. You liaised with the CEO of Tortola Pier Park Limited to effectively obtain a subsidised rent for the kiosk. Is that right?
That's correct.
And that led, as 1152, to a resolution by it's actually the BVI Ports Authority agreed that essentially it's for Tortola Pier Park, but that there should be essentially a subsidized rent for the person. So that was done. So they moved from a 99-year lease on 310 to a freehold at Tortola Pier Park at a subsidized rent
For the kiosk.
for a fee of $1.
The land, yeah.
Yeah.
The land was not Pier Park. The kiosk was at Pier Park.
Yes.
So the kiosk provided her with this waterfront access that she wanted and the land for the commercial building that she wanted.
Yes.
There were two separate
things.
two separate plots. So instead of 310, she got to the kiosk at Pier Park,
Which gave her the waterfront access that she wanted for her business.
for initially a reduced rent, but the
Yes.
reduction itself reducing over time.
Yes,
And secondly and separately, some commercial land
that is correct.
for $1.
That is correct. Compensation for all her years and headache. And is it, Commissioner, I know what you would say, but our ambition here was to help somebody to get a foot in there. She lost a lot of time. She told me over 20 years waiting to do this. You can't put a value in somebody's time. Cannot value somebody's time. She should have had a building built probably 20 years ago. So she lost 20 years of her life. It's only fair that we compensate her properly. We did our best to make to right a wrong.
The parallel with this, and this is happening in August 2019, you have, obviously we've discussed that in terms of the expulsion order, Delta Petroleum ignored that and carried on occupying plot parcel 310. But if we go to...
Were they punished for doing that?
I think you're the man to ask.
No, I don't execute expulsion notices.
Who does execute an expulsion notice?
I guess the governor, I don't know.
Well, I mean, the driver for this, as we've seen for the correspondence, was your ministry.
No, that came from the governor, the expulsion notice.
The governor signed it, but the preceding that was correspondence that we've looked at from
AG chambers.
the AG's chambers.
Yeah, not my ministry.
No, but it's the instigation of your ministry.
That could be. That was before my time, wasn't it?
Well,
Anyway.
I mean, but it would all have been in the file.
Okay.
But it leads up to the expulsion order. I mean,
Okay.
I mean, I can't help you with who did. I mean, if you end up with a particularly hands-on governor, maybe they do it themselves. But if we go back to what's happening parallel to this, because if you go to 1180. what you have on the 12th of June is Bevis Sylvester writing to you in respect of those plots, those parcels of land. I mean, he refers to them in his letters lots 1 and 2, but they're lots 309 and 310, requesting to apply to lease the said Crown land for a period of 99 years. There then follows on the 27th of June at 1166, a cabinet paper concerning that application. So it's now become an application from Bevis Sylvester to lease parcel 310. And it notes it all through, takes us through. This is the one we looked at where the financial secretary raised what Delta Petroleum was doing. So in June 2019, we've got continued contraventions. So reference to continued contraventions, which suggests that they're still in occupation of the land. But what's decided is that parcel 310 will be granted to Bevis Sylvester for commercial purposes. And it's initially said to be for a term of 50 years with a rent of $800. Now, one of the documents you've provided to the Commission, which was something that we hadn't seen before, is the last page of that. Do you know the supplementary bundle you have, Minister, that you brought along? We were looking at the October one, which carries the
response.
Yes. So that you found an email. It's at the very last 2 pages, but it's an email from Ronald Smith Barclay, the then permanent secretary, to you, saying, please note the legal and financial implications. Those are the ones that are in that cabinet memo we looked at. We may want to conclude our discussions with the principle of nature's way so we can make notations in the paper. Files were sent to the chambers for their perusal. That's the Attorney General's chambers. And then we make the necessary adjustment. Please note that the FS is requiring a business plan as well before the matter goes to Cabinet. The office will therefore write to Mr. Sylvester and request the same. And the office did do that. I can take you to it, but if you'll take it from me, it's on the 24th of July 2019. So we then have what we've slightly gone back, but we then have the process that we've gone through where you speak to the principle of nature's way, you speak to Tortola Pier Park, the kiosk arrangement has come up and she ends up in that situation. And then there's the cabinet paper made, and if we go to 1181,
One quick note, well, when it comes to business plan, because it's not a properly defined concept, it may take many forms. Because I think person may take up a business plan as a particular prescribed thing. It may take many forms. Right? I'm not sure which form this one took.
So your voice dropped, Minister.
No, I'm saying I'm not sure which form this one took.
At the moment, on the evidence, it took no form because there wasn't one.
No form. I'm sure I saw a document where they said,
Risso Gill, as he has been during the course
where
of the
they
day, might be able
showed
to help
what
us.
intended use of the property was.
Yeah,
It was to be the headquarters of Delta.
Yeah, that may have sufficed at the time.
But
yes.
but knowing that it was going to be the headquarters of Delta is not any form of business plan.
But see, we know what intention is. Anyway.
I can't hear you, sir.
Forgive me. Yes, page 38, I think, sir, of the 7th of October supplementary bundle is what I think the Honourable Minister is referring to.
And that's from the 27th of May, 2011.
And
So we know exactly what the intention was for this property.
But that's sent on behalf of Delta Petroleum.
In 2011.
Mhm.
And it refers to the easement, which is now not necessary because the easement of.
I must say a business plan may take many forms, and this could sometimes suffice depending on the circumstances. So to insist to be something else.
Just help us with this though, and appreciate Honourable Wheatley that there is some history to this, but in 2011, and we've looked at some of we've looked at correspondence from an earlier point before you become minister, where Delta Petroleum is expressing an interest in leasing this land, leasing parcel 310 at a time when government has already agreed that it should go to somebody else. That is an expression of that intent in May 2011 by Delta Petroleum. How does that constitute the business plan that is required from Bevis Sylvester applying in his own name from his own address?
It's the same land.
In 2019?
It's the same property. He works for Delta Petroleum as the regional manager.
I'm sorry, I'm sorry, Minister, I'm sort of lost.
It's the same person.
Mr. Sylvester and Delta Petroleum, different people.
Yeah, he works for Delta Petroleum as a regional manager. Yes, they're two different entities, yes.
He's a general manager, but they're different entities.
Correct.
And a lease is being granted to Mr. Sylvester for £800 a year for a headquarters building for a regional company.
He's a regional manager.
No, I'm sorry, I'm absolutely understand.
Okay.
But I'm still lost as to why the lease was given to Mr. Sylvester, who's an individual, not to Delta Petroleum, which is the company that wrote in 2011, and why it was granted for £800 a year when it was for regional headquarters. Okay,
that there was a direct request by Delta that at least be put in his name. There was a direct request from Delta that the lease be placed in Bevis Sylvester's name.
Which document records that?
Page 36.
Oh, crikey. Well, hold on a minute. I'm sorry. Thank you first. I'm sure that's the document. This is a document from 2010. Delta Petroleum is obviously a company, and it's a regional company. It would require a non-belonger license. So when the director of Delta says that he would like the land to be leased to a BVI citizen in the form of Bevis Sylvester, what was going on there?
I don't know, sir. That was 2010. I don't know. I can't answer that question.
But and I respect that answer because you were not minister for another 10 years, Nick. But it's on the face of it, it's a request by a non-belonger to put a lease in the name of a belonger because that is beneficial, advantageous, although the real person behind this was the non-belonger. Doesn't seem to me to be quite right.
Remember, and I could only speculate here, it was based on Delta feeling they had the right of forced refusal to the front.
But it wasn't Delta who got the lease.
Because they requested it. Remember they had said, if the land is to go in anybody's name, they're going to have a judicial review, except Bevis Sylvester.
Forget about that. I'm sorry.
I can't answer otherwise.
I'm sorry. No, you may not be able to answer. I understand that. But this is a non-belonger asking for a lease to be put into a belonger's name, presumably because of the benefits in terms of land transactions that a belonger has.
Could be.
But when you were negotiating with Delta, they presumably again asked for the lease to be put in Mr. Sylvester's name.
Is that on the file? Yeah.
Yes, but the same issue arises, doesn't it? You have a non-belonger who can trade in land, who can purchase land on one basis under one system, who asks for you to put a lease into the name of a belonger who can purchase land in a different system at highly advantageous terms, although the real beneficiary is Delta. They want it for their headquarters. It looks very peculiar. I mean, for example,
I can't answer it.
well, you were the minister at the time of the lease to Mr. Sylvester, but Mr. Sylvester would, I assume, but correct me if I'm wrong, obtain the land on beneficial terms. He's a belonger.
I think we use the same terms as Cabinet was giving it out for.
I'm sorry, I missed that.
We use the same terms.
You used the same terms as Cabinet had given it in 2007 to Nature's Way.
That is correct.
But can we break this down? You have referred the Commissioner to correspondence in 2010 and 2011 about the intentions of Delta. So to complete the picture, we're staying in the same bundle. Let's go to 29.
Number there?
29. No, it's in your bundle, please.
Page 29.
Yes,
sorry.
Yes, please. This is all additional disclosure that you've provided on the Wheatley. So in 29, this is a memorandum from the Attorney General to the Permanent Secretary of an earlier version of your ministry, then I think called Natural Resources and Labour. So it's 9th of August 2021. And it's, if you look at the bottom there, it just says, in relation to parcel 310, it's clear that this parcel is to be leased to Delta Petroleum Limited. It is imperative that the lease be made between Delta Petroleum Limited and the Government of the Virgin Islands, and not in the name of Bevis Sylvester, although he may sign the lease on behalf of Delta Petroleum Limited. It's patent that the lease to Delta Petroleum is some form of consideration for the easement being granted by Delta Petroleum of its land to facilitate access to parcels 309 and 310. It's advised that in order to avoid any legal complications which may arise from the lease being executed in the name of Bevis Sylvester on behalf of Delta Petroleum, that the lease be executed in the name of Delta Petroleum Limited. So when this was canvassed in
what year was this?
2011.
And the other one?
The other one,
where Delta Petroleum said, I hear you, but put it in Bevis' name.
That's the letter that you took us to earlier, which I think
2010.
2010, yeah.
Give me a moment.
On page 36, is that document?
Yes.
2010. So they made their intentions clear, how they wanted this to go for whatever reason.
Understood. But the point is that what you've got is a situation in 2010, 2011, where Mr. Sylvester is writing saying, I want to lease this land. And the managing director or a director of Delta Petroleum also writes on the same day and says, I would like to see the said lot or portion, which is owned by the Crown, leased to a BVI citizen in the person of Bevis Sylvester. That's 2010, 2011. We've looked at the memorandum of the AG in 2011, which cautions against that and says, if you're going to, this is going to go to Delta Petroleum, the lease has to be with Delta Petroleum. Now, just keeping that in mind and just taking you back to when you are minister in 2019, did you have direct negotiations with Delta Petroleum that led to an agreement that the lease would be in the name of Bevis Sylvester?
No, I use
or did you look back to what had happened and decide for yourself?
From the file note, yeah.
I'm going to recommend this lease goes to Bevis Sylvester.
That is correct.
In the knowledge that it is actually intended to be for Delta Petroleum.
That is correct.
Did you have any discussions with Mr. Sylvester about that?
He's who wrote the request.
What he wrote as a request was that he wanted to lease the land.
Yeah.
But did you, and he wanted to do so for commercial purposes.
Yeah.
Did you bring him up or speak to him or get to public officer to speak to him and say, well, Mr. Sylvester, what commercial purposes?
No, because I just used a file note that it was going to be used for Delta headquarters. There was no discussion to be had.
All right. Well, can I sort of separate the two events that we need to put to you? So on one side, you have, as minister, have put in place a situation where Nature's Way no longer will have parcel 310. That's going to be revoked by cabinet. They will go to parcel 251, and they will have a kiosk there.
At Pier Park, yeah.
They'll have, the Nature's Way will have a kiosk at Pier Park at reduced rent for a certain period.
Right.
They will also have the freehold of some land.
A small portion of land.
A small portion of land, which is for a nominal fee of $1. So that's what you did. Now, Mr. Smith-Abbott, who set out the chronology of the disposal of land of this piece of land to Mr. Sylvester, concludes his summary, which is based on the work of his team, in this way. I can add that following Cabinet's decision, at the behest of the former governor, His Excellency Augustus Jaspert, a valuation of parcel 251 was commissioned. And the valuation in October 2020 concluded that the market value for parcel 251, now called parcel 290, was $600,000. So the result of your negotiation was that the principle of Nature's Way moved from having a piece of land on a 99-year lease to a piece of land on a freehold, which required payment of $1, but which was valued at $600,000.
She lost a lot. A 99-year lease.
But she lost that because Delta Petroleum were occupying her land.
No.
So how did you come then to value her loss?
She should have been over on 310 for the last 20 years. She had not had a chance to develop her dreams, get a compensation for the time lost. She said, thank you for resolving this over 20 years. So for 20 years, her life was in a holding pattern for 20 years. Can you value somebody's 20 years of not being able to live your dream of having your property for 99 years, 99-year lease, that she could have sold that lease for millions of dollars? That 99-year lease would have had a value in it, would have had a value that she could have resold for millions of dollars. She lost an opportunity to have that seafront that she could have subsequently sell if she wanted to. Would have cost a lot more than $600, a lot more than $600,000.
I think your voice dropped a bit, Minister.
No, I said,
so you said it
had she moved over to the lot which was promised by Cabinet, a 99-year lease, that 99-year lease would have valued a lot more than $600,000 that she was deprived of.
Okay, that's helpful, Minister. In relation to that lot 310, the lot that she didn't have that opportunity for, it is really, not particularly asking you, Minister, but because Mr. Rowett or Mr. Rousseau-Gill might know this, but is there a valuation of that property?
I think that both were done, the valuations.
The valuation of lot 310.
I don't know, there wasn't.
I mean, what the minister says is that a 99-year lease would have been worth millions. So on that basis, that it was worth a lot of money.
Yes.
But Mr. Rowett may be going here next. But this lease, which was worth millions, was.
I said it might have. I don't know what, but it has value. It has a value to it.
I mean, you're not a surveyor, but it's worth a lot of money. But that was given to Mr. Sylvester for $800.
That's for the cabinet decision.
Well, the cabinet decision was to give it to 20 years ago to Nature's Way. When this was done in 2019, Nature's Way had moved out, so the 310 was clear, absolutely clear. Why didn't you go back to cabinet and say, well, the rent of this shouldn't be $800 a year; it should be hundreds of thousands a year?
I think I'm not sure they did evaluation or not. I want to think it was done. I don't recall seeing it, but that is not something that cannot be done.
No, but in any event, what you said is, I know you used the word millions, but you meant it's a lot of money.
Yeah.
It's I mean, we all know where it is.
She developed it 20 years ago.
Yeah. But this was leased to Mr. Sylvester, not to Delta, to Mr. Sylvester for $800. Now, I mean, again, we don't know what's happened. We don't know what's happened, and this is just speculation. But if you lease any land to somebody, to commercial land, to somebody for $800, there's nothing to stop him or her or it, whoever you lease it to, leasing that at the market value, is there?
Guess not. If you have a lease, I guess you can sublease, unless the lease says you can't sublease, which some leases do say you can't sublease.
But this one can't, because we know that this was for Delta's headquarters, not for Mr. Sylvester to live there. So we know that. But
that's why we have lease reviews, because it's unimproved land right now. So there's a lease review.
The lease review, I think, was 5% on the
improved. So
on the unimproved land.
Unimproved.
Yeah. I think.
So that's why we have the lease reviews. So we'll get the real value at some point in time.
Well, on the unimproved land, 5%. Well, we will need to look at the.
Yeah.
But the point you're making, Minister, is that when you recommended to Cabinet, and when you knew that by giving a lease to Mr. Sylvester in his own name for the same price as had been given to Nature's Way in 2007, so some 12 years before, that the purpose was so that Delta Petroleum could access it. And did Cabinet know that?
Yes.
And so there was no mystery about it.
No, I don't think it's all in the file.
Yes, and because you had taken it from, this was the intent back in 2010, 2011.
There's a lot of there's been a lot of talk around this for a very long time. I think everybody would have known what this was about. I'd be surprised if anybody didn't know what it was about. And so
you did not then and there's no evidence that a business plan was presented.
Not to my knowledge.
Even though Mr. Sylvester was written to, there's no evidence that there was a valuation of the property before the lease was done.
Yeah. I'm not sure. I'm not sure.
I can put it this way: no evidence has been provided to the Commissioner that any of the steps that Mr. Joseph Abbott normally says would normally be taken in dealing with a commercial transfer of Crown land appear to have occurred in this instance.
Yeah, but you have. This is a long-running situation here. It wasn't like somebody just showed up and said, "Okay, I want to lease this land." That's different. This is we try to resolve a long-standing dispute.
But I'm sorry to. I may have interrupted both of you, and I apologise. But the dispute had been resolved. Nature's Way had got a deal that they were happy with. So that resolves the dispute. That frees up plot 310. And plot 310, firstly, there is some policy which suggests that where land has been reclaimed, the person who owns the land behind it.
It's a long-standing policy. That's
Yes,
correct.
I
That is correct.
mean, it's one criterion. There are other criteria, but that is an important criterion. And secondly, of course, this land was of unique value to Delta because they own the backing land. But we haven't seen a market valuation of the land. And can I ask this? I don't want a valuation to be done. If there is a valuation, I'd quite like to see it. But
I'm not sure.
Otherwise, I'll assume that there is no valuation. But the market value of the lease would have been worth a lot of money, and there was absolutely nothing to stop you asking for a market value from Delta.
I would guess the consideration there might have been because it's taken so long to resolve the opportunity. Think about it. If Delta had acquired this land when they wanted it 15 years ago and had built a headquarters then versus building the headquarters now, it's a significant difference in building a building 15 years ago and building a building now.
But they hadn't got the land. They had absolutely.
That's what I'm saying. But because of this situation that government created.
But government didn't tell Delta to illegally occupy 310.
No, I'm not talking about that. I'm talking if the government policy has always been if you own the land side, you have the first right of refusal to the seaside. Delta made it very clear from the onset. Ms. Nations was awarded that land against Delta's right of first refusal. Has government followed its own policy and given Delta that land when they acquired the back piece, they would have built their headquarters 15 years ago. They're now going to build headquarters 15 years later. It's probably cost millions of dollars now because of this situation. I hear what you're saying, but you have to also consider that part, and that may have been a consideration where the technical said, maybe let us go back to that original thing.
All of these might have been considerations, but in 2019, when you put this paper to cabinet, as I understand it, your thinking was just that this had been the cabinet had made a decision in 2007 to lease this land for £800 a year, and that's what it should be leased. That was the rental value.
Back then, I'm not sure. I'm saying that's where it should be now. I think the condition might have been, with all the time lost.
But this is your what I'd like to know, Minister, is what was in your mind when you put this paper forward. Not what might have been in anybody else's mind, but what was in your mind. You put the paper forward.
I was so happy to finally get this matter resolved because this lady who was trying to just get her dream on, I was so happy I wasn't focusing too much on Delta. I was focusing on Nature's Way. But my focus really was not on Delta.
So with respect to Delta's grievances, it may be helpful. There is a summary of those at page 2 of the 7th of October bundle.
Yes, thank you very much.
In their judicial review application. It's not long, but it summarizes their grievances in respect of parcel 221. In particular at paragraphs 3 and 4.
They lost sea access.
No,
yes, having invested a good deal in the plot, I think that's what they say.
Yeah, they paid $1.1 million to acquire that property to have sea access that they were denied. They were denied that access. How do you quantify that? These are things we have to consider sometimes. I understand we could have gone the other route and do a modern evaluation and say, Delta, okay, you were denied this sea access 15 years ago, but now I want to punish you a second time.
By charging you a market rent.
Yeah, so we are a little lenient with them and say we'll give you a little break for now, but we do a rent review. Then we say, okay.
But that's on the unimproved land.
Yes.
For which you haven't got a valuation report.
I'm not aware of any. Maybe there's one. I don't know.
If there
there's
is,
no evidence.
well, I mean, just to be clear, Minister, the position is, I mean, firstly that Mr. Smith-Abbott's team have trawled the files to pull together the papers. Secondly, that the second stage of it is that you have produced additional disclosure not once but twice. And putting all together, I mean, what there is absent from Mr. Sylvester's application for a lease is any of the sort of documents that on Mr. Smith-Abbott's affidavit, any applicant for a lease for commercial purposes is required to produce. And critical is no business plan, critical is no valuation report. But as I understand it, you see yourself as having acted in these transactions to right what you perceive to be is a wrong. So in relation to Nature's Way, because the principle of Nature's Way was denied by Delta's refusal to grant her an access to 310, you put in place a situation whereby she, as we've discussed, got $600,000 property for $1. And then in relation to Delta Petroleum, because they had started off complaining that they had bought plot 221 in order to get C access, and then they had illegally occupied 310, giving them C access. You decided that because of an exchange of correspondence in 2010 and 2011, that it was appropriate to give Mr. Sylvester a lease at 2007 rates to again put Delta back into a situation they would have been back in 1990 or 2007, whenever they bought 221.
Those are your words. I wouldn't quite put it so. But I was just saying that the kind of considerations you have to do when you come to these old land disputes, there are things you have to take into consideration. You look at Delta building a headquarters, that's construction in the economy, job creation. There are a lot of things you have to consider with these very old land disputes. They're not very easy to resolve, number one. But hopefully we'll find no more like this.
No, I think we've probably completed this, and I appreciate that. Some of these land disputes are very old. They're very intractable, and they are often difficult to resolve. But in this case, one of the parties was given the freehold of land worth $600,000, and the other was given a lease on a hugely reduced rent from market rent, and as a belonger, although it was in fact going to a company that would otherwise have to have a non-belonger license. And in those circumstances, one can understand why the parties accepted the deals they were offered.
Well, it wasn't easy because the governor took a long time to sign it. I don't know what it.
Yes, but there it is, Miss. You've explained what happened. Are there any other questions?
Could I ask two questions, please, Minister? I mean, and we have sort of moved around this topic slightly in a non-chronological way, and I do like chronologies, but just picking up 2 points, because what I should say to you is that you've obviously gone into some detail in your written responses, and what I'd like to assure you is that is something that, as you'll appreciate, the Commissioner has already considered and will consider again. So the fact that I've not taken you to some of that detail doesn't mean that it's not going to be considered.
Okay, good.
And I hope you'll appreciate that. But can I just ask you just 2 points, please? Now, you've explained that firstly, you had a briefing in that when you arrived, in that here's a file.
These land matters, several of them, several land matters.
So that which you were placed on your desk, and that also that you didn't speak directly to Mr. Sylvester, but you looked back at the correspondence.
Well, you know, we did speak, you know. I'm saying I didn't ask him that particular question because I knew what it was.
I see. So you discussed the grant of the lease to him.
Yeah.
And what was the tone of your discussion? What was the outcome? What did you?
Does this still stand? Is the lease still go in your name, or do we put it in Delta name? And he confirmed, yes, we're still going to go as on file.
I see. So you had looked at the file. You'd seen that there had been this exchange of correspondence where he essentially Delta had wanted it in his name.
Yes,
in 2011.
I was familiar with that. My question was, does it still go in your name, or do we put it in Delta's name?
And did you get? I mean, did his application that came into you as minister, was that something that you were? Was that unsolicited? Did it just suddenly arrive, and then you thought, or had he approached you in any way to discuss it beforehand? No,
I don't think we necessarily had a discussion, but I did tell him, if you want the land, you don't have to again apply for it, which he did. More than likely, that's what happened.
See, so the best you can tell the commissioner is that you may have had an approach from Mr. Sylvester
about the land.
About the
it's a small place. You would have heard what happened. Yeah. And I said, well, you will have to apply. If it's going to go in your name, then you will have to apply, which is what is on the record.
And that's, I think it's the 12th of June letter.
12th of June,
yeah. And then you then spoke to him and said, right, can I just be clear? I've seen the files. It looks like, this is necessary for Delta. Is it going in your name? And he confirmed that.
Because I would have started discussions with Nature's Way from April. So there was several months of discussion before we got to the point where we could say, okay, well, it's now available. If you want it, then whose name should it go in?
I see. Right. But did you contact him to say it's now available, or did he contact you?
I don't recall. More than likely, he would have been calling the office all the time anyway. More than likely. I don't recall.
What would make it more than likely that he'd be calling the office?
He would have heard what's going on. He would have known that we're negotiating. He would have known that. He probably would have called the office saying, what are you all doing? Somebody might have told him, well, they're not really negotiating right now. Wait until we get a clear signal that we can move forward with a lease for you. Because we couldn't move forward before the interest was relinquished from Nature's Way. We could not move forward before that was done. And who's to say when it was going to happen? So you might have been checking and say, is this finished yet? Can we start now? Is it finished yet? Can we start now? Knowing the character, you'd probably been calling my office every day.
So taking it back to the problem you had to solve, the problem you had to solve was Nature's Way being able to use that land.
The problem I was solving was having Nature's Way be able to live her business dream.
I see.
Of having a building and seafront access for her business. Her own building and seafront access. That was the driving force behind all the negotiation. How do I satisfy this situation for this lady?
But given that you went through the file and you looked at the file from 2011, how did you not come to see the expulsion notice?
I don't recall that at all. I really didn't see it. And maybe it's not on the file. Maybe I don't know. Maybe it wasn't on the file. The first one I knew about that expulsion notice when the governor mentioned it to me.
But did you see the preceding correspondence, which was at the instigation of your ministry, telling the AG's chambers, get Delta off this land?
No, I never saw it. I don't know if it was on the file or not. I'll have to go, but I don't recall seeing that on the file. The first one I knew about it, and I was quite surprised because the governor was quite excited about it for some reason. And I was confused because see all these questions you're asking me here? I went through a million times with the governor. My PS did. The lands officer did these various questions here. I had to answer them a million times before about this situation. This didn't take, it took a long time to get the governor, to convince the governor to sign a document. I think he signed a document the day before he was going on vacation in December. I think it was, whenever it was. A long, long time.
Would you mind, Honourable Wheatley, just asking that the file be reviewed to see if that correspondence and the expulsion notice is there?
The challenge is since We moved office since then, and we had a difficult time trying to locate that file. That's why you got some submissions late. So I hadn't seen that file in maybe a year or two, so I couldn't recall what was on. I haven't seen that particular Delta file. So I'm not sure that those things are on that file. We found that file must have been a few days ago. Literally, that's why we were late with submission.
Not the most. I mean, the expulsion notice and the things have all.
Well, the file is in my office now. I can go back and look at that file and see if it's, but I don't ever recall seeing it on that file.
Whatever efforts you can make will be helpful.
I will look at the file again.
Just one more last thing. I mean, we've seen that Crown Counsel, Maya Berry, was involved in dealing with the expulsion notice.
She's a lawyer assigned to my ministry.
Yeah, and she is the one that gave you advice in relation to the negotiations you were doing and this issue. And you've explained that, as I understand it, you had meetings in the Attorney General's chambers, but there are no notes of those meetings.
In my office.
In your office, but
sometimes over the phone. Yeah.
There are no notes of these meetings.
Well, I checked my diary. There are none, and she checked hers. She can't find any either.
But
I doubt if my PS at the time might have notes. I don't know.
But did anyone mention the fact that there was an expulsion notice to you?
First, I heard about it was December 17th, when the governor called me for the millionth time to explain why he should give Bevis a lease. And then he mentioned, about the expulsion notice. I don't know why anyone missed it, even in the FS account. Apparently the FS was aware of it. He alluded to it in his document, but he never produced it and said, this is what I'm talking about. He just said something about Delta. I hadn't a clue what he was talking about.
We've seen that the reference to Delta's contraventions.
Right, exactly. But he didn't say what it was. I didn't know what it was.
But that's in a draft memo that's got, it's in a memorandum that's got your name on it. I mean,
it was in a cabinet paper. Yeah, they make their comments in all those things. But he never said what it was. I mean, if it was something so serious, he should have put it as an appendix. This is what I'm referring to here.
But did you ever ask?
No, I didn't think to even ask. I thought something so serious would have been brought to my attention. I was quite surprised.
I mean, I mean, perhaps if you can enlighten us with this, because we've got a situation where, there's 2018-19. There's this correspondence efforts to get Delta off the land.
2017. Yeah.
It starts in 2018. The expulsion notice in January 2019, obviously before you come into office. But it's all must be fairly fresh in people's memories after you come into office. But as you start dealing with these problems, neither your permanent secretary, who asked for Delta to be removed from the land, nor the council assigned to your ministry who dealt with that, nor the financial secretary who wrote about it in a memorandum.
It was
nobody said to you, Minister, do you know some of this history? It
was never brought to my attention. So I want to think it was not on the file. I would have seen that and asked them about it.
But when they referred to Delta's continued contraventions, did it occur to you to go, look, what do you mean by contraventions? What's going on?
No, I didn't think to ask them anything, because they should have brought to my attention. It was the governor who brought it to my attention. In fact, he mentioned it to me, and I asked afterwards about it. I saw it for the first time, must have been last week, the actual document. I was not made aware of it.
If I could just have a moment, please. Commissioner, that's the end of the questions.
We'll need to give the stenographer a break.
Yes.
Thank you for your patience, Minister, and thank you for your evidence. What we'll do now is to have a 5-minute break for the stenographer, and then come back and complete it. Thank you very much.
Thank you.
Yes, Mr. Rowett, we're ready to resume.
Thank you, Commissioner. Honourable Wheatley, thank you very much for sticking with the Commission. What I'd like to do now is just to return to the topic of belongership with you, and particularly just to ask you some questions about the fast track programme. I don't know whether you heard any of the evidence of the Honourable Premier.
I don't recall.
When describing the fast track programme, he described himself as the face of the fast track programme, but you as the body and organs. And that if there were any questions about how the fast track programme was operated, it was you were the person to speak to. Now, just give me a moment. What we've handed you is some additional material that was disclosed to the Commission following the evidence that you gave on belongership on the last occasion you were here. Could I ask you just to turn up? There's a bundle which is headed Disclosure Request to Honourable Wheatley, dated the 29th of September. Do you have that?
What page is that?
You have two separate bundles, I hope. One is a bundle of email correspondence, and the other one is, yes, do you have that? If you could turn up, please, Honourable Wheatley, just the first page. This is an example of a number of cabinet papers prepared, and you will have seen those as the fast track programme went through. This one is on the 19th of November 2019. And what it's headed Applications for Certificates of Residence and Belonger Status. And as we understand the process.
Just hold on one moment, Mr. Rowett. I think Mr. Rousseau-Gills wants some.
I do apologise, sir. I've mislaid my bundle of the
Don't
correspondence.
worry, you should have it. So, not if we can find it.
Forgive me, sir.
That's fine.
I do now.
As long as you've got it. Okay, thank you. Yes.
And these memos would have come from your ministry to Cabinet, setting out the in batches various applicants for belongership under the fast track programme. Now, if I just take you to that programme, and it was properly called, it's called the Clear Path to Regularisation, Residency and Belonger Status. And if I just take you through paragraphs 1 to 3. So in summary, 3rd of June 2019, the Immigration and Passport Amendment Act 2019 is passed, and it amends the Immigration and Passport Act. And I can take you to the amendments that are made if you need to see them. But the effect was you had a special fast track process to be developed for those residing in the territory for a period of 20 years or more without gaining status to be able to do so. And persons could apply for residence and belonger status or belonger status only. And that was explained to us on the last occasion. But it was intended to be an expedited process with a timeline of 3 weeks for persons to submit the required form and documents. And the scheme or the programme was intended to end in August 2019. I think as we knew, it was extended.
Yes, a little bit.
But applicants were required to pay, upon submission, a fee of $1,510.
That's correct.
Now, this is the bit, because I put this to the Honourable Premier, and this is where he pointed to you as I say, as the body and the organs. So it says the Clear Path to Regularisation, Residency and Belonger Status Programme is a special project initiated and driven by the Honourable Premier. It does not require deliberation of the Board of Immigration for applications received, but is approved by Cabinet pursuant to the Act. The process specifically required applicants to submit their application and make payments up front, complete a written exam, and submit all of the same documentation that persons which have originally submitted through the normal process at the Immigration Department. Following the receipt of completed forms, documents, and payments, persons were profiled for submission to Cabinet. A profile of each applicant which summarised the application of each applicant is attached for Cabinet's deliberation. It should be noted full applications are available at the Department of Immigration if Cabinet wishes to gather further information on each applicant. So in terms of the design of the scheme, this idea of having payment up front, a written exam, you had to put in certain documentation. Was that your brainchild?
No, that would have been the technocrats. That would have been the technocrats.
So what did you ask the technocrats to do?
Exactly what you read right there. We want to fast track persons who've been living here for a while. That was it. Their job was to figure out how to do it. We were told that there's a huge backlog. We are trying to reduce the backlog. We told them we want to create a fast track process. You're the technocrats. You design a program for how it's going to work. So it was implemented by the Immigration Department with the help of additional staff. So they would receive all the applications. That person needs to understand how it happens. They would receive all the applications. They're loaded into the computer in something called Excotrack, which because I'm the minister, it will be sent to me to take to Cabinet. And you said there were probably several hundred, so they came in batches of varying sizes and so forth. And I must add also, sometimes the batches do, because there's a fast track, batches often arrive late. They often arrive late.
For the Cabinet meeting?
Yeah, in terms of the timing for Cabinet.
I mean, you don't mean literally late in the sense of after the Cabinet meeting.
No. I mean, like, ideally, you want your papers at least 3 or 4 days before.
This was sometimes shortly before the meeting.
Shortly.
No, I understand.
I mean, I think that the Cabinet handbook from memory requires that papers are there at least 2 days before Cabinet.
At least 2, exactly. It's not always the case, unfortunately.
So in these instances, I mean, how close to a Cabinet meeting were you getting these papers?
Maybe a day before, the night before, something.
So the night before, you would have to sit there and look through them.
But it's not my only subject, you know. But that's the intention, that you got a chance to look through them before they advance to Cabinet. Doesn't always happen, I have to admit, because of circumstances.
Well, I mean, that actually prompts an important question, Honourable Wheatley, because the process where it differed fundamentally
was the board
was taking the board out of the equation, and so Cabinet made all the decisions. And the question that then leads is: did Cabinet make the decisions together, or did you decide beforehand and bring your decision to Cabinet?
No, Cabinet made the decisions. Cabinet is collective decision making.
So all you could do
is bring something
the night before was to just to make sure you read your papers.
Yeah.
And that's actually what applies across the board, irrespective of the subject matter. All you can do as a minister and Cabinet member is
read the papers, present to Cabinet, and Cabinet makes a decision.
Yeah. So you know, but if you're not presenting to Cabinet, you try and read the other material that's sent to you.
And you want to read your information.
Yeah.
But I can't decide anything. I could only bring a paper to Cabinet.
Mm-hmm.
Cabinet makes the decision, a collective decision.
Now, if you turn through, please, Honourable Wheatley, what you'll see, I think this is it's a sort of example of one of these papers. So you'll see that what's annexed is also the amended Act, which tells us what is common or appears to be quite common in terms of these memoranda, is that the purpose is always given as to allow for persons who have resided within the territory for a period exceeding 20 years to be granted residence and belong status.
There's intention.
And then, so if we turn through to page 12, page 11 first, if we look at it,
Mm-hmm.
what was introduced in terms of the changes to the Act for a time-limited period was a new 16.4,
Mm-hmm.
where it says, where in the exceptional circumstances of any case or for any other reason, Cabinet considers it fit to do so, it may, in its own discretion, grant a certificate referred to in subsection 1 to any person who applies for same in the prescribed manner and who is A, of good character, B, is at the date of making the application for such a certificate, ordinary resident in the territory, and C, has been so ordinary resident for a period of not less than 7 years immediately prior to his or her application. But the second change that was made, we see at page 12, and that is, and this seems to be the provision under which the 20-year rule was operating, where in the exceptional circumstances of any case, Cabinet considers it fit to do so, it may, in its own discretion, grant a certificate referred to in subsection 1, certificate of belongership, to any person who applies for same in the prescribed manner and who, in its opinion, has made significant. That's what there was. That what we see at C is what was inserted, where Cabinet considers it fit to do so, it may in its own discretion grant a certificate referred to in subsection 1. So I've got that, I'm completely confusing you, Honourable Wheatley, so I'm going to stop there and just take you actually to where, if I could just have a moment, please, Commissioner. Yes, sorry. So the change that was brought in, we've looked at 16.4. 16.5 was where in the exceptional circumstances of any case, Cabinet considers it fit to do so. It may in its own discretion grant a certificate referred to in subsection 1 to any person who applies for same in the prescribed manner and who, in its opinion, has made significant and consistent contributions to the economic and social development of the territory, or has been ordinarily resident in the territory for a period of at least 20 years. So Cabinet, if there were exceptional circumstances, could have a discretion that if someone had been ordinary resident for 20 years, it could grant belongership. And that seemed to be the basis on which these memoranda was being put. Again,
forgive me, so as a short way into this, there is a track changes version showing the amendments
page 1348.
You're quite right.
That's what I've just read from.
Forgive me.
If we go through, then you're provided as Cabinet with the memoranda, you're provided with the Act, you're then provided with some more details, but carry running through, you will see at page 23, please, Honourable Wheatley. And it's been redacted, but it's essentially, this is the profile that's prepared by the Immigration Department, isn't it? And again, just return. You're Minister for Immigration.
Yes, I am.
But you had no involvement in signing off the detail of any of this. What this would look like, or
this is presented to me, finished product.
So the technocrats designed the whole process for you.
They designed the whole process. Yes. They collect information, they package it, and it's sent to us. It's sent to me to take to Cabinet.
Now, there are various details that are put in. So you're given, for example, application date. You're given the date of residence in the territory, employment status, occupation, immigration status, whether the police record is clear or not, marks on the cultural test, and then absence from the territory and the reason for it. Because I think when we went through with Mr. Smith-Abbott, and we may have done the same with you, there are specified reasons under this usual legislation whereby someone can be still maintain ordinary residence, but and not lose time. So this would be what you as Cabinet would then make your decision on.
That is correct.
And going through the documents that we've received in terms of these.
Yes, that's one thing. This here would have been an appendix. So this would be what you would see up front. This would be an appendix.
Yes.
To a list.
Yes, I think if we look at, we don't have to read out any names, but if you look at the page 4 or beginning of page 3,
That's what you see in the body of the paper.
Yeah, so you'd have a memorandum that would tell you the background, the purpose, 20 years. It would then essentially, under decision sought, ask Cabinet to review and approve the grant of certificates of residence to the following. And in this case, it's 100 people. And we've seen with memoranda that 100 seem to be the common size of the list of people.
That's
you
a nice round number.
I think we have 11 of these, and with the exception of 2, it's always 100. I think you had 2 where they were 46 and 48, but you're given their names, and then the appendix, one of the appendices is this this profile.
That is correct. Yeah.
Now, if you go through the profile and go through to page 32, you will see that at page 32 there is one individual who hasn't been redacted. Do you have that?
Yes.
Now that is someone that I asked you about on the last occasion that you gave evidence, and you'll see that there are details there, but the details that are given is that you'll see the date. You don't have to read it out, but you'll see the date in which that person came to reside in the territory. Do you have that?
Yes. Well, no, that's application date. So
it's the last one, but the last but one profile.
Sorry?
Do you have page 32? And where?
Yeah, I'm seeing a date.
Yeah.
Oh yes, okay, got it.
Now, the way I'm just trying to understand the way Cabinet would work. So you get these memos with multiple names on them. You'd have, I mean, the profiles run to many pages, and you would read those and then make your decision in Cabinet.
That is correct.
So in relation to this individual, you'll see that in terms of cultural tests, that's written as unavailable, and in terms of police record, that's written as clear, and in terms of absence from the territory, nothing is recorded. Now, would you accept that some of those details on what you know about this person must be inaccurate?
Well, I don't know this person, so I can't really say.
This is the person that I put to you.
I know the family, I don't know him. I don't know the person.
But do you know his circumstances?
Yeah, you made it very clear.
Right, well, if you look at where it's written as police record clear, do you think that is an accurate record?
Based on what I've heard, based on your testimony, no, it can't be correct.
But the reason for asking you about it is it's about the process, because as we looked on the last occasion, a query was raised by the Attorney General, who referred specifically to details. And you're aware of those, and I can show you them again if you need to see them. But on this, on the information in this profile, would you agree that this individual would have met the threshold?
Not by what I'm seeing here.
What detail would you have required?
Well, they all need to be filled out. All the first I know, all the fields need to be filled. As far as I know, all the fields need to be filled by the persons collecting the data.
Well, can you explain how, if the fields are not filled in, it reached Cabinet?
These technocrats collect all information, they are batched, and they're given to me to take to Cabinet. When we go through them, if something is not right, they are removed. The person is not or should not be granted status. I think in this case, the person was not granted status because these things were not filled. I would assume, it's a long time ago, I would assume.
Well, you may remember the Cabinet minute that I took you to, because his application was deferred for reasons because of the concerns raised.
It was probably flagged as, look, I know this person. The discussion.
Well, do you want to see it again?
I think that would be fair to the Minister.
But I think the Barcelona was the person granted status or not? Were they granted status? I don't think they were.
Can we take it in stages, please?
Sure.
What I'm trying to understand, Minister, is just the process of how it works. So where you've taken us to now is that Cabinet gets these documents and decides on these profiles.
Yes.
And we've got one profile where one could raise a question. Now, if you look at the other bundle that you've got, which is that one, yes. If you turn to page 27, please. Now that's what we went through on the last occasion. I won't bother reading it out again, but if I draw your attention to point 36, that's the information the Attorney General gave you. And the decision was made to defer the matter for 3 weeks. What isn't apparent on the decision is that Cabinet doesn't at that meeting say, well, we're not granting this individual residence or belonger status because the profile is incomplete. In fact, it's deferred.
And if I'm not mistaken, I think in Cabinet, once if something is deferred and it's not brought back, it is a dead issue.
But how does that work? Because under the fast track process, Cabinet was deciding.
Right.
So if I apply under the fast track process, Cabinet has to make a decision. The Immigration Department can't make a decision. The Immigration Board doesn't exist for this purpose. So it's Cabinet has to. So any application has to come back to Cabinet to decide.
That's correct.
But taking it in stages, here you have someone who you say, firstly, there's two difficulties, aren't there? The first one is that it's incomplete.
Right.
I'm sorry to interrupt. When you say incomplete, what do you mean by incomplete?
All the fields that were accountable, they say all the fields aren't filled in. Like absence from territory reason. That's not
the absence for territory.
That's not filled in.
It's not filled in.
Yeah.
I haven't been through the whole of this, but I think that everyone else has put in some absence from territory, even if it's only weeks or months.
I think all of them have it. They should all have it.
Yes, okay. But this doesn't have anything.
Right. That's why the person wasn't granted status because it's incomplete.
Well, we'll come on to that. But when it's got absence from territory and it's just got a blank, is that incomplete or? But
I would, in my mind, I would say it's incomplete. I'm not sure because I'm not sure what technocrats are saying.
No. I just said this is what you're thinking about this. So you would expect if it was non, you would expect the word non to be put in there, as it is for some of the other fields. Okay, no, that's helpful. Thank you.
But on the information that the Attorney General, so the first thing is that despite it being incomplete, there isn't a decision taken at that Cabinet meeting to refuse the application.
Okay.
And just to add to that, we've looked at the minutes, and it's the Attorney General who raises this particular individual. And the attorney raises the individual because he raises the fact that when it says police record clear, that is not correct. That's not being incomplete. That's simply. And
that's what Cabinet is there to do, to scrutinize the applications.
But does it? I mean, as the Commissioner pointed out, it's inaccurate. Does that, or did that raise any concerns for you about the other applications?
Well, naturally it would. You wonder, after the technical class, are there any other errors in here?
And did you take that step?
Of course, I would ask them, make sure. I think I do, memory solid, I think I found one or two others also, not like this, but where something wasn't what we had expected. I think I found one or two others after I saw this here.
But take it in stages, please. I mean, after this, did you go back to your technocrats and say, we need to review this?
Oh, absolutely. If memory serves me right, I would have said, listen, we need to do a better job of scrutinizing what you're sending because I found this error.
I mean, to be fair to the technocrats, their job is just to compile and send it.
But it wasn't finished. It wasn't completed, as I'm saying.
But it's the job of cabinet in this under this fast track program to do the reviewing, isn't it?
And make the decision about it.
Yeah. But in this case, where you've got somebody who's incomplete, why didn't you just refuse it straight away?
It was refused.
It was deferred.
Well, I'm not sure why it was deferred, but was it ever confirmed? I think the answer would be no, it was never confirmed. And I'm not really sure what thinking was there. I don't recall. I see the minutes. Where there's
the minutes of paragraph 41 might help, Minister. It says that the Premier and his ministers conferred on the matter and agreed that the applicant be deferred. So we don't know and don't need to know what there was a discussion and it was agreed to defer the applicant, although on the basis of what the attorney had said, not on the basis of any parts being incomplete or whatever, but on the basis of what the attorney said, this record was wrong.
Yeah, it must have been a shocking revelation.
But just to pick up one point Mr. Rawat made, you say that after this you went back to the department.
But my key person, yeah. I said,
I meant to say, I don't want to put words into your mouth, but make sure that these are filled in correctly.
Well, no, it wasn't necessarily a matter of being filled in correctly, but everything we're doing here fits with the amendments we made.
So after this, what did you say? You went to the head of the department.
The main person,
you went to somebody anyway, and said what?
And I said we have to make sure that when you're sending these things forward, they're complying with what we have here. But because I had found a few other errors. See, when you go through, there's 100 of them. Oh, but I know this person, and so situation. Please double check this for me. Oh. You know, Minister, there's a lot we're doing. It was a mistake. And I said, no, if you have to slow down a little bit, slow down, that you're giving cabinet accurate information. So this wasn't the only one thrown out. There are others that were thrown out.
I mean, I'll
default or whatever, because information was like, it's not quite accurate.
But these errors were found, as I understand it, on the basis of pure happen chance that one of the people looking at them, the cabinet members, knew of a person and just happened to know that some information was incorrect. I mean, in terms of a process, that's not the ideal way of dealing with a process where the cabinet is the assessor and the decision maker, because there is no board.
There was a danger of this. And we did find others. Remember, even after cabinet decides, so you have this block of sub-center cabinet, we may look at it and approve something, but it then has to be awarded. So if you find something, even after you approve it, you just finish the process there. You could finish the process. Even though you approve somebody, you could not implement it because you found some other information afterwards.
If that information came to light to an appropriate person.
Yes.
But in terms
if you ask me if there may have been other errors, there may be other errors. I can't say. There may be other errors. I can't say.
Commissioner, could I
just... I would put my neck on the block for that.
Sorry to interrupt you, Honourable Wheatley. Could I just ask for a short 2-minute break? Just need to verify one detail.
Certainly, yes. We'll just have a short break, Minister.
Oh, sure.
Thank you very much. Thank you, Mr. Rout. Are we ready to proceed?
Yes, I think, Honourable Wheatley, I think the point we've got to, and if I can just summarise what I understand it to be, if you can tell me whether you agree. But firstly, that these profiles that we're looking at are what Cabinet made its decision on. As I understand the fast track process, and we saw that when we looked at the memo, but documents would be submitted. The Immigration Department had the job of scrutinising those documents and collating the information and putting it in the profile for Cabinet.
That is correct.
And so you wouldn't automatically get all of the paper. You would.
Oh, no,
see,
no. I wouldn't see it. Yeah, I wouldn't get the physical paper.
Yeah,
no.
you would see what's in this profile.
Exactly.
And that's what you would have as a Cabinet to make your decision.
Unless you knew something outside of what is here.
Yeah. So if looking through, let's say, for example, and I'm making a complete hypothetical, but let's say someone said, I'm ordinary resident and I've only been absent because I have been studying, and studying is permitted, or I have been working on government service, and you knew that actually they hadn't been on government service, then that's an error that you, from your own knowledge, you could spot and you could take back to the Immigration Department. But you're dependent on the Immigration Department being accurate in the information they summarize for you.
That is correct. And it raises a very, the Commissioner said it earlier, it raises a very important point about this here, because where it says police record clear, I want to know where they got that record from that says clear. Do you know where the record came from that says clear? The police record is far supposed to come from the police. So why is the police record saying clear if you are telling me now that it is not so?
Well, we're not the ones telling you. The Attorney General was the person who told you.
But it raises the question, why is the police record saying clear if the Attorney General is saying it is not so?
Yes, I mean, that's a fair question for you to raise. What a question I can properly ask you is whether, as a result of that, and as you say, you spotted other errors as you went through, what steps did you take to, as Minister, to deal with those issues?
I simply asked them to be a little more careful to take. I know it's a lot of policies you get through in a very short period of time, but you have to make sure that you're not sending Cabinet any bad information. We are depending on technocrats here to give us reliable information. We are depending on the police force to give us accurate records. Now you are telling me this record that was collected, you are telling me it is not correct. Well, the AG is saying it is not correct. It raises a serious question for me as to where this police record comes from that is saying it is clear according to what Immigration has, but someone is saying it is not so.
Because the risk, isn't it, is that Cabinet can make a decision on an erroneous basis.
Yeah.
Because you're dependent on the profile, aren't you?
Yeah, unless you have to know the person, you really have to go by the profile.
Yeah.
And we depend on the technocrats to make sure that these things are accurate. Nothing erroneous should really come to Cabinet. This is unacceptable.
But given that you spotted errors, did you ask for an audit to be done of the application?
I didn't.
And in respect of this 100 applicants, we know about this individual. We've dealt with him, and he was deferred. But the other 99 were approved on that day. Yes, thank you.
If we go to page 55, please, in that same bundle, you have it.
I think you need to bring in the police to answer some of these questions. 55.
Well, the difficulty we have is that we have asked for the underlying documents, but it's not something that the Attorney General considers appropriate to give to the Commissioner. So we have to go with what we have, Honourable Wheatley. If I take you to 55, and please don't read out any names, but this is the letter that was written to that individual explaining why the application was not successful. So it's written some considerable time after it came before Cabinet, because as we saw, I think it came before Cabinet in 2019. I can give you the date, November 2019, so some considerable time later, in December 2020, the person's written to and told that the reason is that they have not met the 20 years residing period in the territory that is specified in the 2004 immigration policy. Now, one question that we've raised with the Attorney General is did the decision come back to Cabinet? Because you have on the Cabinet decision, you defer it. Under the fast track scheme, it's Cabinet that makes the decision. So logically, it ought to come back to Cabinet. Even if the upshot of Cabinet is Cabinet says no, it ought to come back. And it's a puzzle we haven't been able to solve.
Yeah, I meant to double check that. I may have, I think if in Cabinet you have a paper that's deferred and you don't bring it back, it automatically dies. I want to think it automatically falls off.
That may be right in terms of a paper, but here the cabinet have to make the decision. There's nobody else who can make the decision.
So it's an automatic denial. If I have to double, and I think I did ask the Cabinet Secretary if it's something that, yes, it was default because people were shocked at the situation. If it automatically dies if it's not brought back, if it's default, and I think the answer is yes. I don't know what period of time.
Before, just to help you, I mean, I should have drawn this to your attention because we have asked for this clarification because it seems a bit strange to the Commission that it didn't, even to be rejected, it didn't go back to Cabinet because under the, as I've said, you make the decision. What we've been told is this. Once the length of time since the end of the fast track scheme in relation to belongership, due to the length of time since the end of the fast track scheme in relation to belongership, the Department of Immigration determined that the letter should be issued and the application fee returned. This procedure was followed with other unsuccessful applicants. Okay. And so it seemed that if you were just, if your application hadn't been determined or was otherwise unsuccessful, the Immigration Department took a decision and issued letters like this. But
I wasn't aware of that because.
But are you aware on what basis the Immigration Department could make that decision?
It may have been at Cabinet didn't accept the particular one and sent it back. I'm really not sure. It may have simply been that Cabinet didn't approve.
Because well, we know in this case that Cabinet didn't make a decision; they deferred.
Right.
We don't know if there were deferrals in others. But
maybe they may have been just rejections outright.
I can
because so let me help you one. So the way the process works, the immigration collects information, they collate it, is presented to Cabinet. Once Cabinet makes a decision, it is then sent back to them to implement the decision.
I would agree with you because on the evidence of Ian Penn, he explained that the letters would be issued saying your application is successful or your application is unsuccessful under the normal scheme. And we know from the papers that we've got that there is a Cabinet decision where 4 people are not approved, for example. And so that's Cabinet making a decision one way or the other. But in this case, all that we know is Cabinet defers. And then the reason we've been given for why it doesn't go back to Cabinet and the Immigration Department refuse it is just that it was still there after the end of the fast track scheme.
I just suspect this was a Cabinet procedural thing. There's a certain period passes and it's not brought back, it's automatically removed from Cabinet making a decision. But that's what I suspect.
Yeah, but if you can't help, please say.
I said that's my best guess. I don't really know.
Okay, well,
it's my best guess.
Much as your best guess is welcome, we want to try and avoid you guessing. Yeah. What we are also were given, and it may be that you might not be able to help with us, but what we have been provided with is that of the I think it's probably over 1,000 people that passed through the fast track program.
Yes, well about that.
That there were 46 people who did not qualify under the 2019 program. Now, on the papers that the Commission has received.
Question. When you say didn't qualify, mean it didn't get past the immigration to get to cabinet, or cabinet
Well,
didn't approve them?
the best people to ask that question to is the IRU.
Well, I thought you had information.
What I'm reading is the Commission has been sent a table prepared by the IRU, we assume, which is headed persons who did not qualify under the 2019 fast track scheme. The basis on which they didn't qualify, I can't help you with.
Okay.
But the point of my question is that I have.
Forgive me, sir. I think there is an answer to that.
Oh, well, there we go.
Where they did not meet the 20-year residency requirement.
Thank you for that.
So standard.
But the point I was getting to, that you have, on the information that's been provided to the Commission, we cannot confirm that there are 46 refusals. We can confirm there are 4. Are you aware whether all the batch memoranda have been disclosed to us?
I don't know.
It may be something we're going to have to ask again, but I don't want to waste time by taking
What are you asking? You say you only found 4 rejections?
Yes.
It could be that they never even made it to cabinet. That's what I don't know.
Well, with the helpful assistance of Mr. Risso-Gill, and with the fact that Immigration Department cannot make a decision, they must have made it to cabinet and been refused on the basis they didn't make 20 years.
I can't recall.
But what you can't explain is the discrepancy between the fact that on the papers provided to the Commissioner, we only have examples of 4 people being rejected.
By cabinet.
At all, but they're rejected by cabinet because only cabinet can make the decision. But we can't explain where the other 42 have come from. All right. Well, I'll leave it there. Can I deal with one last matter, please?
Sure.
We need to go to the bundle, and it's the Part 2 belongership bundle, please. We went through with Mr. Smith-Abbott, and indeed yourself on the last occasion, Honourable Wheatley, about the importance of good character, and that good character is a feature of belongership applications in the normal sense. Now, this is a document. If you look at 1270, please.
Thank you.
1270.
Yeah. Now, this is obviously, we're now in May 2021. We're looking at a cabinet memo. It is after the fast track program has ended. And this deals not with belongership, but certificates of residence status, January, March, April 2021. If you look at paragraph, so what you have is that in terms of background information, the Board of Immigration is now back involved in the process. They, at paragraph 2, express concern in relation to the numbers of persons meeting the qualifying years for resident status, refer to a effort made to clear a backlog, reduce a backlog, and you've spoken to the Commission about backlogs. And they process a total of, in this case, it's actually 188 people applications. But it's when we get to 3 that I'd like to draw your attention to something, because there was specific mention of one applicant who was not recommended, and there's reference to that applicant having a criminal record. The detail of the offences were redacted by the IRU, but what's said, because it's residents that we're discussing, is as stipulated in section 18(1)(a), a person receiving certificate of residence should be of good character, and therefore these persons should not hold any criminal record within the territory. And you have various documents provided to you. Now, if you turn in the bundle first to 1441, it's section 18 of the Immigration and Passport Act, which deals with certificate of residence and says, subject to the provisions of this section, the Cabinet may, after consultation with the board, grant a certificate of residence to any person who applies for the same in the prescribed manner and who is A, of good character, and B, in his or her application stated an intention to reside permanently in the territory. Now, that's section 18. So what the board is recommending is that this person is not of good character. You cannot
Good. Thank you, everybody. Just to explain to those people who are not here, we've just had a short session in private, which has dealt with the particulars of one individual applicant. What I'll do now is I will ask Mr. Rawat briefly to summarise the question that was put, and then Mr. Rizzo-Gill, who's appearing on behalf of the Attorney General for Honourable Vincent Wheatley, will read out the gist of his evidence that we can read out, because it contains no particulars that can result in the identification of the individual. Mr. Rawat.
Thank you, Commissioner. Honourable Wheatley, I'd taken you to a memorandum to Cabinet from May 2021 and drawn your attention to one applicant who was not recommended for resident status. The reason was because that application was being made under Section 18, and Section 18 stipulates, or Section 18(1)(a) stipulates as a precondition that someone must be a person of good character. Mm-hmm. In this case, this individual was not a good character.
The person had a police record.
I think if I could just ask Mr. Rizzo-Gill just to put on the record the circumstances in which the decision was made.
Yes. The Minister and members of Cabinet were aware of the individual circumstances of the offending and considered it was nevertheless appropriate to grant a certificate of residence.
Thank you, Mr. Rawat. Thank you, Mr. Rizzo-Gill, and thank you, Minister. Any other questions, Mr. Rawat?
No, well, I've reached the end. Can I first of all thank Honourable Wheatley? I think he probably, when he turned up at 2:30, he did not expect to be here.
No, definitely not.
I hope it's not too late for dinner. But can I thank him for making himself available and for his patience, but also for the way in which he has given his evidence.
Yes, and can I please echo that, Minister? Thank you for your patience and your time, which is longer than any of us expected, but it was very helpful. And thank you for the way in the courteous and helpful way in which you've given your evidence. It's much appreciated. Thank you very much,
Commissioner. Thank you,
Mr. Rawat.
We resume tomorrow at 9:30.
Good. Thank you very much.
Thank you.